ಅದು ರಜಾನಾ ಹೇಳಿ.
Court officer,
ಹೇಳಿ ಸರ್.
sir, sir,
ಏನೋ ಆಡಿಯೋ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ, ವಿಡಿಯೋ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಎಲ್ಲ ಕಟ್ ಆಗ್ತಿದೆ.
sir, I am a part. Hello, sir, I am a party in person from Australia.
ಹೇಳಿ ಸರ್.
I am party in person Australia. ನಮ್ದು ನೋಟಿಸ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದೆ ಸರ್. ಮೇಡಮ್ಗೆ ನಾವು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇವೆ. ಮೇಡಮ್ ಬಂದು
ನೋಟಿಸ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದೆಯಾ?
ಲಾಟ್ಸ್. ಹೌದು ಹೌದು ಸರ್.
ನೀವೇನು ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಬೇಕು? ಕೇಸ್
ಹೌದು, ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ಸರ್. ಅದಕ್ಕೆ ಮೆಮೊ ತಂದಿದ್ದಾರೆ ನಮ್ ಫ್ರೆಂಡು. ಅದಕ್ಕೆ ಮೇಡಮ್ಗೆ ಲಾರ್ಡ್ಶಿಪ್ಗೆ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ. ನಾವು ಪಾರ್ಟಿ ಇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಸರ್.
ಹ್ಯಾಂಡ್ ಓವರ್ ದಿ ಮೆಮೊ ಐ ವಿಲ್ ಪೋಸ್ಟ್.
ಸರ್ ವೆಂಕಟೇಶ್ ಅಂತ ಇದ್ದಾರೆ ಸರ್, ನಮ್ ಫ್ರೆಂಡ್ ಕೊಡಕ್ ಹೇಳ್ತೀನಿ ಸರ್ ತಮ್ಗೆ.
ಇದೇನಾ?
ವೆಂಕಟೇಶ್ ಅಂತ 13494 ಸರ್, ರಿಟ್ ಪಿಟಿಷನ್.
ಪೋಸ್ಟಿಂಗ್ ಮೆಮೊ ಕೊಡಿದ್ಯೇನು? ಎಲ್ಲ ಪಿಟಿಷನ್ ಕಾಪಿನೇ ಕೊಡ್ತೀರಾ? ಎಲ್ಲ ಬೇಡ ನಮ್ಗೆ. ಪೋಸ್ಟಿಂಗ್ ಮೆಮೊ ಕೊಡಿ ಸರ್. ಏನೋ ಮೆಮೊ ಟು ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಟು ರಿಪೋರ್ಟ್ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ ರೂಲ್ 13A ಅಂತ.
ಅದೇ ನೋಟಿಸ್ ಬಂದಿರತ್ತೆ ಸರ್ ನಮ್ಗೆ.
ಯಾವ ಡೇಟ್ ಇದೆ ಗೊತ್ತಾ ನಿಮ್ಗೆ ನೆಕ್ಸ್ಟ್?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್ ನಮ್ಗೆ, ನಮ್ ಕೇಸ್ಗೆ ಡೇಟೇ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡಿ ಎಲ್ಲ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದೆ. ನೀವು ಯಾವ್ದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅದು ಕೊಡ್ತೀವಿ. ಫೈಲಲ್ಲಿ ಡೇಟ್ ಇರಬೇಡ್ದು. ಆದ್ರೆ ಫೈಲಲ್ಲಿ ಡೇಟ್ ಇದ್ರೆ ನಮ್ಮ ಮೆಮೊ ಕೊಟ್ಟು ಬರೋದಿಲ್ಲ. ಮೆನ್ಷನ್ ಮಾಡಿ ಹೇಳಿ, ಪೇಜ್ ವೈಸ್ ಕರೀತಾರಲ್ಲ ಅವರು. ವಿಚ್ ಡೇಟ್ ಯು ವಾಂಟ್ ಸರ್ ವೆಂಕಟೇಶ್?
ಟುಮಾರೋ ಸರ್, ಟುಮಾರೋ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ, ಎನಿಥಿಂಗ್ ಫೈನ್.
ನಾಳೆನೆ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್, ರಿಯಲಿ ಅಪ್ರಿಷಿಯೇಟ್ ಸರ್.
ಅವಳು ಹೆಂಗ ಇವನ್ ಹೆಂಗ್ ಮಾಡಿದ್ ನಂಗೆ ಮಾಡೋಳು ಅವಳು.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್,
ಹೇಳಿ.
ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಸರ್.
ಮೀಟಿಂಗ್ ಇದೆ, ವೇಟ್ ಮಾಡಿ ಮೇಡಮ್.
ಯಾರು ಡೇಟ್
ಮೆಮೊದಲ್ಲಿ ಯಾವ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದಿರ ಡೇಟು ಅದೇ ಡೇಟ್ ಹಾಕ್ತೀವಿ ಸರ್. ಲಾಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟಿದ್ರೆ ನೋಡಿ, ಅಲ್ಲಿ ಏನ್ ವಿಚಾರಿಸಿ ಏನ್ ಹೇಳಿದ್ರು? ಬ್ರಾಂಚ್ ಹೋಗಿದ್ರಾ? ಏನ್ ಹೇಳಿದ್ರು? ಹಂಗಿಲ್ಲ, ಅಲ್ಲಿ ನಮ್ ಬುಕ್ ಇದೆ ನೋಡಿ, ವೇಟ್ ಮಾಡಿ. ನಮ್ದು ಮೆಮೊ ಬುಕ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಬರ್ದು ಕಳಿಸಿರ್ತೀವಿ. ಮತ್ತೆ ಮೆಮೊ ಕೊಟ್ರೆ ಅದು ಇನ್ನ ಲಾಂಗ್ ಡೇಟ್ ಹೋಗ್ಬಿಡುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಡಿಯೋ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್.
ಸರ್ ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ ಆನ್ ಮಾಡ್ಕೋತೀವಿ, ಇವಾಗ ಮ್ಯೂಟ್ ಮಾಡಿರ್ತೀವಿ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ?
ಇದೀನಿ, ಲಾಗಿನ್ ಆಗಿದ್ದೀನಿ.
ಓಕೆ ಸರ್, ಅದೇ ಫಸ್ಟ್ 10:30ಗೆ ನೋಡಿ, ಧಾರವಾಡ ಮ್ಯಾಟ್ ಕರಿ ಅಂದ್ರೆ ಕರಿತೀನಿ.
ಆಲ್ ರೈಟ್ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ. ಅದು ಒಂದು ಡೇಟ್ ಒಂದು ಇದು ತೆಗೀರಿ ಸರ್. ಬೆಳಗ್ಗೆ ಬಂದ ತಕ್ಷಣ ಅದೊಂದು ತೆಗ್ದು. ಅದು ಅವಳಿಗೊಂದು ಕೊಡಿ. ಒಂದ್ ನಿಮಿಷ ಇದು ಡೇಟ್ ಬರಿಬೇಡ. ಇದು ಈಗ ಕೊಡಿ ಸರ್, ನೀವು ಅಲ್ಲಿ ಕೊಡಿ. ಸುಮ್ನೆ ಆಮೇಲೆ ಎಲ್ಲಾನು ಅವತ್ತು ಒಂದೇ ದಿನಕ್ಕೆ ಇಷ್ಟ ಆಗ್ತದೆ ಮ್ಯಾಟರ್.
Yes.
Posted to memo, police protection is given by the trial court. Even the in my suit, the injunction order.
When is the order?
That on Saturday order has been given. Police protection. Matter is right. He has filed their 39(2)(a).
When are they going to execute it?
Already 39(2)(1 and 2) applications allow. But police assistance may dispose of silent portion of property in the house. In my suit,
Yes, 230 is.
That one matter.
230.
In an execution petition, there is a threat of dispossession. But an arbitration award was passed. That was.
When was the order passed?
But it's passed last week. Tomorrow, at least, my lords may have it.
Yes.
It's a
Some
matter,
urgency, that's the reason.
matter for 230, my lords. It's a partition suit, my lords, which has already been stayed in
The order
2025 on Friday, my lords.
What is the order?
My lords, it's with regards to in the state suit, my lords, the trial court has gone ahead and entertained an application for interim injunction, my lords, and has stayed the matter and stayed for me from putting up any construction, my lords.
It doesn't matter. Today itself, if
My-
by 2:30 we do it, to the afternoon you will not start working.
Please,
You
my
can
lords,
come
there's
tomorrow.
already construction that have already started, my lords.
You can come tomorrow.
In fact, it's a stayed matter.
You can come tomorrow, no to urgency for 2:30, give it to the court officer. Yes, out of the list.
Page wise adjust.
One submission matter. Urgency the matter because the matter is listed on 16(6) on that I could not able to present it from the court. Due to personal interview.
No, this second round of mentioning started. When the matter came up, I am not there, so again you take up the matter. It is unreasonable on the part of the advocate to make this submission. Every day I am coming across these kind of mentions.
The lady was accepted, apparently funeral, I went to the village.
When is it posted?
16(6) it was posted.
When is the date?
Date. Next date.
Next date given.
Hearing before the trial court on 10/7.
This court assigned the date on what?
July, first week of.
When the matter is coming up before the trial court.
It will come on 18th of this.
You are just giving a date or you're sure about when is it
No,
coming?
it has given date as well.
When it is coming?
18/7.
18?
18/7.
Then what is urgency? 18/7. When is the date given by this court?
1st of July.
Then why are you making mention?
Because they said,
No. If that is coming up, you're getting a hearing before that. Yes.
For tomorrow, there is a partition suit. Ali application happen.
Without any reason, don't tell me tomorrow. Why tomorrow? Why it can't come in a usual court?
For argument, Your Honor.
Huh?
Because in trial court,
When is it posted?
today, Your Honor,
When did you file that petition?
we filed in the month of March, Your Honor. We
Why
complained
you are
office-
mentioning it today?
we filed because of office objection, we complained office objection. Your Honor.
So you have taken 3 months time to comply with the office objections. We will take 3 months to hear the matter.
Sorry, Your Honor. Then we have it tomorrow.
Oh, you have all unreasonable requests every day. Take it. Yes, call the list.
Page wise adjustment, list number 1, page number 1, serial number 1 to 4, page number 2.
Serial number 2, my lord.
Hmm?
Sorry, serial number 2. A weak adjournment kindly may be granted. We need to get a
Till
instruction,
number
my
2,
lord.
where is the reason to mention it?
We need to file a
We'll
translated
see.
copy, my
We'll
lord.
see. Yes.
Page number 2, serial number 5 to 15, page number 3, 16 to 26.
Serial number 19, my lord.
Hmm.
Senior is not filling, we'll have to, after 2 weeks.
This is matter in the month of September at the request of land council the petitioner. Yes, next.
Page number 4, serial number 27 to 32, page number 5, 33 to 35, page number 6, 36 to 40, page number 7, 41 to 43, page 8, serial number 44 to 45, page 9, 46 to 49, page 10, 50 to 53.
My lords, serial number 50, my lords. Short date may be given, my lords.
You offer the petitioner.
Yes, my lords.
They have filed the vacate petition.
Yes, my
Have
lords.
you informed them?
We called, the earlier advocate filed NOC, that's why we cannot.
So please wait till the advocate comes.
Page
Yes.
number 11, 54 to 59, page 10, serial number 60 to 64,
My lords, 60, my lords, serial number 60.
Yes.
2 weeks time, my lords. The partition,
Also in the month of September.
my lords, the date may be fixed, my lords.
Will not fix the date. Let the other court take the call. Yes.
Page
Right.
number 2, list number 2, page 1, serial number 1, page 2, serial number 2, page 3, serial number 3, page 4, 4 to 5, page number 5, serial number 6 to 9, page number 6, serial number 10 to 11, 13, page 7, 14 to 17, page 8, 18 to 23, page 9.
My lord, serial number 21, my lord, for petitioner, senior feeling not well, my lord, one week time may be granted, my lord.
It's a vacate stay petition coming up, which is of the year 2025.
My lord, senior feeling not.
Have you
well.
informed the other side? Then you make a mention, but you can do it when the matter reaches, not now, without informing the other side, when they file the vacate petition. Yes.
Page number 9, 24 to 28, page 10.
Mm. Mm. Why? Huh? Chances of, let's just matter tomorrow, 28. No, today.
Serial
If
number
it is,
20.
it's coming up tomorrow. Tomorrow list this matter in the first list tomorrow. Yes.
Serial number 27.
Ah.
May I request for 2:30, my lord.
Why?
This is a matter wherein your lordships were pleased to give date on Thursday. It's a disposed of matter wherein, my lord, I made a mention that my loan is discharged and they are not releasing the document. They had filed their objections. Twice it has been listed before your lordships. It is not reaching because my.
Matter in the first list tomorrow.
Please.
Yes.
Page number 10.
Serial number.
Number 10, serial number 29 to 36.
That's serial number 30.
Was going on settlement between the parties, my lord. Respondent is also present. In another connected matter also is pending before.
This is matter in the month of September submitted.
None, my lord. First, second.
Talks are going on.
My lord, second week, first week of July, my lord. Please, my lord.
It's a matter on 9th of July. They submitted that the compromise talks are going on between the
My
parties.
lord, serial number 33, my lord. I am for the petitioner, my lord. Senior is hospitalized, my lord. It may be taken up on 25th. The trial court. 33.
33, you don't appear.
No, I appear, madam. Yes, I appear for the petitioner, my lord. Senior is hospitalized. Trial court, my lord, there is Monday, my lord. 25th, my lord, it may be taken up.
25th?
5th.
This is matter on 25th.
First list, my lord.
In the first list.
Please.
Yes.
Till page number 11, till number 37 to 44. And
Hmm? 230, that is 7.
page number 12, till number 40 to 47.
Yes.
Matter pertains to Dharwad bench. House of Hegde for petitioner.
I represent the petitioner, Mr. Chair.
My lords, I appear for the state, my lords.
My lord, this was with respect to the opening up of rowdy sheeter, my lord. My lord, facts are this. My lord, the
What are the
petitioner.
objections? No, let's go to the, I remember the case.
Please,
come
please.
to the objections that are filed by the state.
Yes. My lord,
Objection and memo also, my lords, to show that.
yes, I have filed.
Regularly, the review has taken place, my lords, in view of the judgment passed by the B.S. Prakash case, my lords.
Yes.
My lord, kindly come to the statement of objections that they have filed. I mean, I have filed. My lord, before that, kindly compare the memo that they have filed. In the first page itself, the memo that they have filed on 26/2/2026. My lord, at page number 3.
No, one objections are dated 25/11/2025.
My lord, they have filed a memo. State has filed a memo, my lord, on 26/2/2026. For that, I have filed objections.
No, not for that. First of all, we look at the initial objections that are filed by them on 25/11/2025. What did they say in that?
My lord, I would, what my lord had said is, after filing up the.
I remember that. First, let's see this. What did they say in the initial objections?
Yes, my lord. Their statement of objections, my lord. The relevant portion is My lord, paragraph number 3 to 5, my lord.
Yes, let's read.
It is submitted that the rowdy sheeter opened on 19/12/2020. At present, he is accused in CC number so and so, which is pending for
Where?
evidence.
1 minute, where are you reading?
My lord, the statement of objection at paragraph number 3.
It starts like this, the petitioner's entire basis for the belated application.
So their statement of objection is dated 20th to 2026.
No, that is what I'm saying. There is one more objection on 25/11/2025. First, they have filed this, then when the court has directed them, probably they have filed the memo.
Now, for that memo, my lord, I have filed objections.
Yes, let's see para 3.
My lord, it is submitted that the rowdy sheeter opened on 19/12/2020. At present, he is the accused in CC number so and so, which is pending before evidence before the court of Honorable Principal Judge and Additional Civil Judge Sirsi. He was acquitted in CC number so and so and NMPS crime number so and so. B report has been submitted in NMPS so and CC number so and so. The case has been settled before Lok Adalat. He has filed a criminal petition before the Honorable High Court praying to cost so and so. And the Honorable Court was pleased to cost the same. Now, my lord, all the crimes.
Rowdy sheet was opened on 19/12/2020. Basing on the crimes that were registered against you, that is CC number 701 of 2019 and 122 of 2018.
May I, my lord, make submissions on that, my lord. That's the reason, my lord, I requested my lord to kindly come to the memo that they have filed in page number 3. They have given the details of the cases that were registered against me. My lord, the memo dated 26/2/2026 at page number 3. My lord would find serial number 1 to 5.
Yes.
Yes, my lord, for this reason, they have opened the rowdy sheeter. My lord, now the objections that I have filed, my lord, I have clearly given the documents also saying that, my lord, before opening up of this rowdy sheeter, I was acquitted in all the cases except
All the
one.
5 cases.
Except one. Kindly see, my lord, the first. Sorry.
What is that number?
My lord, kindly come to my statement of objections. It's just 1.5 page objections, my lord. I have filed it on 2/6/2026, my lord.
This is what last time also I said to put up that.
My lord, crime number 50.
Probably copy is not served on me.
A copy is served, sir. Your signature is there. My lord, kindly come to paragraph number 3, my lord, of my statement of objections.
What is this? What did they do on that? No, what is the office note on that? Then what is that? Why they don't read the orders? No, whatever it is, there should be a office note when an order is passed. This is matter on second. Call the concerned worker and find out why it is like that. You just.
My lord, objection is not.
Put up your objections to that memo are not put up in spite of an order on the last occasion. Let me find out. We'll have it on,
My lord, if the staff wants a new, statement of objections, another copy, I can file it in Dharwad bench, my lord.
yes. As a,
Please.
first of all, ask why there is no office note on that, in spite of an order. And tell the Registrar Judicial to come into the chamber. Yes.
Grateful, my lord.
No problem. We'll have it on 2nd of July.
Grateful, my lord.
Yes.
List number 1 for the hearing on ISL number 1, Ashwini Patil.
Why item number 1 should be passed over? That's your problem. If the senior counsel comes when the matter is going on, he'll come, or else I'll hear the matter. Every day this farce is going on. Yes, argue the matter.
The plaintiff's petition,
Yes.
plaintiff's application for production of documents at the stage of further evidence was rejected by the trial court. Primarily, my lord, on the basis that I had cited a wrong provision, my lord, in my application by United States.
Let's see where is the order.
Please, let's be kindly turn to my lord, the impugned order at page, my lord, 18.
Yes.
Starts, my lord, at page 21, my lord, the reasons. Lord, initial are the contentions. Para 10, my lord, at page 22. Your lordship would find, my lord, I have gone through the principles laid down in the above referred cases. In the said decision, it is held that in the initial stage of the case where the evidence has not yet begun or commenced, the application filed for production of documents is reasonable to be allowed. Further, if the documents helps the court for arriving to a right conclusion of the rights of the parties, under such circumstances, the application deserves to be considered. But in the present case, as rightly pointed out the learned cause of the defendants, in the objection statement,
Of which year?
but the suit is of the year 2012. What happened, my lord, was there are certain IAs, my lord, for suit is for declaration, my lord, and injunction. It pertains, my lord, declaration of right to shares, my lord.
What was this application filed?
Application was filed, my lord. There were recasting of issues that was challenged, my lord. Certain additional issues were framed and original issues were deleted. That was challenged, my lord, in the defendant before this honorable court. This honorable court said, let the additional issues which are framed remain, but let those deleted also remain on record. Thereafter, my lord, it was posted for further evidence, my lord, of the of PW1. Then, my lord, affidavit was filed, and at that stage, my lord, an application was filed, my lord, for production of these documents.
Continue reading this.
Please. But in the present case, as rightly pointed out with the learned counsel of the defendants in their objection statement, that the very provision of law mentioned in the application is wrong. Even after bringing the said fact to the notice of the applicants have not taken pain to rectify said mistake. The facts narrated in the above referred case are quite different to the facts of the present case. The applicant in the affidavit, though contended the documents are misplaced and they could not be traced at the time of filing of the suit. But where they were misplaced and when they have been traced out has not been disclosed by the appellants. The application is cleverly drafted to avoid the true facts to come before the court. Argument seems reasonable. Therefore, due respect to the principles laid down in the above referred cases, I am of the view that they are not helpful to the case of plaintiff applicants. When it comes to the defendants in support of his arguments, has relied upon decisions and so and so.
Let's see your affidavit. Where is it?
Please, the lordship would find my application. Right at page 26, is the application. But the lordship would find, I have mentioned as order 14, rule 17. There,
Forget it. What are the contents of it?
please. Then, my lord, your lordship would see the list of documents I needed to point out. My lord, the first document is an excise license. My lord, this is pointed out to produce. But my case is that the defendants had fabricated a partnership deed, and the partnership deed, my lord, which they produced before the excise authorities was in 1993, whereas, my lord, the license which was granted in favor of the firm was of the year 1992. Then, my lord, insofar as serial numbers 2 and 3 are concerned, my lord, those pertain to the forms filed before the ROC, my lord, insofar as showing whether there is resignation of directors or not. Insofar as that, my lord, the communication between the authorities, my lord, is what I have sought to produce. And serial number 4, my lord, is the website of the Central Forensic Laboratories, my lord, because there are 2 reports which are sought to be relied on by the other side. First report, my lord, is in my favor. Second report is in their favor. So, my lord, I had pointed out that there is no occasion for a second report to be obtained. Then, my lord, fifth, of course, my lord, is an order of the Supreme Court, my lord, which arises from proceedings before the Company Law Board.
Yes, Mr. Nepal.
1 and 5, my lords, I have no difficulty. Document numbers 1 and 5, they can
There
produce
is a
it.
list given.
At page 26.
Hmm.
1 and 5, absolutely no difficulty.
Hmm.
Now, so far as 2, 3 and 4 is concerned, lords, this is arising out of a criminal case. This is the materials collected by the investigating officer during the course of investigation in a complaint filed by me against them. How will the investigation materials, my lords, will be relevant for the purpose? Because he is the plaintiff in the present suit. If at all he feels that the document is required to be proved in a manner known to law, he has to take steps under Order 26 Rule 10A. That's the only method, because these are all the materials which is born out of the investigation papers of another case which is filed by me. Lords, the Supreme Court has said.
How can you file those?
Now, kindly have a look at paragraph number 5, my lords. This is something which is to his knowledge. He had to state, my lords, the requirement under Order 7 Rule.
No, that is a different aspect. Whether why they have not, why he has
This
not
para
produced
4,
it.
he says that these are the materials collected during the course of investigation in the criminal complaint filed by me. Dehorse that they have to establish their case. So I have no difficulty, my lords, without there being any. These two documents can even be permitted to be marked by consent. But let him not drag on the matter further, my lords. 2012 suit. We are interested in concluding this suit.
Not in disposal of the suit. I'm also interested because it's my suit for.
1 and 5.
No, insofar as 2 to 4 also, I thought not my tenant friend had said, insofar as 2 to 4 also is not.
But they are investigation papers. It cannot be summoned.
I'll point
Lords,
out
I
the
just wanted to understand, my
What
lords.
is the purpose?
What
of the-
purpose they should disclose in the affidavit?
I think if my tenant friend permits, I'll answer.
No, it's not a conclusive.
What has happened? The defendant relied on a forensic report in the written statement to say that the signatures are true. The issue is the same.
That he has placed.
That he has placed.
That is marked.
That is no. His different evidence is still to begin. So therefore, I wanted to point out that insofar as the second report is concerned, the question does not raise because forensic department itself says unless there's a court order, the question of because not the issue is regarding forgery. The same issue is there in the civil suit also. Of course, there are criminal cases are pending. But insofar as these are not official documents of authorities, it's not. Kindly see serial number 2.
No, is the case that the defendant is relying on the reports
Yes,
pertaining to this
yes,
case
yes.
to say that something is wrong.
Yes,
My lords, I'll put it this way, my lords. Written statement is filed saying that there is also a findings elsewhere. But now, when it comes to the civil suit, I will have to establish independently, or he has to establish independently. Merely because I make a statement in the.
In spite of marking this document.
Yes. Lords, now let us assume, my lord, that I just wanted to say this, my lord. Let us assume that such a report exists or does not exist. How does it make a difference? Because the way to introduce a report before the civil court in relation to any expert opinion is through the expert. He has not even summoned the expert.
Oh, no, by allowing this application, there is no prejudice to the defendant.
Lords, it's not about the prejudice, my lords. This is.
That is for him to prove his case.
I have
by
no
introducing-
difficulty, my lords. Just if your lords were to see the documents, why it becomes necessary for the purpose of his trial, other than the statements made by him. Paragraph number 4 at page number 28. If there is anything, if your lords might kindly see this. First sentence, I state that the plaintiffs have made allegations against the defendants 2 to 4 with respect to forgery and fabrication of certain documents pertaining to Shashi Distilleries, partnership concern of the first defendant company. In order to prove the said fact, letter dated so and so, that can't be permitted. If he wants to prove that these are all the documents in relation to which there is a fabrication, because it's his case that there is some fabrication of some document. He has to do it in a manner known to law.
Then he will summon the concerned witnesses as the documents are marked.
Lords, the documents will
But
have
if
to
I
be
may just
introduced
point
to
out,
them.
well,
Lords,
perhaps
the-
not be
under
understanding.
what, can I just persuade your lords, may kindly see, it is not permissible to rely upon the investigation papers in a criminal case. Even an order of conviction cannot be relied upon.
No, ultimately, what is the evidentiary value of that? Court will
Lords,
be
now,
deciding
Lords,
it.
the under Order 7 Rule 14, it is the relevancy which is required to be examined. The relevancy is with reference to how it is going to be relevant in the event this is to be brought before the court. He has to say how it is going to be relevant for his case, number one. Secondly, the court will have to make an assessment. The court says it's not necessary because these are the documents which is.
Forensic expert who has given that opinion, he would be calling the.
No,
expert as a witness.
your lords may kindly see, that is not what is called for.
Yes.
That's not what is called for.
In fact, your lordship has pointed
The
out there cannot be a rolling
acknowledgement-
inquiry at this stage of production of documents.
No, the relevancy, because they have come belatedly, they have to explain as to how this is relevant and why the non-production of these documents is going to be prejudicial to them. That's the only yardstick. If the second yardstick they are not fulfilling, and the first yardstick, there is no way that their application will be allowed. Copy of the letter issued by Ministry of Corporate Affairs. Acknowledgement dated 19/6/2015 of the Office of the Excise Commissioner, having received the report dated so and so. Printout of the website of the Central Forensic Laboratories regarding jurisdiction. Regarding jurisdiction, my lords, of course, it's a notification in the public domain. 2 and 3 is not a report by itself. May I just persuade, my lords? Your lords may kindly see this judgment. Para 21, my lords.
Yes.
If the will is a valid and genuine will, there is an interstice in respect of the interest created in favor of Charu. If he was murdered by the murderer of the testator. On this question, the courts below have assumed on the basis of the judgment of conviction and sentence passed by the High Court in the sessions trial that Charu was the murderer. Though the judgment is relevant only to show that there was such a trial resulting in conviction and sentence to Charu to transportation of life, it is not the evidence of the fact that Charu was the murderer. The question has to be decided on the evidence. However, for the purpose, we shall assume that in favor of the appellant, Charu was the murderer. Result not only up to that stage, up to plus term E. Whatever he has to establish, because he is the plaintiff, he is required to establish independently by production of the materials. Now, to say that there is some investigation papers there and you summon this is not going to be of no avail. Because 161 statements per se, it's of.
Unfortunately, that's not the order of the court.
Lords, may kindly see the order of the court, my lords.
Court only more concerned about what is the provision of law.
Lords, that the court says that it will ignore and then proceed. Lords, may kindly see. Paragraph number 10.
Yes.
I have gone through the principles laid down in the above referred cases. It is held that the initial stage of the case where evidence is not begun or commenced, the application for production of documents is reasonably allowed. The documents helps the court in arriving at the right conclusion of the parties under the circumstance application deserves to be considered. But in the present case, as rightly pointed out by the defendants, the objection statement that very provision is wrong. Even after bringing to the said notice, the applicant has not taken to rectify the same. Facts narrated about referred cases are quite different from the case. Applicant in the affidavit, though contended that documents were misplaced, they could not be traced at the time of filing the suit. But where they were misplaced and where they were traced out has not been disclosed by the applicants. Application is cleverly drafted to avoid the true facts before coming to the court, before the court argument seems to be reasonable. Therefore, with due respect to the principles. So the reason which has been assigned by them for the purpose of production of the document is what is taken. The second facet which I said is not there in the affidavit for the court to consider. If they had said that, no, this is the kind of document, this is the relevancy of the document, if it is not produced, it will be considered only if they state so.
Court has only considered two things. One is the correct
Provision of law. The other one is the reasons assigned.
Second one is why they have not filed these documents at an earliest point of time.
Lords, that's the reason why I said.
Court has not raised anything with regard
Can I
to whether
just
those
pursue Lords,
documents can be
kindly
marked
see
or
Order
not.
7 Rule 14 says that it is necessary for them to state at the first instance what documents are in their custody and in what form and should be filed. If they are relying upon documents which is not in their custody, they are also required to state, Lords, in the plaint, under Order 7 Rule 14, that this is the requirement. If they don't do so, then they get a second chance, which is under 14(3). Lords, this is how it reads.
Yes.
A document which ought to be produced in the court by the plaintiff when the plaint is presented or entered in the list ought to be added or annexed to the plaint is not produced or entered accordingly shall not without the leave of the court be received in evidence in this behalf at the hearing of the suit. Now, this leave which is sought for has to be read in the context of 14(1), where a plaintiff's use upon a document or relies upon a document in his possession or power in support of his claim. He shall enter such documents in a list and shall produce it in the court when the plaint is presented by him and shall at the same time deliver a document. Where such document is not in possession or power of the plaintiff, he shall, where possible, state in whose possession or power it is. So this is the mandate in terms of 1 and 2. 3 has to be read in the context of sub-rule 2, my lords, of Rule 14, where it is required for him to state in the plaint. If he has not stated so, then he enters into the second realm to say that this is the relevancy with which I want to produce the documents, which is not forthcoming in the affidavit. So that's what I can say, my lords.
And right from 2024, it's here.
That of course, my lords.
So
No, that's I told them that that you should have. My lords, even now these 3 documents becomes absolutely irrelevant the manner in which, because from 24 to 26 they have the benefit of the interim order. They are happy with the suit having been stayed.
I'm just, looking at the manner all these CPC matters are coming up. I'm just wondering how many thousands and suits are stayed as of now. every matter that is pending before the court is with the vacate stay.
That's true.
Nothing is without, in every case there is stay.
Stay,
If there
that's
are about 200 matters coming up in the list, 175 matters, there are stays.
The stay matters.
Then
No,
that's how the
Milords,
trial courts will.
Sometimes I understand, Milords, but sometimes it happens. The trial courts also sometimes goes on a hyper technical, like the one where your lordships find that the provision is not corrected. If such a hyper technical approach,
In the interest of, the system, in the interest of the litigants, there should be some way out for this. In every matter, stay forever, it will be pending on this.
no, that's the reason why I said, Milords, that probably it should be granted for a
Matters have to
very,
come, but there should be some time frame for that. Every matter, and when the matter comes up for admission, for the preliminary hearing itself, is it a point for stay or not is the first question.
That's true.
Every order that comes to the High Court can't be stayed.
And your lordships, sometimes what happens is nothing irreversible will happen if the matter is going on in the meanwhile in the trial court. And then this is decided and the matter can be set right there itself. But sometimes it becomes irreversible.
Right, in every IA, if it takes 2 years, you come up with 20 IAs, so it's 20 into 2. Like how it is in 2012 matter, we are still before the
In
High
this
Court.
case, there was an order 7 rule 11 and then modification of issues and it's so not.
The people are afraid of the litigation in India. Yes, please come.
can I seek your lordships,
Yes,
excuse me.
agreed with the order passed in. I number 18, OS number 25582 of 2012, dated 5/4/2024. The plaintiff is before this court. The petitioner herein has filed an application under Order 14, Rule 17, read with 151 CPC. It is a case of and he it's for the permission of the court to produce the additional documents, running into 1 to 6. An affidavit is filed in support of the same, stating that the plaintiff seeks to produce the excise license granted dated 2011-1992 in favor of Mrs. Sashi Distilleries. The said document has not been disputed with the defendant, and the said document is necessary to prove the case. And it is stated that the plaintiffs have made allegations against the defendant number 2 to 4 with respect to forgery and fabrication of certain documents pertaining to Mr. Distillery's partnership concern. In order to prove that, a letter dated 4/2/2008 issued by the Ministry of Corporate Affairs to the Assistant Commissioner of Police and the report dated 25/4/2008 drawn up by the Office of the Director of Forensic Science Laboratories, Bangalore. Upon examination of the signature, the fabricated partnerships dated 3/5/1993, 1/6/1997, 8/10/2024, and share transfer forms as against admitted signatures and acknowledgements dated 19/6/2015 of the Office of the Excise Commissioner have received the forensic report are very much necessary. It is stated that the documents could not be produced at the time of filing of the suit, as a file consisting of the documents was misplaced during the course of discussion between the advocate and the plaintiff, as it is being referred for the purpose of studying the allegations in the criminal complaint as well. And recently they have traced out the file. There is a report by the State Forensic Laboratory, and the second report was obtained by the second investigating officer, which is necessary. He is relying on an order, and he also wants to place a document, that is the order passed by the Company Law Board dated 10/8/2009, dismissing the company petition, holding that questions of fraud and forgery complaint can be decided only by a civil court, and an appeal is preferred before the High Court. And the High Court by order dated 3/2/2010 dismissed the appeal and held that the civil court will not be bound by the finding of the CLB on merits of the case. Thereafter, that document is filed before the court. A special petition was filed and the same was dismissed by an order dated 16/12/2011. Said fact is not disputed by defendants, and that document is also necessary. It is stated that the application filed is bona fide and not an intentional one. The additional documents intended to produce by the plaintiff is just unnecessary for the court to arrive at the right conclusion. The trial court, by order impugned, had dismissed the IA. While dismissing the IA, the court has observed that in the present case, the defendants in their objection statement stated that the very provision of law mentioned in the application is wrong. Even after bringing the said fact to the notice of the applicants had not taken pain to rectify the said mistake. Further, the court has observed that the judgment that are relied on by the petitioner do not apply to the facts and circumstances of the case. And further, it is observed that the applicant must disclose bona fide reasons for considering the production of documents in subsequent events. So also, the provision under the application filed is totally irrelevant. There is no such provision under Order 14, Rule 17 CPC, and accordingly dismiss the petition. Then counsel appearing for the petitioner submits that quoting of a wrong provision of law cannot be a ground for the court to dismiss the application. It is submitted that in the affidavit that is filed in support of the IA, the petitioner has categorically mentioned that what is the necessity to file these documents, and there is a factual foundation for those documents in the pleadings, as those documents were not in the custody of the petition, could not be traced out at the relevant time. They could not file the documents, and unless the leave is granted to produce these documents, that would cause a lot of hardship to the plaintiff. All these aspects were not considered by the court. Next para. Learned senior counsel appearing for the respondent submits that the court has rightly dismissed the application, not only on the ground of quoting the wrong provision of law, as well the documents that the petitioner is relying on are not necessary to decide the dispute between the parties. Further, the petitioner is relying on documents which are part of an inquiry where the respondent has given a complaint against the petitioner. It is submitted that it's a settled law that the court cannot consider the report or inquiry which is part of a criminal case in these proceedings. The plaintiff has to prove his case by choosing necessary evidence, but he cannot rely upon those documents which are irrelevant. And considering the fact that those documents are not relevant, court has rightly dismissed the application, and there are no reasons to interfere with a well-considered order. It is also submitted that this is a suit of 2012, and from 24 to 26, a stay of all further proceedings is granted by this court, which shows that the plaintiff is not interested to pursue the suit, and it is a suit. Next para. Having heard the counsel the petitioner and the senior counsel appearing for the counsel for so and so, for the respondent counsel. There is a material on record. The application is filed under Order 14, Rule 17 CPC, seeking leave of the court to receive certain documents. The court has dismissed this application on two counts. One is a wrong provision of law. By quoting a wrong provision of law, these applications are filed. And further, what are he has not failed to disclose the bona fide reasons. Both the grounds both the grounds on which the court has dismissed cannot be sustained. Number one, quoting a wrong provision of law cannot be a ground for the court to dismiss an application. It's always for the court. If it is permissible, whatever is the provision, the court can allow the application. Then coming to the case about the bona fide reasons, this court has perused the affidavit that is filed, and the reasons that are stated by the petitioner appears to be reasonable to allow the application and to receive the documents. Whether as submitted by the counsel, whether the court can consider the said evidence or not, it is for the court. And during the course of trial, the court will consider the documents and the evidence put forth before the court, basing on the facts of the case. And at this stage, this court need not go into that aspect. In that view of the matter, this court is passing the following order. The order dated so and so is set aside, and the IA dated so and so is allowed. Consequently allowed. Number two, the plaintiff, without further delaying the suit, shall proceed with the same. And this suit being a suit of the year 2012, the court shall dispose of the same as expeditiously as possible.
Great.
Whatever it is, they should have, when I said put up that reply, then you have to say whether it is available or not. No, they can't be so careless. Yes, call the next matter. Next.
Cell number 2, don't keep the numbers. Sorry, Harish. Cell number 2, for admission matters.
Lord, proxy counsel may seek a short adjournment for the simple reason Annexure C is, I have to file a translated copy of the.
Annexure C is an impugned order.
Yes, my lord.
Huh?
But, it's a copy, it's in Kannada, my lord.
I'm saying impugned order is in Kannada.
Yes, my lord. It's Annexure C, my lord.
Where is impugned order?
Page number 26, my lord. It's filed, my lord. Proxy counsel.
Order is in English only.
Lord, my friend said this is relevant. Short adjournment.
There's no short. Once it is out of list, out of list. This is matter in the month of September.
Cell number 3,
At the request of non-counsel, the petitioner.
Lord Mariappa for petitioner, B. Bopanna for respondent.
Yes, memo for withdrawal. Memo is asking to withdraw the petition. Memo is taken on record and dismissed as withdrawn.
Cell
Yes,
number
next.
4, Somshekaraya RP.
The petitioner here in Malad filed appeal before the trial court challenging the judgment decree partition suit. But along with IMLAD, the trial court ordered emergent notice to an appeal memo and also on IMLAD. But in the meanwhile, Malad, the respondent filed execution and it is now posted for acceptance of commissioner report.
What is it?
Malad,
What is the suit for?
Malad, suit for partition and separate position.
You are?
I am the dependent in the trial court. Malad.
Defendant number?
Dependent number 1, Malad.
What is the IA?
Malad, now I have filed appeal challenging the judgment decree and also IMLAD notice has been ordered, Malad.
When was the suit decreed?
Malad, suit is decreed long back, Malad, but the appeal is filed on in the year 2000, now recently, Malad. That is on.
No, when is the judgment and decree?
Judgment decree is of the year 2022, Malad. But since it is an ex parte judgment and decree, Malad, the parties came to know only when the commissioner visited the land, Malad, then made arrangement and filed appeal, Malad, along with IA, Malad.
Suit is of which year?
Suit is of the year 22, Malad.
No, suit is not 22. 22
My lord, suit is of the year 20, decreed in the year 22, and the appeal is filed in the year 26. My lord. FDP is also filed in the year 22. But recently, when the commissioner, when the matter, when the
What do you want the court to do?
since the it is the contention of the appellant petitioner here in Malad, it is all self-acquired properties, and the
If it is self-acquired properties, you would have contested the suit.
Malad, because in the Mufsir matter, though they engage, but they are not aware of the judgment passed. It is only when the FDP proceedings are way back in the year 22.
RA, and in the RA, you must have filed an application for stay of the.
Stay, my lord, since there is a delay, my lord, the court has no power to grant stay, my lord. Now it is posted for, tomorrow it is posted for acceptance of, in fact, my lord, the writ petition is filed on the last date of the vacation, my lord.
So let the court decide.
My lord, if the commissioner is appointed, if the
What will happen? Commission is appointed.
acceptance of commissioner report, my lord.
Then what will happen after acceptance of the commission's report?
When the property will be,
That will be done immediately within 5 minutes after this, after the commission's report.
and now the case is posted on 29/6.
The court decide. Let the High Court will not interfere on that. What the court, the appellate court can't do, why should this court do? The same principle applies.
No, since the case is posted on 29/6, in the meanwhile, 29/6, the main appeal is there, my lord. In the meanwhile, tomorrow it is there, my lord. Therefore, in view of the urgency, my lord, because of vacation, my lord, I moved, my lord, but.
Anyhow, now we will ask the court to decide your application. Anyhow, they have appeared before the court?
No, notice is that first date of hearing itself is 29/6, my lord, for the respondents. If the court comes, my lord, your lordship knows, my lord, in the rural son, my lord, if something happens, my lord, it is a family members, all brothers. Since small fightings and other things,
For that reason, we
my lord, it will spoil the relationship also, my lord. Therefore, my lord, otherwise, my lord.
So because it will spoil the family relation, stay should be granted.
Otherwise, my lord, since it is a partition suit, my lord, your lordship knows.
Let us see what is the affidavit that you have filed, why you have not contested the matter.
My lord, it is in Kannada, my lord.
What did you say?
My lord, it is stated.
Page
my lord,
number?
my lord, along with my page number 67, my lord. My lord, he has stated that he was not well and he was also not aware of the case. Therefore, my lord, he couldn't file the appeal, my lord. That's all, my lord. Oh, in 5 lines, my lord, in the official cell, my lord, they are not expressed.
For everything official. There are so many courts in Mofsil.
My lord, that there is a judgment of the Supreme Court, my lord.
With this kind of affidavit, even the appellate court will not do anything even after the
My lord, I have also read, my lord, absolutely filed this thing. My lord, may make one thing. My lord, I may permitted to move the appellate court, FDP court, my lord, by filing appropriate application to stay the further proceedings.
Why should the court, if you have a right, you have a right.
Right. With that observation, my lord, that I will.
The appeal is pending. Why would the FDP court do all that? You should get that
FDP
order
court,
from
my
the
lord, under order 20.
I will not say anything of that nature. Wherever
Liberty may be granted available in
That's it.
if that's
The
that
present
wording
petition
says.
is filed. Seek the following prayer. The suit is filed seeking partition in the year that is OS number. What is the number of?
OS number 44 of 20, my lord.
44 of 2020 on the file of the junior civil judge. Everything is in Kannada.
My lord, it is in page number 14, my lord, in the court of senior civil judge and JMFC,
Senior civil
Arsikere,
judge and JMFC.
Arsikere, in OS 44 of 20.
Read in the year 2022, and the the petition has filed RA number 82 of 2026 on the file of the second additional district and session judge, and has filed the appeal with the delay. It is a case that the matter is coming up for the first time before the appellate court on 26th of
29/6, my lord, now.
29th June 2026. It is a submission of the land council for the petitioner that as there is a delay, the appellate court would issue notice before the executing court, the commissioner is appointed. And if the executing court proceeds further, it would cause a lot of hardship, and there shall be stay of all further proceedings before the executing court. Next, the petitioner has filed the appeal, and the appeal is pending consideration before the IA condonation of delay along with the appeal is pending consideration. Is pending before the appellate court. At this stage, this court is not inclined to pass any orders. Accordingly, this court has passed the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies. Yes.
Cell number 5.
Accordingly disposed.
This is a matter where in my premises, I had purchased this property by way of a bank auction. Sale certificate is registered, e-khata, everything is in my name. In my property, there's a high voltage transformer. There's a high voltage transformer. May kindly come directly to the photograph in page 49.
What is the relief you're seeking?
No interim relief, I've only written to.
What is the prayer?
I have sought for this transformer to be relocated because this does not service my unit. This services the adjoining unit. This used to be owned by the same person.
Yes.
Devraj.
The Devraj who is directed to take notice on behalf of the respondents. Then counsel sir for the petition, sir, the copy of the writ petition.
Please.
List this matter.
I would only request a short date because of the rains, because it's a high voltage transformer.
On 20, or we'll have it on 29? So that
Please,
on
please,
29th
because
of June.
it's only rain season, because that's only,
29.
please,
Yes,
oblige.
next.
Cell number 6. Why can Narayan Sharma? Petitioner.
I'm appearing for petitioner, my lord. See, a suit for declaration of position, my lord. The respond number 13 to 15, when the matter was set down for evidence and already
Plaintiff.
please, my lord.
You are the
I'm
plaintiff.
plaintiff, my lord.
Suit for?
Suit for declaration of position. When the matter was set down for evidence and plaintiff has let in evidence, the respond number 13 to 18 have filed an application to get it impleading as additional defense in the suit. They are claiming that the respond number 13 is a society, is an association registered under the Karnataka Cooperative Societies Act, and the remaining response are the representatives of respond number 13, and they have purchased the property, apartments on the land which is one of the portion in the suit schedule, and they wanted to come on record. That application has been allowed, my lord. Again, that I filed this petition, my lord.
Please come to the order.
Please, my lord.
It's coming up for the first time. You have not filed any caveat. We'll hear him. If it's a matter for interim order, we'll grant. Yes.
It's in page number 60, my lord.
60.
60.
Yes, let's read the order.
In that operative portion, it's from 62, my lord, para 10 onwards, 62. And in the para 11, the plaintiffs have filed a suit for the relief of declaration to declare that they are the owners of the suit schedule property and also challenge the several sale deeds and confirmation deed.
Yes, please.
The suit is filed over old survey number 165, new survey number 356/3, measuring 1 acre 22 guntas. As per the applicants, there is an apartment constructed including the suit schedule property totally measuring 75 acres. Recently, the plaintiffs have come to the property and installed notice board. From the perusal of the photograph furnished by the plaintiff, that is exhibit P1213, the court can notice there is an apartments constructed. Certainly, as per the records, there are constructions where, as per the applicant, they are the representatives of the association styled as West End Heights Condominium Apartment Owner Welfare Association. Since there is apartment and several flats constructed, the presence of the applicants are necessary as there is several deeds existing. It is the plaintiff who are claiming title of the suit schedule property and also to hand over the possession. They have to prove the same and also have to prove the deeds are not binding on them. Certainly, if the association and their representative is permitted to come on record, no hardship will be caused to the plaintiff. It also helps the court to come to proper and effective conclusion. Hence, with these observations, I proceed to for
Please come to the plaint.
plaint, my lord. Please
Come to the cause title.
It's in page number 17, my lord.
17.
17, my lord. In that, the first defendant, my lord, measures Annabelle Builders and Developer Private. Sorry.
You have filed the suit for declaration.
Declaration position.
Who is the first defendant?
First defendant is the purchaser of the suit schedule property along with other properties, my lord. Is the
This
developer?
person, this builder has constructed the said apartment.
Please, my lord.
Who are the others? Who is the
Others
third?
are they are purchaser, prior purchaser, that unnabe builders, my lord. They are the vendors,
And vendors are the first defendant.
first defendant. And there are 4 or 5 sale deeds, my lord. What has happened, my lord? Earlier there was one more suit filed by me. Again, they are vendors.
Now the persons who are in occupation of the property wants to come on record.
Please, my lord.
Hmm.
They have purchased during the pendency of the suit, my lord. There was one earlier suit that was decreed in my favor.
Now
Then
the
they have
builder,
constructed.
you have filed the suit against the builder. Builder has sold away the property to
Please.
all the apartment or the persons are in occupation.
Please.
Why would he?
No, the builder is also already contesting the suit. He is hotly contesting the suit.
No, what is the, he will not have any interest to contest the suit because what is the interest he has? He has sold the property. Now he has passed on the burden to the defendant, to the other people.
No, maybe, my lord, but what will happen, my lord? I am fighting for this property since 2005, my lord.
Correct. Who will be the?
I am not able to enjoy the property.
Affected party.
I am the affected party, my lord, because I have already affected because
No, if your suit is decreed, who is the affected party?
maybe, my lord, but what has happened? Or what I am saying, my lord, because since 2005 I am fighting for this property. I am not able to enjoy the property because this property has been granted to me in a partition.
Court do understand your problem. We are not on the problem
No,
of the plaintiff.
I am saying prima facie because they are not the bona fide purchasers. In respect of this property, why I am saying this because, my
When
lord,
was the apartment constructed?
it's in after 2010, my lord.
When was the suit filed?
This suit was filed in 2016, but earlier suit I had filed, that was decreed in my favor. During the
They will come and tell how they are not aware of the suit. And how he is a bona fide purchaser.
they cannot claim bona fide purchase because this pendants, section 52, my lord. They cannot.
No, tell the court, what is the difficulty if they are impleaded?
No, because it is unnecessarily prolong the matter, my lord.
We will tell them not to prolong the matter.
Then kindly give direction to the trial court to dispose of the matter early, my lord. Kindly fix your time, my lord.
Matter that comes to the High Court, one direction to the trial court because you have come filing the court fees. So
Please, my lord, that is
the court will tell the trial court to dispose of all the matters.
No, because I am kindly see the fate of my client, my lord.
Tell
Because
them-
this 1 acre 25 guntas has been allotted to my share in the partition.
Direction to the Bangalore court. Yes, come, please come. We will anyhow say that unnecessary adjournment shall not be granted to the to this pleading applicant.
And kindly fix a time, my lord. Otherwise,
That's not
Because
not
it's-
right on the part of the High Court.
so,
to
but
do that.
kindly see the fate of this party, my lord. Because since 2005 he is fighting for this property, my lord.
Your client alone, not everybody's fate is like this.
No,
All
that-
litigants were going to the courts.
No, even though there is an injunction declaration in my
Have you
favor,
not
they
come
have.
to court?
No,
Have you, no, if I grant stay in this.
No, it will prolong.
Into further
my-
misery.
It will delay it further.
The present writ petition is filed, agreed with the order passed in I number 11 invoice number 451 of 2026 by the 7th additional senior civil judge at Bangalore, rural district Bangalore. The facts of the case are the petitioner herein, who is a plaintiff in the suit, has filed the suit seeking declaration and possession
Declaration.
in the year 2000, that is OS number 451 of 2016. The present IA is filed. Where is IA?
It's in page number 43, my lord.
An IA is filed.
IA number 11, my lord.
An IA is filed.
$43 million. 44.
By the secretary, how they are arrayed as, it just says, I am the secretary of the first impleading applicant. No, that is not the affidavit, I think.
No, that's what I'm.
Huh?
They have not said anything, Lord. And this is a society. This is an association.
Look at it. I am the secretary of the first impleading applicant. Which is the, where is that? Now, Western Heights Apartment Owners Welfare Association. Yes. In the suit scheduled property, there is an apartment named as Western Heights Condominium Apartment Owners Welfare Association. And the secretary has filed this IA. On behalf of the said apartment, the secretary has filed an application to implead the welfare association as a defendant to the suit. It is their case that they have purchased the property from the first defendant.
Yes, ma'am.
Yes,
Please,
ma'am.
please.
Purchase the property from the first defendant.
Flats, ma'am.
They purchased the apartments from the first respondent. Right from the right from the year. They say that they purchased it from the year 2007.
No, they have not mentioned when they have purchased the apartments. They say that their vendors have purchased. That is only they have mentioned in their affidavit. When they have purchased, nothing has been mentioned, my lord. That is during the pendency of the suit only. They have purchased it.
Occupancy certificate was granted on 18/6/2014 till 25/7/2016. It is their case that they purchased the property, purchased the said apartment, purchased the flats from the first defendant. As such, if any order that is passed in the suit, as they are the affected parties and they are the proper and necessary parties for adjudication of the dispute, as the actions sell the property, the defendant will not evince any interest in the litigation. Hence, they have filed an application under Order 1, Rule 10. The trial court, by order impugned, had allowed the IA. While allowing the IA, the court has observed that from the photographs furnished by the plaintiff, that is Exhibit P12 and P13, the court can notice there is an the court can notice that the apartment is constructed. Certainly, as per the records, there are construction. As per application, they are the representatives of the association, styled as Western Heights Condominium Apartment Owners Welfare Association. Since there are apartments on several plots constructed, the presence of the applicants is very much necessary, as several sale deeds are executed. It is a plaintiff who is claiming title of the plaintiffs are claiming title of the suit's scheduled property and also seeking handover of the possession. And they have to prove the same and also have to prove that the deeds are not binding on them. Certainly, if the association and their representative is permitted to come on record, no hardship will be caused to the plaintiff. It also helps the court to come to proper and effective conclusion and accordingly allowed the IA. Land counsel appearing for the petitioner submits that the applicants are the necessary parties to the suit. Already the developer is arrayed as defendant number 1. The builder is arrayed as defendant number 1. This or the petitioner has filed earlier suit in the year 2010. Earlier suit.
The earlier suit, my lord.
10.
Yes, my lord. Earlier suit was filed in 2005, my lord.
2005, and the present suit is filed in the year 2016, and during the pendency of the proceedings, they have purchased the flats, and that is hit by list pendency, and their presence is not necessary to adjudicate the dispute involved in the case. And now, by impleading these applicants, it would amount to enlarge the scope of the suit, and further unnecessary delay will be caused. It is submitted that the court was not right in allowing the IA, and the order needs to be set aside. Next part. Having heard the counsels on either side, there is the material on record. The suit is filed for declaration and also seeking recovery of possession. Admittedly, the applicant society is in possession of the of the apartment which was constructed by the first defendant. The court has rightly observed that as the plaintiff is seeking the relief of recovery of possession, if the applicants are impleaded, no prejudice would be caused, and in fact, it would facilitate the court to adjudicate the dispute in an effective manner. This court finds no infirmity with the order impugned, and accordingly, this court is passed the following order. The writ petition, this court do not find any merits to the writ petition. Accordingly dismissed. Number 2, the court shall not, as this is a suit of the year 2016, the court shall not give unnecessary adjournments.
In this case, we challenge the RSA mailers regarding earlier suit, and the respondent one did not challenge that order. That's why we, as a appointment owners association, we challenge that order as a third
Have you
party.
said so in the simply application? You didn't say?
Nothing to do with this.
Yes, after came to know this case, we filed impleading application and
of the
RSA also.
petitioners. It is a case that the earlier suit was decreed and the builder has not questioned it. The apartment association has filed the RA and their
RSA.
That is not their pleading, Lord. In the application.
You are not stated so.
This is for the first time they are saying.
First we filed the First we filed the IA, my lord.
Did you say so in the affidavit in support of the IA?
No, my lord. First we filed the application in this case. After that we filed the RSA, my lord.
Don't record.
That's
Because
fine.
anyway, I'm not recording your appearance.
Please.
Yes.
And
This
time.
the court shall not.
That's this is the 2015.
No, they're not issuing adjournments to the implead applicant.
Lords, it is because that the RSA is pending adjudication before this court. That direction may be a little bit of a difficulty because it is pending adjudication.
That is a different issue.
It's a different issue.
Yeah,
You want
different
any
issue.
He is deriving his title
The court
from the same
shall
suit.
shall not grant unnecessary adjournment and shall proceed with the matter. That's it. Next.
And timeline, even what?
I am not issuing notice. There is a question of accepting notice.
Timeline, my lord, even 1 year.
No time.
Cell number 7. Cell number 7. Savita Damodaran.
It's a plaintiff's petition, my lords. Suit for injunction and declaration. Issues were framed. After that, I filed an application for recasting and addition of 3 issues. 2 issues are allowed. 1 issue is dismissed. I'll only point out why that issue is important.
Come to them.
My lords, if my lord comes to the plain, my lords, plain is at page number. The prayers are at page number 33, my lords.
Yes.
34, my lords. C, prayer C. Directing the defendant number 1 to provide and complete all the amenities in the Schedule B property as set out in Schedule D to the plaint. This was one of the prayers. That was not the issue in this. There is a pleading to this effect. There's a prayer and the defendant has disputed this prayer. So there should be an issue on this regard. So that's why I filed an application for recasting of.
No, where are the issues?
Malas,
Where are the,
please,
where,
Malas.
where are the issues? First frame.
First frame, please, Malas. Page number 72.
72. 72 or
Sorry, Malas, 73.
Ah.
After the framing of issues,
Now, what are the additional issues?
I filed an application under page number 76, Manoj.
Yes.
76, I had prayed for, there were some typo errors in issue number A, B, C. That was corrected and additional issues.
Then the plaintiff prove that the
Joint development agreement dated so and so executed between defendant number 1, 2 is null and void and not binding on the plaintiff. This is recasted. Now this issue has been included. And next is also included. And F is whether the defendant number 1 proves that all the common amenities, facilities, exclusive reserved for the benefit and use of the members of the plaintiff number 1 association has been completed and handed over to the plaintiff.
Burden be cast upon them.
Malas?
Why should the burden be cast upon them?
Well, because I have said that the amenities are not given. The defendant
That's for you to say. That's for you to prove.
in the written statement, they have said that no, we have given amenities.
Both the cases burden lies.
Correct. I have to prove. For that issue has to be there.
You wanted an issue where
Please.
the burden is cast upon the defendant.
Then if
Let's see what did the court say. Where
Please,
is it?
minutes. That is not the reasoning which the court has given at annexure A minutes. Page number 21 is the order, where the operating portion of the order is. Court dismisses on a different ground.
Let's see, where is it?
Page number 21, minute. 21, the operating portion is at page number 22.
The plaintiff further proved the 12 meters so and so clear for framing additional issues.
However, the issue regarding the completion and handover of the common amenities by the defendant number 1 does not fall within the scope of the present suit and is beyond the jurisdiction of this court in these proceedings.
Come to the plaint again.
Plain minutes. Annexure B is the plain.
Page number.
It starts from 25 minutes.
Permanent injunction restraining the defendant and all persons claiming under them from carrying out any development of the.
That issue is framed.
No, I'm looking at 34.
Please minutes.
Is the
34. I'm only.
Prayer.
Please minutes. I'm only interested in player number C as of now because player number A and B.
The scope of the
Please,
suit,
please. I'll just explain what is the scope of the suit minutes. We are the apartment purchasers. Defendant number 1 was the developer. Now we had to get 5 acres, 35 guntas of land, which is the apartment complex and the common amenities. Now what the defendant number 1 has done is, out of that 35 guntas of land, he has entered into a JDA with the defendant number 2. I have asked for the cancellation of that JDA, and in that 35 guntas of.
And counsel for the.
I have not asked for the stay minutes because it's my suit. Only notice, and I'll take on the lower court advocate.
The notice
That-
to the respondents.
Cell number
Petition
8.
permitted to take out hand summons, list this matter on
In e-
6th of July.
Please, minutes.
6th
Great.
of July. If the memo is filed by 3rd of July, list the matter on 6th July.
I'll do the needful minutes.
Cell number 8.
Appearing
Appearing
for
for petitioner in this matter, my lord.
respondent number 1 and 2, my lord.
It's too late.
This one.
Sorry.
This is suit is for declaration and injunction, my lord. I have sought for amendment of certain para, my lord.
Suit for declaration, which year it is
Declaration and
filed?
please, my lord.
Which year it is filed?
2017, my lord.
What is the present stage?
Now it is in the
Argument.
stage of arguments, my lord.
Now you want to amend the plaint?
No, my lord, the reason, my
I'm
lord,
only asking the question, you want to amend the plaint?
please, my
Strike
lord,
off the pleadings and amend the.
The affidavit.
please,
Come
my
to the
lord.
affidavit that's filed in support of it.
Annexure C, my lord, page 24, my lord.
Where is that, which you want to add amendment sort?
In the
Come to
application, my
page
lord.
23.
In the application, my lord. Amendment sought for in page 4 and 5, my lord. Para 5 after 25 line, my lord.
though subordinate officer survey authority, there is no land in survey number 32 of Kenganalli village, Kalambala Obli, Shira Taluk. How the third respondent has recommended to formation the site to the siteless poor persons under Ashraya Yojana. The same is illegal, created fraudulent document with support of the local political persons. Third defendant has no right to do so.
So you want to
This-
delete, you want,
that has to be
after the
deleted.
entire evidence is completed, you want to delete the
Strike
certain
off the pleadings.
admissions from the plaint and you want it to be added, substituted with something else.
My lord,
It's
the
not fresh
reason, my
evidence.
lord, after the cross examination, my lord, the sixth
That is what
respondent.
is called pick up the latches.
May I
Up to the
sub-
order, we'll see.
Page 30, my lord, reasons.
Let's read the reasons part from page number 7, para number 7.
The suit is for declaration and permanent injunction. The plaintiffs indeed to delete in page 4 and 5 after 25 line, that is through subordinate officer survey authority. There is no land in survey number 32 of Kenganalli village, Kalambala Obli, Shira Taluk. How the third defendant is recommended to formation the site to the siteless poor persons under Ashraya Yojana. The same is illegal, created fraudulent documents with the support of the local political person. Third defendant has no right to do so. And indeed to add, taking advantage of the revenue documents, that is Kata and Pani stand in the name of the Sarkari mentioned in the column 9 of the RTC as per petition filed by the Panchayat officer, Taru Grama Panchayati, Shira Taluk for sanction the land for the purpose of giving the sites to the siteless poor persons under Ashraya Yojana scheme. The Tashildar Shira defendant number 3 has sent the petition copy with enclosure to the survey authority Shira after received the copies from the Tashildar Shira before visited the land bearing survey number.
Has seen.
Please, ma'am.
Has seen the order.
My lord, the reason, my lord, they have filed the petition seeking for formation of the conversion of the land, my lord. But they have not measured and not given the notice, my lord. That is the reason, my lord. They are saying 32/3, my lord. And I have granted 8 acres, 20 guntas, my lord. They are interfering in my property, my lord.
You have already filed the claim. Entire evidence is let in. Basing on the pleadings, issues are framed. Entire evidence is completed. Now at the stage of arguments, you want to withdraw certain admissions made in the plain and you want to introduce a new case. Why you should be allowed? Which
No,
is
my
not
lord.
contrary to settled law.
No, they are saying that they had filed a petition before the assistant commissioner, my lord. That documents we had sought
But
for.
that you have filed an IA. That is dismissed.
That is also
If that
dismissed.
is
my-
dismissed,
for-
you have to question it by filing a writ petition. You have not questioned. So what you couldn't achieve in that, you want to achieve it by amendment, by amending the pleadings, which is not permissible. Please come. Agreed with the orders passed in I number 12, invoice number 146 of 2017 by the Principal Senior Civil Judge and JMFC at Sira, date 24th March 2026. The plaintiff is before this court. The plaintiff has filed a suit for, the petitioner plaintiff has filed a suit for declaration and injunction in the said suit. The court, basing on the pleadings, have framed the issues and the trial completed, and when the matter is at the stage of arguments, the present application is filed seeking amendment of the plaint, whereby the plaintiff wants to delete a portion of the admissions made in the plaint and wanted it to be replaced by another pleadings that came to be dismissed by the court. The next paragraph. While dismissing the said IA, the court has observed that,
Paragraph 9, my lord.
yes, observed that
Page 31, my lord.
that the petitioner's plaintiff has filed an application under Order 16, Rule 6 of CPC to direct the sixth defendant to produce the documents regarding petition filed by the Panchayat Development Officer. The said application was rejected on 30/8/2024. Thereafter, they have filed another application and that also came to be rejected by order dated 21/2025. and posted the matter for arguments on 4/2/2026. After taking adjournments to address their arguments, the plaintiffs have come up with this application seeking to strike out their case and intended to raise new plea in the plaint by way of amendment. The court observed that it essentially asking the court to ignore the evidence adduced based on the said plea and to start a new trial. The court of the view that this is a abuse of the process of law. And also it is a well-settled principles of law. The plaintiff and the defendant cannot be allowed to amend pleadings if it results in withdrawing an admission made in the original pleadings after trial, which would prejudice the other party. This amendment sought by the plaintiff is nothing but a withdrawal of their case and insert new pleadings, which would definitely prejudice the defendants and accordingly dismiss the application. Land counsel appearing for the petitioner submits that at any stage of the proceedings, the amendment of the pleadings can be sought. The court, basing on the facts of the case, has to consider the same. Just because the trial is completed, that cannot be the ground to dismiss the IA. It is submitted that earlier two applications that were filed by the plaintiff were dismissed as they wanted the certain documents to be produced. In the light of those facts, they have come up with this application, and the court has failed to consider the same. Next paragraph. Having heard the counsel for the petitioner, or is the material on record? In the suit of 2017, when the matter is posted for argument, the present IA is filed. Admittedly, by way of this IA, the petitioner wants to introduce a new case and wants to withdraw the admissions in the plaint. After the amendment to Order 6/17, if the application is filed after the trial has commenced, it has to be stated that in spite of due diligence, the said facts could not be brought to the notice of the court. But this is a case where the matter is posted for arguments. At this stage, when the application is filed, it is all the more relevant whether there is due diligence on the part of the plaintiff or not. But looking at the application that is filed, it appears that to get over after the evidence to fill up the latches, the petitioner plaintiff has come up with this IA. An IA under Order 6/17 cannot be permitted to fill up the latches, and they cannot be permitted to withdraw the admissions, which would cause prejudice to the other side. In those circumstances, the trial court has rightly considered and dismissed the application, and this court finds no reasons to interfere. Accordingly, dismiss.
Cell number 9. Cell number Saya.
Petitioner.
Yes.
My lord, this petition is arising out of the stay order passed by the First Appellate Court. First Appellate Court to stay the entire proceedings in the FDP proceedings. The order portion is at page.
No, what is the suit?
Suit was for the partition and question.
For the defendant in the suit.
We are the respondents here in the First Appellate Court are the plaintiffs in the original suit. The suit was decreed. It is operative portion is at page number.
Who are you? How are you arrayed in the
I am
suit?
the plaintiff in the trial court.
Against
My
the
suit,
defendants
my
have
suit
filed-
was rightly decreed.
Against the defendants have filed the appeal.
Yes, please.
In the appeal, the court has granted stay of
Entire proceedings in FDP proceedings. After the lapse of 4.5 years. In the appeal proceedings in the, my lord, appeal proceedings.
Let's see the order.
Please. At annexure F, please.
Page number.
Page number 114, please. Before that, the judgment pronounced on 21/2000 21/2021 as per annexure A.
Date,
Judgment.
English.
Judgment.
What is the date? Please tell it in English.
Date 21/2021. 21/2021. 20th January 2021.
Is a judgment a decree?
Yes, please.
When was the appeal filed?
Appeal was filed in the year during the year 2021.
Numbered as RA number?
IA number,
RA number 8 of
yes, please.
2021.
Yes,
Now this IA is filed when?
the appellants filed on 16/8/2025. 16/8/2025.
Why is
Sorry,
it so difficult to
sorry.
say the date? 16?
Sorry, 16/8/2025. Annexure D, please,
No, let's see the order.
please. It is at page number 114, please. IA number 11 under order 41 rule 15 read with section 151 of CPC filed by the on behalf of the appellants to stay the proceeding operation and decree of judgment in and FDP 45 of 2024 dated 21/2021 on the file of the senior civil judge. Okay, the appellant is opposed on behalf of the LRs of the respondent number 1 and 2. It is contended that the respondent number 1, the appellant number is the younger daughter of the respondent number 1 and 2, and the appellant being the second daughter is mesmerized at the hands of the second respondent, R.V. Timarayappa, and who is none other than the husband who has mismanaged the affairs of the joint family. The appeal is filed only to protract the proceedings and to deceive the legitimate share right means profits arising out of the suit schedule property. The suit is decreed in favor of the class 1 legal heirs of the Dodda Hanumantaya, that is under section 8 of Hindu Succession Act. The appellant being the daughter of Dodda Hanumantaya is trying to deceive the legal rights of her own sister, brothers, and who are the respondents number 1 and 2, hence prayed for dismissal of the application. The operative portion of the order, judgment.
Only the drawing of the final decree is stayed. That is not stayed. What will happen?
My lord, there is an application is pending for appointment of the.
No.
Please.
The FDP proceedings can go on. Only the
entire proceedings is stayed.
Where?
That is the
Drawing of final decree is stayed.
Stayed.
Please read where it is stayed.
Wherein the operative portion is at page number 118.
Read.
Please. During the final, I number 5 for CPC is by on behalf of the appellant is disposed of as follows. Drawing of final decree in FDP 45 of 2004 dated is stayed until further orders. Final decree is stayed. Wherein two applications
You are
is pending.
saying final decree proceedings are stayed. No.
Please.
Only passing of final decree is stayed. If it is not stayed, then what is the purpose of filing RA? RA will itself becomes
My lord, in the RA, wherein they are contending that one unregistered document relinquished deed. That is rightly observed by the third court.
I have no clarity whether it is.
But my lord, after the lapse of 4.5 years, they have filed the application.
Whatever it is, please come.
And my lord, one submission. If there is an expedience, this time may be given.
RA of 21, no. Agreed with the orders passed in I number 11 in RA number 8 of 2021.
My lord, one submission. The appellants here in using the means profits more than 30 to 30 lakhs.
Is it part of this IA that I will decide in this? Whatever they are doing, you have to go before file an appropriate application. If any
application is pending before the trial.
The court will decide. The writ petition is filed agreed with the order passed in I number 11 in RA number 8 of 2021 dated 7/4/2026, whereby the court has granted an order by staying the drawing of the final decree in FDP number 45/2024 drawing of the final decree in FDP number 45 of 2024. And the appellant was directed to proceed in the appeal and cooperate with the court for early disposal. When counsel appearing for the petitioner submits that there is an application for mean profits also. At this time, if the FDP, this order will cause a lot of hardship to the plaintiff, plaintiff in whose favor the suit is declared. It is submitted that the suit is filed in the year 2021. Now the stay of final decree proceedings were granted in the year 2026. Hence, the order needs to be set aside. This court, having heard the counsel for the petitioner, peruse the material on the court. The suit is for partition, suit is decreed, final decree proceedings are going on. On an application filed by the appellant, the court has directed that the final decree proceedings may go on, but drawing of the final decree is stayed. In the considered opinion of the court, there is no illegality with the order which requires interference in the hands of this court. Unless and until such order is granted, even if the RA itself, the pending RA itself will become infectious in those circumstances. This court may not find any reasons. Dismiss. Yes,
Number
next.
10, Shekhar LS. Petitioner.
Yes.
Petitioner is seeking expunging certain observation from the interim order. By virtue of order by this honorable court, I got an unregistered document, Annexure C,
Where is that interim order?
impugned order, madam. Impugned order is at ink page 54. The particular paragraph is 57, page 57.
Will order notice?
Please,
Notice to the
I may be permitted to take out hand summons to the
Summons.
trial court advocate.
And shall file a memo to that effect if the memo is filed on 10th of July, list on 13th.
Please.
Yes, 11.
Cell number 11, Prasanna VR, for petitioner.
Yes.
That there was a decree for recovery of money
You are
followed with the execution. I am the judgment debtor, my lords. That an execution is filed in which, my lord, an application for attachment of property has been filed along with an application for dispensation of notice. There is no order on the application filed for dispensation of notice. On the other hand, my lord, straight away the executing.
The decree, when was
But,
the execution?
Not execute decree, my lord, is on 3/1/2026, my lords. Execution is on 13/2/2026, my lords. Within two, of course, it is within 2 years.
So no notice is
But
required.
of course, my lords, when the property is sought to be attached, my lords, a show cause notice should have been issued, asking as to why the property shall not be attached and sold for recovery of the decretal amount. No such procedure. My lords, on the other hand,
See, where is that procedure?
not an application is filed seeking dispensation of such notice. Not IA number 1, IA number 2 is for dispensation under order 21, rule 22(3). Therefore, when an application is filed, there must be an order, my lords, on such an application, at least dispense with the notice. Otherwise, my lords, the court would have ought to have issued notice asking the judgment debtors. Anyhow, my lords, since execution is filed, my lords, I cannot alienate the property, and I will undertake, my lords, I will deposit some amount. Not they kindly see the order, my lords, dated 17.
What is the amount?
My lord, amount, my lords, is 54 lakhs, my lords.
Then half of it should be paid.
But I will deposit 25% of the amount, my lords.
In a money decree suit, unless 50% is paid, we will not stay the decree, the operation of the decree.
But of course, 50% my lords will be 22 lakhs or 27 lakhs, my lords. 4 weeks, my lords, will ask me, my lords. Otherwise, my lords, will be.
Counsel for the petitioner submits that. The court, without even issuing the notice, has passed an order for attachment of the properties for the petitioner. Though an application is filed seeking dispensation of notice, without passing any orders, the court has passed the order. It is a submission that the same is impermissible. In those circumstances, it is submitted that there may be a stay on the operation of the order dated.
Blood order dated 17/2/2026.
17/2/2026. Considering the submission of the then counsel for the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the petitioner shall deposit 50% of the decretal amount within a period of 6 weeks from the date of receipt of the copy of the order.
Much up.
Notice to the respondents. Petition is permitted to take out hand summons on the counsel appearing for the respondent before the executing court and shall file a memo to that effect by 16th of July, or else the stay granted by the court stands vacated.
Obliged.
Number 12, Shankara Gowda VN, for petitioner.
I'm appearing for petition, Your Honor. Respondent hearing a plaintiff before the trial court to file the suit for permanent injunction, Your Honor. The case of the plaintiff before the trial court, my lordship. Suit showed property was,
What is IA?
my lord,
IA
I order 13 1 and 2, my lordship.
is granted. by
Order
the trial
13 2,
court.
that is not to interfere with the scheduled property that was allowed by the
No, that is granted by the trial court.
trial court, my lordship.
Appellate court has reversed it.
No, confirmed it.
Oh, you're the plaintiff.
Everything, I am the defendant.
Oh, granted.
Yes, my
Trial court
lordship.
granted, confirmed the whether.
Confirmed
appellate-
that
Let's see the order straight away.
the specific case, my case is, my lordship.
You can read it from the order also. What is the specific case?
Trial court order, my lordship.
We will go to the appellate court's order. You can come to paragraph number 15.
Yes, ma'am. In the light of the above proposition of law, let us take the glance over the material placed on record and the observation made by the trial court that is the suspect contention of the defendant 1 and 7 that they are in possession of the suit properties bearing side number 6 and 7. Purchased under the registered sale date.
When was the property purchased?
In the year 2004, my vendor has purchased the property from this very same plaintiff, Your Honor, and plaintiff and his family members. In the year 1997, entire property is purchased under the registered sale deed. In order to establish the same, the defendant have produced the documents. However, the trial court has not considered the same. It is also further contended that the trial court has not considered the document produced by the defendant's appellant in the observation made by the trial court at page number 12 and in paragraph number 15 that though the defendants have contended they have purchased the property site number 6 and they are in possession of the same. They have not produced any conversion order and all the other documents. During the course of the argument, the learned counsel for the respondent has filed the memo and produced the documents that the defendant number 1 and 7 who are in the appellant for the present case have already sold out of the sites and 6 and 7 favor some other person. The respondent also produced the copy of the sale deed. It is therefore the appellant becomes purchase and perusal of the said document. The order of the trial court in all there are 8 defendants in this appeal is being preferred only by the defendant number 1 and 7. It is under this circumstance the order of the other defendants to say that defendant number 2 to 6 and 8 are also required to be arrived as a respondent in the appeal. It is therefore the appellant defendant number 1 and 7 are arrived only the plaintiff as a respondent. It is therefore having regard to the facts and circumstances of the case and the document produced by the respondent in order to establish their appellant's defendant number 1 and 7 have already sold out of scheduled properties items to some other.
Your defendant number?
6 and 7.
What
One-
it is finding?
1 and 7.
It is therefore having regard to the facts and circumstances of the case, in order to establish that the appellant's defendant number 1 and 7 have already sold out the suit property, that is site number 6 and 7 to some other person, the appeal does not, you have sold the property.
Yes, my lordship.
When did you sell the property?
In the year 2025. My lordship, they also filed the suit per day injunction saying that Your Honor, already in this case, already interim order was
Subsequent purchases are not the parties to the suit.
not parties to they are not parties to the suit, Your Honor. What happened in this case, my lordship? Kindly see in my paragraph, my grounds itself, my incip in page number 9, Your Honor. My lordship, the plaintiff and the entire family members sold the entire 10 acres of land, even not even retain a single inch of land.
That is one aspect. No, you are not interested in this litigation at all. You have sold the property.
Or sold the property, but the vendors are stepped into the shoes of this petitioner, Your Honor. They also filed the suit before the trial court. The honorable court held that already you are this your interim order against you in your favor. That's why we can't grant any interim order in that case, Your Honor. That was the held. That is also appeal was filed by before the honorable court in WP number 17,267 of 2026.
It is permitted to take out handsomens on the
Lordship,
concept of
taking this defendant, the respondent himself has sold the property, my lordship.
File a memo to that effect by 16th of July. If the memo is filed, business matter on 17th July. Yes, next.
13.
And that tag with 17,267 of 2026, my
Write on
lordship.
a paper, this along with so and so.
Number 13.
Write on a
Rupesh
paper and give. Yes, 13.
Lord, 13 appear for petitioner, my lord. My lord, I am the purchaser of the undivided share of the property, my lord. The wife and deceased minor daughter filed a suit for partition, my lord, wherein I am a party. My lord, the suit was dismissed, my lord, on the ground that the sale was for legal necessities. So the plaintiffs approached first appellate court, my lord, wherein the court decreed in their favor, my lord. Thereafter, they have approached FDP court. In the FD final decree proceedings, my lord, I filed an application, my lord, stepping into the shoes of my vendors, seeking to assign their share to me, my lord, as a bona fide purchaser. I purchased the property before the institution of the suit. So I filed an application, my lord, in IA number 6, seeking to assign the share of my vendors to me, my lord.
Yes.
The trial court, I mean the FDP court rejected my application, my lord, on the ground of maintainability.
Let's order.
The order is at page number 77, my lord.
Yes.
My lord, the reason starts from para number 6, my lord.
Yes.
At 79.
Yes.
The plaintiffs have filed a copy of judgments and decree passed by the 5th Additional District and Sessions Judge, Tiptur in RA number 1005 of 24. On perusal of these documents, the Honorable 5th Additional District and Sessions Judge Tiptur.
You were a party to the suit.
Yes, my lord.
And there is a judgment.
Yes, my lord.
And now you want this clarification from the executing court. Why?
No, my lord, in RA, my lord, the in favor of plaintiff 5 by 18.
Whatever it is.
Yes, my
You
lord.
were contesting.
Yes, my lord.
When you're contesting whatever the relief you want, the appellate court would have passed a decree. Why should the executing court now interpret what is the decree now?
No, my lord, the first appellate court.
Understand you purchase a property like after that or some other reason you have gone before the execution. You are a party to your suit.
Yes,
to the
my lord.
RA. Whatever are the finding, whatever is the judgment decree, the executing court will execute it.
Yes, my lord, in the first appellate court, my lord, the 13 by 18 share was allotted to my vendors. So I filed an application to assign that share for the.
You ask the executing court. There should be a finding by the appellate court or in the suit or in the appeal. No finding on that.
No, in the appeal, the sale deed, it was said that the sale
Court
deed.
finding is correct. Come to page number 80. Tirupur has specifically stated that the sale deed dated 28/1/2020 executed by defendant 1 and 2 and 4 in favor of third defendant in respect of 4 acres 5 guntas is not binding on the plaintiff share.
Yes, my lord. Only the sale deed, the court said it is not binding on the share of plaintiffs, my lord. I am not, I mean, seeking what.
Seek that clarification from the appellate court. You are before the court. What is my share? Now at least I am entitled for the share of my vendor or whatever it is. You should ask the court.
Yes, my lord.
Why are you making the executing court to do that exercise?
No, my lord. See, as a bona fide purchaser,
No, you are before the appellate court. You are before the suit. You are a party to the suit. That should be determined by the court.
No, the court has determined in favor of my vendors, my lord.
There will be a finding in respect to what will happen to your sale deed also in the suit, in the judgment.
Now, with respect of sale deed.
When you are a party, so it will say that as far as the share of your vendor is concerned, you will entitled to have that. That would be the whole purpose to implead the purchaser.
Yes, my lord. Only with respect of sale deed, my lord, the court said it is not binding on the share of plaintiffs, my lord.
So what exercise you have to do before the appellate court, you are doing it before the executive. Impermissible.
No, madam, only assigning the share to me, my lord.
It will be done by the executing court when there is no finding with regard to this by the appellate court or in the suit. It's only executing it. You are a party to those proceedings. You can seek that clarification from that court.
But my the sale deed, my lord, the appellate court said only it is not binding on the.
Then you should file a review, and you should ask the court. Then what happened to my share, and what is the finding on my fate?
My lord, now I am stepping into the shoes of my vendors, my lord.
That interpretation is not possible. Court is right. Please come. The petition is before this court. Agreed with orders passed on I number 6 in FDP number 1 of 25 dated 4/6/2026, whereby the court has dismissed an application filed by the applicant defendant number 3 under section 44 of the Transfer of Property Act, read with order 22 relating CTC. It is a case of the petitioner that the executing court may assign the share of defendant 1, 2, and 4 to the petitioner herein who is the defendant number 3, with respect to item number 125 with the suit schedule properties, and to defendant number 3 in separate position enjoyment of item number 125 of the suit schedule properties that came to be dismissed by the court, wherein the court has observed that the judgment and decree passed in RA number 10005 of 2024, it is stated that the sale deed dated 28/5/2020 executed by defendant number 1, 2, and 4 in favor of third respondent defendant in respect of 4 acres 5 guntas in item number 1 is not binding on plaintiffs. When the appellate court has specifically ordered the share of plaintiffs and defendants, this court, the executing court cannot interfere in the order passed by the 5th Additional District and Session Judge Tirupur. Hence, the application filed by the third respondent, the third defendant is not maintainable under law. If the third defendant is agreed with the judgment decree, court has already observed that if the third defendant is agreed with the judgment and decree passed by the 5th Additional District and Session Judge Tirupur, they have to prefer an appeal in proper forum. It's not judicial discipline to interfere in the order passed by the appellate court. That the share of the parties are allotted as per the judgment and decree passed by the 5th Additional District and Session Judge Tirupur in RA number 10005 of 2024. You didn't prefer any appeal against this?
Appeal is filed, my lord, is pending.
The land counsel appearing for the petitioner submits that when the sale deeds executed in favor of the petitioner are not set aside, and the court has allotted the share to the plaintiff, and as far as the share of the vendors of the defendant or concerned is entitled for the said share, and that rights can be assigned to the petitioner defendant number 3, and this aspect was not considered by the court and dismissed the application. Next, by having heard the counsel for the petitioner, there is a material on record. The petitioner is defendant number 3. He was the party to the suit as well as to the appeal. The appellate court has passed a judgment and decree whereby the court has decreed the suit, specifically mentioning about the shares of the plaintiff and the other defendants. As far as defendant number 3, who is a purchaser from the joint family members, and about his sale deed or about his share, there is don't say about the sale deed, about his share or about his entitlement. There is no mention in the judgment and decree passed in RA. The trial court has rightly observed that it cannot go beyond the decree, and the court cannot pass any order, and the remedy available to the party is to question the judgment and decree passed by the appellate court. In the considered opinion of the court, the order passed by the court is a well-considered one. No interference is called for. Accordingly dismissed. Yes, next.
14, P.S. Malipati.
My lord, in this matter, my lord, I am appealing for the petitioner, my lord. The petitioner, my lord, is the plaintiff in the trial court, my lord. The plaintiff shall file the suit for partition and separate possession, my lord. My lord, the case was, my lord, the case was posted for argument, my lord. The plaintiff has filed the application for recalling and reopening the evidence of the further evidence of the PW1. My lord, earlier, my lord, he has filed the application for rejection of plaint under Order 7 to 11, and that application was rejected, and it was referred the CRP before this honorable court, my lord. CRP was dismissed, my lord, in the month of December 2025. My lord. Thereafter, my lord, I have read the evidence, and cross-examination was completed. Now posted for cross-examination evidence suit, my lord, the arguments, my lord. My lord, some documents I have left out at the time of my lord reading the evidence. Subsequently, I have filed the application, my lord, for recalling and reopen annexure C and D, my lord.
After the suit is of which year? 2009.
My lord, suit was 2009, my lord. My lord, after filing of suit, my lord, the defendant has filed application for rejection of plaint, my lord. That application was dismissed, and subsequently he has referred the CRP.
Please come to the order. Let's see what are the reasons.
My lord, kindly see, my lord, page number 28. Sir, page number 30. Page number 30. My lord, para number 8. The plaintiff, my lord, as per the plaintiff number 4, my lord, the defendant is working KSRTC Tumkur division. Recently, they have obtained the document from the KSRTC under the RT Act. Earlier advocate not produced the document. Hence, the summons of the document from the KSRTC for examining the KSRTC official. The evidence has been reopened. The plaintiff has filed IA so and so summons the KSRTC officer to produce the document and give the evidence. The suit in 2019, even though the plaintiff has reduced the complete evidence in 2000, but however, the order of the order 711 CPC, the defendant went to Honorable High Court matter filed the CRP. Now the CRP was dismissed in the month of December 2025. After the that, my lord, the defendant has dead the evidence. Now the after the completion of those filed, case was put. My lord, my submission before this court, my lord, the Honorable High Court had disposed the CRP 2025. Thereafter, my lord, I have lead the evidence. Within the 6 months, my lord, I have completed. Within 3 months, my lord, I have completed. My lord, at the time of my lord, evidence, my lord, I have marked.
Come to your affidavit. Where is the affidavit?
My lord, affidavit, my lord, para number 3, page number 23, my lord. It is submitted that set out the argument of defendant side, however, when my advocate on record verify the case paper preferring the argue the case, but a key document established my case is not at all marked and same is not found in the file, which is obtained under the RTA information. I have obtained some document and stated about and handed over my earlier counsel who has on record and he has informed that he has produced the document, the shared document to this court. However, either it is produced and for not found in the file, at this copy of I have copy of the date document without original, which is not to be produced to court, and therefore they summons those documents from the administrative officer, Karnataka State Finance Corporation, and also
What are
given the
those
evidence in
documents?
support of sir.
What are those documents?
My lord, documents regarding service records, my lord, pertaining to the defendant is working as a KSRTC driver, my lord. In item number 4, my lord, the item number 4 of the social property, my lord, it was purchased by the petitioner number 4 and the defendant, my lord. But that item number 4 property was purchased the income of the petitioner. Therefore, my lord.
Petition is committed in court hands. Will not stay your suit.
My lord, the trial court, my lord, has posted the argument date by day, my lord. Therefore, my today is posted for argument. Until appearance of the defendant, my lord, this honorable court by.
You are seeking stay of your own suit in this manner. That shows that you have no interest to pursue the case.
My lord, yeah, my submission, my lord, the defendant has approached before this court by filing a CRP, my lord. The CRP was pending till 2025, my lord. The orderly observation is the honorable High Court.
You will keep this suit pending for another 10 years now.
No, my lord. It may be time limit fixed, my next date of hearing. I have read the evidence.
This is matter. Once the petition is permitted, take out hand summons and file a memo. Once the memo is filed, list the matter.
My lord, interim order may be till next date of hearing, my lord. It is 10 days, my lord. Otherwise, till appearance of the defendant. Otherwise, my lord, the trial court has disposed.
You serve the papers on Monday. It will come on Tuesday. Yes.
Number 15, Vikram Sinha for petitioner.
The petitioner, your lordship.
Yes.
Your ladyship, I am the defendant number 1 and 2 before the trial court, and I am the Residents Welfare Association. There are 198 villas in my residential community, my lords. My lords?
What is the suit for?
Suit is for injunction, restraining me from collecting maintenance, restraining me from disconnecting any power of the generator, DG sets, doing garbage disposal, all other thing, my lord. They have asked for the scheduled property of 16 acres. All this interim order.
If you stop, who will do?
My lord, I am not. No.
They are seeking an injunction, restraining you from doing all this.
Collecting even the maintenance also.
Who will do it according to them? They will do it.
That is what, my lord. There is a contractual obligation in against them in their own sale deed by the plaintiffs before the trial court.
What are the plaintiffs?
Only 9 plaintiffs, my lord. 13 plaintiffs, 9 villa owners. And it's a gated community, my lord. We are taking care of it. There's an interim order which is granted against them in my previous suit. They do not disclose that before the trial court. After my caveat lapses, my lord, after a matter of 1 year, we have not troubled them even though we have an interim order, my lord. Their main contention is they don't want to be a part of the association. They want to form a parallel association and they want to do their own things.
Let's see the order.
Order is at, my lords, page number Annexure A, my lords, page 23, my lords. Annexure, my lord, before that, my lords, I would want you, I would want the ladyship to see the interim application, my lord, at page 28. Order 39, rule 1 and 2, which they have filed. Kindly, let me take your ladyship to the page 29, my lords, where the schedule is there. Page 29 schedule of the application filed by the plaintiffs before the trial court. They say the residential layout known as RBD
16
Stillwaters.
acres, 34 guntas.
16 acres entire they have asked for interim order, my lord. There are only 9 villa owners.
Application, let's see the affidavit in support of that.
My lord, affidavit is at page number 30, my lords. I so and so. I state that I am plaintiff number 13 in the above suit. I state that I am well aware, my lord, I am not come here on merits. This had to be disposed within 30 days under order 39 rule 3A, which the trial court hasn't done. Even after me filing the objections on the first date of hearing,
When was the injunction granted?
my lord, injunction was granted on 5/3, my lords, 5/3/2026. Kindly see the order sheet, my lord. First, they do not grant the injunction.
You file your objection.
My objections were filed on 2/4/2026. And till date, my lord, I have filed even order 39 rule 4 application to
Want the
vacate
court
the
to
interim
decide
order.
it?
My lords?
You want the court to decide that application?
Yes, my lords, it has to be decided.
That's it.
That's it, my lords. That's it. Within 30 days time, my lords, as per order 39 rule 3A.
Please come. When comes to the petitioner submits that. The petition is filed seeking the following prayer. When counsel for the petitioner or defendant submits that. The respondent have filed a suit for injunction seeking several reliefs and also filed an IA seeking interim injunction. And by order dated 5/3/2026, the court has granted injunction as prayed for. The petitioner defendant has filed his objections on 2/4/2026. And from 2/4/2026 till now, the court has failed to consider the application. The same has to be decided within 30 days from the date of the application. Hence, the petition has come before the court. And that's a limited prayer the petitioner is seeking before this court. Considering the submission of the land counsel to the petition. The writ petition, this court is passing the following order. The writ petition is disposed of directing the trial court to consider the IA, your number is?
My lord, IA number 3, my lords, is order 39 rule 4.
Filed by the defendant.
Number 1 and 2.
I number 1 and 2. That's IA number 3. 3 within a period of 1 week from the date of receipt of the copy of the. Yes.
Cell number 16.
Deeply obliged, your
Petitioner
Same in this matter, cooperative portion, no notice is issued to the respondent. A disposal of the matter is in the interest of both the parties, as no adverse orders are filed. Yes.
My lord, appearing for the petitioner. My lord, the petitioner is the holder of the CL-9 license. My lord, a request was made for shifting the said premises from one panchayat to another panchayat. My lord, the online portal of the excise department provides for trade license, wherein I have to upload the trade license that is given by the local panchayat. My lord, I make an application before the local panchayat requesting for trade license. My lord, they keep my application pending till date, no order is passed. By operation of law, my lord, under section 72C of the Panchayat Raj Act, my lord, if an application is not decided within 60 days, it is deemed license. Now, my lord, the deemed license, my lord, in online portal, I cannot upload that license. It is not accepting because I don't have a license. Even though it is construed as a deemed license, physical copy.
Where is the prayer?
My lord, prayer is your lordship should find at, my lord, page 9. And moreover, my lord, there is a circular also by the government wherein trade license is not required. I have
What
produced
is this 17/4/2026 endorsement?
My lords,
Your prayer be to quash.
yes, the endorsement is given by the excise department now that you have to make an application under online portal only. Now, with regard to online portal, my lord, without trade license, it doesn't accept it. So this is the dilemma here.
What are your
My
instructions?
lords, the Panchayat Raj, first of all, it has to answer, my lords. Rest I take the notice, my lords. The Panchayat Raj lawyer is Praveen Kumar. One Mr. Praveen Kumar has to take notice.
Panchayat will issue the excise license.
No, my lords. The concerned Panchayat officer who has refused to issue the trade license, he has to answer, my lords.
Now here trade license, my lord, there is one circular which I have produced. Unfortunately, my lord, it's in Kannada. I thought, my lord, since it is against the panchayat, it will be classified as LB. Otherwise, I would have filed the translation copies.
Trade license.
Trade license is not required. As per government circular annexure E, my lord, it is in Kannada.
No, you all these directions, directing the respondents to consider the shifting of license of the petitioner without insisting for the trade license. To make necessary change in the online portal. So it's only the panchayat who is concerned with this.
Yes, panchayat has to, either it has to issue trade license or, my lord, the
Who is
excise
Who is
department.
the counsel?
Praveen Kumar, one Mr. Praveen Kumar.
So and so, and then counsel for the petitioner is for, shall serve the copy of the writ petition on so and so. This is matter on Tuesday in the name of the council.
Please, my lord, oblige.
That is tomorrow, my lords? Tomorrow.
Tuesday.
Next.
36.
Please.
Cell number 17. Krishna.
I appear for the petitions, my lord. The petitioner is the plaintiff before the court below, my lord. The petitioner is the plaintiff before the court, my lord. It's a suit for specific performance of an agreement executed by the defendant, my lord. The suit is filed, my lord. An ex parte injunction is granted, my lord. Defendant is placed ex parte. The matter is at the stage of evidence when the plaintiff's counsel himself brought to the notice of the court that the agreement of sale is not stamped. Lord, thereafter, my lord, the trial court, my lord, transmits a Xerox copy of the document to the district registrar for an opinion, my lord. District registrar opines that, my lord, it's an agreement where possession has been handed over, my lord. It's contrary to the document itself, my lord. Possession has not been handed over. In fact, my lord, though I paid the stamp duty, my lord, I had not got it endorsed on the agreement of sale. Therefore, my lord, I made an application to the trial court to transmit the original agreement of sale to the district registrar to be dealt under section 31 of the Karnataka Stamp Act. That application has been dismissed. Defendant has been placed ex parte. I have produced the agreement of the translation, my lord. It's one without possession, my lord. My application is at page.
Notice is not necessary.
Notice may not be necessary. It's placed ex parte, my lord. Page 71 is my application, my lord. Annexure H 71 is my application.
This will hear it on next on 29th and pass orders.
My lord, very well, my lord. But the matter is posted on 6/7, my lord. The trial court is insisting that I have to pay the duty.
This is matter on 29th, considering the submission of the land council. There shall be stay of all further proceedings. Your suit.
Stay of suit till the next date, my lord. That should suffice.
It's a matter on 29th.
Obliged.
Cell number 18. Sharath S. Gowda.
Give the file. Give the earlier file.
Defendant's petition, my lord.
Then counsel for the petitioner suppressor. The agreement of sale dated 19/8/2020. Through the agreement of sale dated 19/8/2020, the portion of the suit stated property has not been handed over to the plaintiff. And the report of the district registrar is contrary to the contents of the agreement. These aspects were not considered by the court. They submitted to the defendant and was placed ex parte. This is matter on 29th. Till such time they shall be stay of all further proceedings. Yes.
Cell number 18. Sharath S. Gowda.
Great to appear for the petition. Defendant's petition, my lords. Lords, initially plaintiff filed the suit for bare injunction, my lords. Later on, she converted it for the relief of declaration. Lords, plaintiff case is this. Lords. My lord, suit,
What is the present IA?
my lords.
What is the present IA?
Present IA, my lords, I filed an application to delete marking of a document styled as declaration cum ratification deed, my lords. I'll just narrate, my lords, why this was filed. Plaintiff, my lords, claims on the basis of a sale deed executed by Remco BHL Housing Society, my lords. My lords, the acquisition, my lords, was quashed by this honorable court, later confirmed by the Supreme Court, my lords, directing to restore the land to the landowners. In spite of quashing of the acquisition proceedings by this court and by the Supreme Court, plaintiff claims that the landowners have executed a document styled as declaration cum ratification deed in the year 2000, my lords. My lords, our submission was before the trial court that there is reconveyance, because once the Supreme Court quashes the acquisition, title restores to the landowners. If landowners have to reconvey the land to the
Something should happen.
society,
No. The apex court said that it should be reconveyed. Then
it is reconveyed to the landowners. If
all the revenue, all the records and all.
everything came in the name of landowners. If landowners again have to give it back to the society, my lords, it must be but through a registered document itself. Now the plaintiff claims that the society has got a document in the style of declaration cum ratification deed from the landowners in spite of quashing of the acquisition proceedings. This document is not registered, my lords. Therefore, we objected for marking of this document. My lords, we cited, your lordship may now kindly take annexure G, my lords, for a moment. Identical thing. And this was produced along with the application. Annexure G, my lords, at page 131, running page 131. Your lordship may kindly take page 133, prayer also.
Yes.
Defendant number 2, so and so is seeking issuance of certificate to quash the order dated dismissing IA number 10 filed under 115, seeking an order not to mark 3 documents mentioned in the application. Then your lordship may kindly take page 141. The point that arose for consideration before this honorable court. Your lordship will see this declaration cum ratification deed, whether page 141, my lords, where lordship got page 141, my lords. Whether the agreements dated so and so produced by the plaintiff are required to be impounded. Second, whether the declaration cum ratification deed dated 1811 is inadmissible in evidence, as the same is not a registered document. Then your lordship will kindly come to para 19 onwards.
No, ultimately we'll come to 152. What is the court?
Ultimately, my lords, this court said it is compulsory registrable document at page 153.
The trial court is directed to impound the agreement dated.
Yes, so and so. And Roman 4, the declaration cum ratification deed is compulsory registrable document, but the same is not registered. Therefore, the same shall not be received.
Impounded
is the finding. This is in a collateral case, identical document in a collateral case. Now, in spite of producing this judgment, in the instant case, if your lordship takes the impugned order, my lords, strangely, contrary to the finding of this honorable court,
Which number?
page number, my lords, in the impugned order starts from page 18. Your lordship may kindly take page 29, running page 29.
Where is the consideration of this court's order?
Well, this court order is not at all considered, in spite of producing that along with our affidavit.
Let's see, where did you say in your affidavit about that?
Please, my lords, your lordship may kindly take my affidavit. My application, my lords, is at page 166.
Same is confirmed by the High Court of Karnataka.
Yes, my lords. Your lordship will kindly take. I have produced both WP order at para 12, my lords.
Please come.
Para 12, page 169.
The defendants in the suit or before this court agreed with the order. Where do you get that order?
Order page 18, my lords.
Agreed with the order dated 2nd June 2026, passed on I number 44 in OS number 3188 of 2017 by so and so, dated 2nd June 2026, whereby the court has rejected the IA that is filed by the defendants.
1 and 2.
It is submitted that this order is contrary to the order passed by coordinate bench of this court in WP number 1655 of 2024, dated what is the date
27
of
March
order?
2024. 27 March 2024.
27th March
2024.
2025, wherein this court, with respect to the very same documents, the agreement, the document that is agreement dated 29/4/1984 and 25/2/1992, the court has said that
And the declaration come ratification deed, my lords. That is the
declaration come ratification deed, they have to be impounded.
for agreements, my lords, it said impounded. Declaration come ratification deed, compulsory registrable, not permissible to be taken in evidence.
Where did the courts, the declaration come ratification deed dated 18/11/2000 is compulsory registrable document, but the same is not
Received in evidence.
compulsory registrable, therefore the same shall not be received in evidence. It is the case of the petitioner that this particular order is placed before the court, and the very same, the rectification come
Declaration deed.
rectification deeds are before the court dated 18/11/2000, but the court has failed to consider the same. Considering the same, they should be stay of all further proceedings. Same notice to hand summons to the counsel for the respondent. A memo shall be filed by 20th of July, or else a stay granted by this court stands vacated.
Cell number
Lords,
19
interim order, my lords.
Interim order of the
Stay.
grant.
Yes. May I ask for and delivery of the interim order, my lords. Trial court is proceeding on date.
And delivery of the order.
Grateful, my
Yes.
lords.
Cell number 20.
And is the matter coming up before the trial court?
Tomorrow, my lords.
Yes.
H. Manjunath.
Very good. This matter become infructuous, my lord. Trial court already disposed the matter by judgment and decree.
Memo is filed stating that the writ petition has become infructuous and the trial court has already disposed of the
Disposed
suit
on
itself.
24/4/2026.
24/4/2016, the suit itself is disposed of. Hence dismissed as infructuous.
Cell number
21.
21. 21.
Am I permitted to appear for the petitioner's counsel? Lord,
Who
what
wants
is challenged in the suit, my lord, is a compromise. Lord, separate suit challenging the compromise is not maintainable. They will have to go back to the same court and, my lord,
He
file
is the party to the.
not a party, my lord. Then, my lord, the Supreme Court says, even if they are not a party, the remedy is, my lord, to go
That compromise is by the court.
by the
or-
family members,
By the court or before the legal services authority?
by the court, by the court, by the court. Can I just give this judgment? my
Yes,
lord?
take that.
Please have a look at, my lord, para 39, my lord. Page 705, para 39. Admittedly, para 39, my lord, 39. Admittedly, the plaintiff is a stranger to the suit which ended in a compromise. Therefore, in view of the direct bar under Order 23, Rule 3A, he cannot seek declaration that the compromise decree passed in suit number so-and-so are void ab initio, null and void, and same are liable to be set aside. The law on this point is well settled in Trilokinath Singh versus Anirudh Singh. Bar under 23, Rule 3A is applicable to third parties as well, and the only remedy available to them is to approach the same court. In the present case, such an exercise is not possible in view of the bar of limitation. Hence, the suit is to be unsustainable. Here also, my lord, what they would do is, they would challenge the compromise decree directly. Please have a look at the plaint, my lord.
No, according to you, a third party to the compromise decree
Yes, my lord.
cannot seek a suit for declaration that that said compromise decree is not binding on him.
No, my lord, they cannot. In view of this judgment,
This judgment.
yes, my
Where
lord.
is the law on this?
My lord, there are other judgments earlier.
See, that you please place before the court.
Yeah.
There is no ratio in this para 39 to be considered.
Very well, my lord. Trilokinath judgment is there.
Get the Trilokinath.
I'll agree. My lords may have it tomorrow, my lord.
Tomorrow.
Yes, my lord. I'm grateful.
Cell number 22. Yeah, Abhinav Ramanand.
Lord, in this, my lord, the title is denied in the year 1999. Suit is filed in the year
Come to
2024.
the affidavit straight away.
Sorry, my lord.
Come to the affidavit that's filed in
Yes,
support
my
of the IA.
Yes, my lord, I'll come. Please take the application,
Hmm.
my lord, which is there at page number 33, my lord. Please take page number 33, that is the application. My lord, please come to para 2 in page number 34. My lord, 63, 64, it was standing in the name of the plaintiff's father, Nanjundappa Pandit. And then representation was given by Nagappa, alias Nagaya, that is father of the defendants, on 1/12/1999 to the village panchayat to transfer the kata in his name. At para 7, plaintiff has stated after the death of Nagappa, his wife and daughters were deceased. Then, my lords, may please come to, my lord, page 35. From the above averments made in the plaint, I'm reading the third line, my lord. It is clear that the plaintiff became aware of the adverse claims made by the legal heirs of Nanjunda Pandit in the year 1999 itself. Title and claim of the plaintiffs having been denied way back in the year 1999 cannot be the subject matter of a suit in 2024, 25 years after his right title and interest was denied. Under Article 58 of the limitation.
Suit is for declaration.
Yes, my lord, suit is for declaration.
No, why you say that it is 33 years?
Declaration is 3 years, my lord. Declaration injunction is 3 years. Declaration possession is 12 years.
Yes.
And my lord, no, if my lords were to see the plaint, no document is produced as to how this plaintiff gets title.
No, please come to the plate.
I'll come to the plaint, my lord.
Yes.
Please come to page 26, my lord. My lord, whatever is stated in the affidavit is just, my lord, what I have extracted. My lord, para 5, my lord, about the 1962-63, it was in the name of the defendant's grandfather. Then 1999, my lords will get at page number 28. Then, my lord, no averment. They file, my lord, before the panchayat, my lord, they get it rejected. Entire course of the plaint, my lord, no mention of how they derive title to the property. Not one document is produced. There is no cause of action. And their title is denied in the year 1999. How they derive title, one document, basic document, they must produce before the court and plead about it.
How did the court decide this?
Court says, my lord, it's a question of trial.
Let's-
I'll show that to my lords. Lord, please take. Lord, page 15, where the contentions are noticed. Then, my lord, reason starts from page number 20. Please come to page number 22, para 7. It is pertinent to note that the defendant submitted that the title of the plaintiff was.
Let counsel for the petitioner submits that. According to the plaintiff, the defendants have denied their title to the property in the year 1999 and making a illusory cause of action in the year 2023. The present suit is filed. But the court has dismissed the case, saying that question of limitation is a fact and law. When on the face of the plaint, looking at the arguments, that itself shows that the suit is barred by limitation. This aspect was not considered. Considering the same case, stay all further proceedings and so on.
I'm grateful.
Notice, hand summons from the council. Memo shall be filed by 16th of July, or else the stay granted by this court stands vacated.
I'm grateful, my lord.
23, A. Madhusudan Rao for petitioner.
In this case, for the petitioner, my lords, this matter may be kindly taken up on next week, my lords. But if we have some personal inquiries.
Listed in the third week of July. Yes.
Number 24. Jitendra.
Petitioner. The suit filed by the plaintiff for their injunction, and later, after hearing the IA number 1, he filed IA number 2 seeking amendment of the plaint, seeking the prayer included the possession by way of adverse. And I have
For
filed the
injunction, and now he wants declaration that he has perfected the title by adverse possession.
yes. I have purchased the property from his father, my lord, in the year 2015.
When is the suit filed?
Suit filed in the year 2024, my lord.
That was a bare injunction suit saying that he is in possession of the property.
Yes.
Then
I have permitted him to take care of the property, my lord.
No, whether he's entitled for adverse possession or not, the court will decide. Now let's see, where is your IA? Come to the order.
IA number,
Come to the
Three.
affidavit.
IA number 3, my lord,
Page number.
page number 61, my lord. The said application, my lord, I have filed writ petition before this honorable court, and this honorable court stayed the proceedings of lower court
Where is
pending
that?
before this honorable.
Hmm?
2/6/2026. And hand summons also issued to him, and I have
What
served.
is the present application?
Present application is the rejection of suit.
What is that application?
That
Amendment of
application,
date?
I challenge the amendment of the plaint.
Hmm. Then we'll tag on this to that, then we'll ask them to take notice. The Lizzie's matter along with so and so, petition is permitted to take out hand summons.
Cell number 25, Ravindranatham.
Yes.
And defendant's writ petition as CRP, and application was made under for rejection of plaint.
Come to the affidavit.
Please, impugned order, and
Affidavit.
page number 13. Court says that section 16 of Hindu Succession Act applies. Therefore, plaint cannot be rejected. Contention of the plaint, see?
I'm looking at the affidavit filed by you.
Affidavit page number 30, 28, paragraph number 2. My contention before the trial court is that.
Yes,
under
you're
section-
relying on the amendment to section 6.
Yes, yes.
Please come to the order. How the court has dealt with it.
Court said, suit will not come under section 6 at all, and it is only under section 16. Now, the plaintiffs have filed the
Notice to the respondents, petition is permitted to take out hand summons on the counsel appearing for the respondent. File a memo to that effect by 13th of July. If the memo is filed, list the matter on 14th.
the interim prayer.
Cell number
Interim
26,
prayer. Now it is posted for evidence, it appears.
We'll see, evidence takes a lot of time.
Please.
It's 26.
cell number 26, Shanath.
For the petitioner, my lord. Lord, this petition is challenging the allowing of the miscellaneous application under section 25 of CPC, my lord, 24 of CPC, my lord, for transfer. My lord, respondent number 1 had filed a suit for partition in the year 2008. It was decreed and FDP was filed in the year 2009. My lord, prior to the filing of the partition suit, one of the sharers had sold the property to the petitioner herein. Subsequent thereto, all the parties who are part of the partition suit have entered into a confirmation deed in my favor. They have executed a confirmation deed in my favor. Subsequent thereto, I have filed a suit for declaration stating the decree in partition suit is not binding on me, and I have withdrawn in view of the compromise deed that is executed in my favor. Subsequently, my lord, I file an application before the FDP court seeking deletion of my item schedule property. And no order is.
Of the compromise.
Yes, ma'am. In view of the
respect
compromise.
to the property which you have purchased.
Please. Thereafter, no order was passed. The respondents were directed to file their statement of objection. No objection were filed. Despite that, they file a miscellaneous petition under section 24, seeking we have no confidence in the presiding officer, hence this FDP should be transferred to a different court. My lord, no allegations are made. And my lords, if my lords come to page number 22, the impugned order, the court says.
How are you concerned now? No, you are not contesting it. Only one
No, my lord, my application.
No, this is the only thing. Ultimately, they have to proceed with the FDP proceedings.
My lord, the order, the FDP court has deleted my item schedule property from the array of, from the pool of properties, my lord. Now, my lord, that order.
Transfer, it will transfer from after whatever the subsequent proceedings. Earlier order will not go.
Yes, my lords, may kindly come to this reasoning that is given by the judge, my lord.
No. When is the order deleting your property?
That is prior to this, man.
Then how will it affect?
Lord, I'm only seeking stay of this order because there are certain observations made against me in the order, and there's no reasons given. My lord, this is against the judgments of this honorable court and the honorable Supreme Court.
We will hear it, will not stay anything.
But I'm just seeking stay of the order, my lord, not of the proceedings.
Why should we will hear the other side and pass orders? No stay. Notice to the respondent petition permitted take out hands and file a memo. To that effect, the memo is filed on 29th of July. By 29th of July, list is marked on 30th. Yes.
Serial number 27 for orders matter. Kumaraswamy MC.
I'm appearing for respond number 14 and 15, my lord.
My lord, I'm for the respondent number 63 and 64 in this matter.
There is an interim order in this.
My lord, on submission, my lord.
Yes. Yes.
My lord, already MFA 50466/25 connected matters ongoing, my lord.
No representation on behalf of the petitioner. This is
Paragraph
part,
5 and 6, my lord, the trial court has clearly explained why the application has.
No stay. This is matter in the month of September.
Serial number 28. Serial number 28.
For the petitioner, some objections are still lying. I am seeking some more time to remove the objections.
The writ petition
Notice was
has
issued.
become infructuous. Your lordships may kindly see.
Take that.
At the suit is pending there.
We'll see
Maybe-
what it is.
I may
what
be,
he's saying.
On the
make my
application
submissions.
filed by the other
Lordships may
side.
kindly see the order, the prayer which is sought in the present writ petition. He has challenged the order dated 2/5/2026, wherein the honorable trial court has directed both plaintiff and defendants not to act upon the compromise petition.
That
Due to want of time and urgent the matter for 2/6. 2/5/2026.
Another order is passed.
Pardon?
Another order is passed.
Yes, ma'am. Your lordships may kindly the certified copy of the order. On 1/6/2026.
1/6/20.
2026. May I, my lord?
Hence, the application is dismissed. With liberty to approach this court after disposal of the writ petition.
What
And
the
this court
honorable-
will pass necessary orders on pending application, depending
That's
upon the
why-
result of, what is this?
That is, I may, let me explain.
That is the
On
challenge in this
On
report.
1/6,
Submit, I'll hear.
on 1/6/2026, I filed an application for extension of the interim order, which was granted on the last date of the vacation, last date of the working day. The honorable trial court, only on the ground that the present writ petition is pending before this honorable court, has rejected my application for extension of the interim order. As such, there is no interim order which is subsisting as of now.
Oh, that order is in your favor.
That is challenged in this writ petition. Now, in view of non-extension of the interim order by the trial court, this present writ petition will not survive. And the your lordship,
Sure, IA?
IA is
That
for my
IA
lord.
is pending for consideration.
That will be
That is
decided.
the
That
challenge.
the court, let the court decide within span of time limit may be fixed.
Where is the impugned order?
Impugned order, your lordships, the petitioner is filed
Page 49.
48.
Operative portion is 49, 48 to 49. So my submission is that applications are not maintainable.
That
Will be
And they are
decided in
inter-
the court.
decided-
There is no adjudication on the merits of it. That the court has to decide on the maintainability of the application.
That is the challenge in this writ petition, and the court has issued notice. Let them file reply, and I have procured the objections. Some objections have been
Petition is
raised.
agreed with order dated 2/5/2026. Whereby, before pending consideration of the application filed by the respondent herein under section 151 CPC, under order 16 rule 6 and order 11 rule 14, let me section 151 CPC. The court has directed not to act upon compromise decree till reopening day on 1/6/2026. When counsel appearing for the petition submits that interim order, the respondent submits that the interim order is not extended, and he has placed before the court the order sheet wherein an order is passed on 1/6/2026 stating that hence application is dismissed with liberty to approach this court after disposal of the writ petition, and the court will pass necessary orders on pending application depending upon the result of the writ petition. Basing on this, it is submitted with the learned counsel for the respondent that there may be a direction to consider the IA on the merits of it. Learned counsel for the petitioner submits that IA itself is not maintainable, hence he has come before the court. The petition has come before the court, where the court has passed an order that the compromise decree should not be acted upon. Now that interim order is no more, is not extended, and the IA that is filed by the respondent, IA number?
IA number, two IAs have been filed, my lord.
Numbers.
I will provide.
Both the IAs filed under Order 16, Rule 6 and Order 11, Rule 14, read with Section 151 CPC. The court shall consider the same in accordance, the court shall consider the same in accordance with law. Nothing survives for consideration in this petition.
That is my submission, that should not be considered, because Lok Adalat compromise everything, he is a
And the
stranger.
court has to pass an order saying that it is not maintainable.
But I have come against the impugned order 49.
I am also looking at 49. The writ petition is disposed of, the directing the trial court to consider the pending IA in accordance with law
My lord, time limit may be fixed because I am the
within a period of 1 month from the date of receipt of the copy of the order.
much of it.
29, Vishnu. Petitioner.
Yes.
In this case, my lord, I am appearing for the petitioner.
Hmm?
Petitioner, my lord, I am the plaintiff in the original suit.
What about the office objections? Why can you not
Office
complain?
objection, my lord. We have filed the 3 application, recall, reopen and production of additional documents before the trial court. Common impugned order was passed on 2/5/26. Against it, we paid 3.
Not as, is it by way of a common order?
Common order.
Let's see that.
May I make a submission? I filed my wakalat and my name is not shown in the cost list.
Anyway, it's coming up for preliminary hearing.
Kindly come to
Notice is not
annexure
ordered.
A, page number 16, Your.
Orders on IA number 20 to 22. Learned counsel, the office objection with regard to the maintainability is overruled. Yes.
In this particular case, my lord, the matter was posted for argument. At that moment, the plaintiff has found that there are 3 sale deeds, certified copies. It is pertaining to the boundaries of the property. It is the suit for the possession, my lord, and mean profits and other things. Then, my lord, at that juncture, the obtained the certified copy to identify the particular my property along with the boundary properties, and it is till today that boundary properties are existent. The honorable court has rejected that application, saying that it is a belated stage and it is at the stage of argument and not permissible. That particular thing order was passed on 2/5/26, my lord. Immediately on the opening day, this petition was filed on 1/6/2026. My humble submission before this honorable court. The now matter is posted for judgment. In such circumstances, my lord, if I get one opportunity.
When was the matter posted for judgment?
2/4/26, my lord. So the one day it is enough. I am not going to do any other particular thing. And this honorable court already.
One more day is required. What you will do?
Pardon?
1 day is required. What will you do?
I will mark that document, let them cross-examine, and the matter may be taken.
All this will happen in 1 day.
Maybe, my lord, if we are marking is only 3 documents certified.
Why have you not done it at the earliest point?
That is the things, my lord. The earlier.
It's not that is the thing. That is what is required. Come to your affidavit.
Come
Come to the affidavit filed in support of the IA. Where is the affidavit?
IAs are, my lord, at ink page number 48.
To recall the order dated 12/3/2019.
That is
Purpose of further chief examination of PW1. When was evidence is completed?
The evidence is completed, my lord, during
19.
Evidence itself is completed in
No,
2019.
my evidence. The total this.
Your evidence is completed?
My lord, after that, my lord, they file an application for the appointment of a commissioner. Two applications are filed for appointment of commissioner. Commissioner is appointed, my lord, and thereafter commissioner's report is also filed. Objections are taken and matter has been dragged on like this, my lord.
No, your evidence, when is it completed?
What, my lord?
Your evidence, when it was completed?
I completed in 2019 itself.
Oh, in the same year?
Not
Yes, yes.
19, 21, my lord. The,
We are in 26.
I agree, my lord. That was, there was.
Once you agree, then there is nothing.
No, relating to that, my lord, the findings of this honorable court as well as the Supreme Court, my
What the
lord.
Supreme Court and this court
The,
said?
even at the posting of the case for judgment, this honorable court is having power to provided that there is an injustice is going to
There
happen.
are reasonable grounds. What are the reasonable grounds? That's why I want you to look at, to read your affidavit. What did you say?
I specifically, plaintiff is dead, my lord.
Paragraph number, which paragraph you have given the reasons?
The fourth.
Please read that.
I submit the plaintiff after her lifetime, she is dead during pendency of the case.
When she died?
She died, my lord, 2018. Then, my lord, the LRs of the plaintiffs are lawful owners and futures and ownership in the suit scheduled property. Above case is posted for argument partly heard. The fact commencing, in fact, after commencing the argument from the plaintiff side, it was found that court records 3 sale deeds pertaining to the east, west, southern side of the boundaries of the suit scheduled properties are not able to trace in the court file. As per my knowledge, while submitting the interim application, the said 3 sale deeds are submitted but not able to trace it. Subsequently, I have informed my advocate that I will get certified copies of the said 3 sale deeds again requested submitted before the honorable court. Accordingly, I have availed the said 3 sale deeds on 31/3/2026, my lord. Produced 3 sale deeds with memo and necessary application is also filed. I submit that the first sale deed dated 28/11/86 is exclusive executed by writers and artists, House Building Cooperative Society Limited, Vishwabharati Housing Society, in favor of one Hanumant Reddy in respect of site number 295 of.
Why these documents are not marked?
It was the under impression that the earlier it was given. At the time of the argument, we were traced out these things. It is necessary to identify the property itself, my lord. Because of this,
Suit is for?
justice, he shall not be suffered.
Suit is for?
Pardon?
Suit is for?
Possession only. They are not disputing our title. It is also allotted to me 1986.
Yes, what you said?
Lordship may kindly see.
They are also the allottees, different property number. They are saying it is my property.
Yes.
First of all, my lord, those documents which are sought to be brought on record, my lord, has got nothing to do with the case. The boundaries are nothing to do with my case nor his case. Now kindly see, my lord, my ink page 64 of his petition, where, my lord, I have filed my statement of objections at ink page 63. Kindly come to paragraph 2, my lord, ink page 64. This is a long checkered case of delay and harassment by the plaintiff, as the suit has been filed in the year 2018, seeking for a relief of possession and permanent injunction and mean profits. Both the parties have led their respective evidence, and after completion of the evidence, case was posted for final arguments on 24/3/2021, on which date the plaintiff came with an application for appointment of commissioner. The said application came to be allowed on 18/11/21, and the commissioner's report has been tabled before this honorable court on 9/11/22. Said report was not in favor of the plaintiff, and under circumstances, another application was introduced for appointment of the second commissioner of the same subject matter. The second commissioner report has also been tabled before this court on 15/4/25. The said report is also found to be not in his favor, and thereafter this honorable court proceeded to hear the case on merits. Plaintiff has addressed his arguments, and during the course of his arguments, no such issue has been raised, stating that the said document now sought to be produced with a mistaken impression that the said documents were already on record. If such documents were before the court, same would be reflected in the list of documents produced along with the suit. Such a contention by the plaintiff is unacceptable and an abuse of the due process of the court. Plaintiff has been unable to establish his case by his own evidence and documents produced by him, which are direct evidence to prove the case on hand. Further, there are two commissioners' report available before court, which report also states that the boundaries of the suit property and that the suit property is nowhere available in the fourth phase of the layout and that it is situated in the first phase of the said layout in question. And further, the report says that the property of the defendant is in the fourth phase. And further, to substantiate the same, the plaintiff has also admitted in his cross-examination that the defendant is the owner of site bearing number 4.
Different property, that is not my property. My property, kindly come to ink page number 33, my lord. This is the property number 295/P. And this particular 3 sale deeds are the adjacent western side property, northern side road it is existed, southern side property and eastern side property. 3 sale deeds certified copies are produced.
Why they are necessary now?
That is the particular issue, my lord,
Why
relating
issue?
to bona fide error.
Wanted 2 commissioners to be appointed. 2 commissioners were appointed. Report was before the court. And what you should say? What is the-
Commissioners, even there is this one, my lord, findings. The commissioners have reported before the trial court contending that survey number, these particular things are different survey numbers. Relating to that aspect, they have admitted that there is a sanction plan. It is their particular sanction plan is, my lord, subsequent to the earlier sanction plan. They have not produced the earlier sanction.
Agreed with the orders passed in number 20 to 22 dated.
And there are judgments relating to this aspect, my lord.
Please pass on. I'll consider and I'll dismiss. Exactly.
Only I am seeking opportunity, my lord. I am ready to do the things even on the same
The court
date.
is not ready to give you opportunity. Which paragraph in this Justice Krishna Kumar's judgment? Paragraph?
Relating to this particular
You can
case,
use
my
the
lord.
paragraph. Don't have to read the entire one.
Paragraph number, it is the case, my lord, posted for judgment. In that case, 3 applications are filed. The para number 3 and the observation is para number 4 and 5.
Next.
Then
Then
another Supreme Court, my lord.
you are relying on another judgment of Justice Vijay Kumar Patil. Which paragraph?
Yes, my lord. That in that particular case, para number 5, 6, my lord. Then Supreme Court judgment, my lord, the para number 8 and 11.
Yes. After lunch, I dictate this judgment.
Much obliged. With any cost
So
or
and so submits that.
with
For
any.
the respondent. No. I will dictate it at 2:30.
Name.
So and so. As filed wakalat on behalf of the respondents. Wakalat is taken on record. Yes, next.
Much of.
2:30 for all this for dictation.
Much of.
Number 30.
I appear for the petition.
Sam Devi.
I'm filing a memo for withdrawal, my lords. I was supposed to file a civil revision petition on the section.
MFA.
Civil revision petition, my lords, on the section 115 of CPC.
This is
I'm seeking,
filed questioning, order 7 rule 11.
my lords, order 7 rule 10, my lords, written of.
Memo is filed seeking, the writ petition is filed questioning an order passed on order 7 rule 10, and the petitioner has filed a writ petition. The office has raised objection with regard to the maintainability, and the petitioner has filed a memo seeking to withdraw the petition to file the appropriate petition accordingly. The writ petition is filed, and the memo is taken on record, and the writ petition is dismissed as withdrawn, giving liberty to the petitioner to file the appropriate petition within a period of 1 week. The office shall return all the documents. Yes.
Number 31.
Grateful.
Sidramaya VP.
The first petitioner is wife. Second
What is
petition
this? What are the office objections?
My lord, office objections, why annexure A is furnished? It is belongs to daughter of the petitioners, even though she is not a party to the proceedings. My lord, this document is produced by the.
You cannot produce a document like that in a writ petition, unconnected, which are not filed.
These are all connected. These are all issue based.
No, is it filed before the trial court?
No, this are the trial court, my lord, I am not a party to the proceedings. In the award, execution was filed to execute the award. There are 4 transactions.
No, what is the impugned order?
Impugned order is attachment warrant of the property of the petitioners.
You are a party to the executing.
Executing court petitioners are party.
Then have you filed this document there? You can't file in a writ petition whatever you want to file. You have to file the documents as filed before the trial court. If you're filing anything, that has to leave has to be there. You have to see how can you file.
Well, unless these documents are furnished, we have not filed objection before the trial court, mother. That is.
We can't help it. You have to file it separately by filing filing an IA for that, seeking the leave of the court. Office was right.
With liberty to file.
Annexure A is not related to petition. The office objection with regard to office of number 1 is upheld, and the petitioner shall comply with the same.
My lord, liberty to place all these documents before the executing
No
court.
liberty. You file, come up with an IA. Application, they have to number it if you file.
32, Prasanna VR.
2 applications notes are one and IA number 4 and 5.
Wait, what are the 2?
Common order notes. One application brought was section 47(3) of CPC seeking to intervene in the execution proceedings as third party obstructor. And notes another application notes under order 21 rule 26 seeking stay of further proceedings in the execution petition.
It's by way of a common order.
A common order.
The petitioner submits the order impugned or the common order. Hence, office objection with regard to the maintainability is overruled. Yes.
Please. Let the petition is.
We'll see it after lunch.
Yes.
One matter, Lords, may I make a mention, Lords.
Not now.
Serial number 18 in second list. Lords, we want to compromise the suit partially before the trial court, but because of a stay order granted in my petition, I am the petitioner, I have got a stay here. The trial court is, Lords, not recording the partial compromise.
You should have mentioned it in the morning.
I am aware, Lords. I'm sorry, Lords.
Because I make it a point that no mentioning at the 1:30 or 2:30 because there is no end to this mentioning.
I understand, Lords.
18.
ಮೇಡಮ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮೇಡಮ್ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆಗುತ್ತಾ ಲಿಸ್ಟು ಕರಿತೀರಾ
ಮೇಡಮ್ ಯಾವಾಗ ಕರಿತೀರಾ ಸರ್
ಕಂಟಿನ್ಯೂಯೇಷನ್ ಅಲ್ವಾ
ಮೇಡಮ್ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆಗುತ್ತಾ ಅಥವಾ ಧಾರವಾಡ ಬೆಂಚ್ ಐತಲ್ಲ ಅದನ್ನ ತಗೊಂತೀರಾ
ಧಾರವಾಡದ ಆಗೋಯ್ತು
ಆಗೋಯ್ತಾ
ಪಾರ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಆಗಿದೆ. ಆ ಹುಡುಗಿಗೆ ಕಳ್ಸು, ಫೋನ್ ಮಾಡ್ತಾವಳೆ ಅವಳು. ಪಾರ್ಟ್ ಡಿಕ್ಟೇಷನ್. ಹೌದಾ, ಯಾರಿಗಾಗಿದೆ ಇದು? ಇದರಲ್ಲಿ ಐವ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಯಾರು ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡ್ರು ನೋಡಿ ಇದು. 15ನೇ ತಾರೀಕಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಲಿಲ್ವಂತೆ. ನೋಡಿ ಸರ್, ಯಾರು ತಗೊಂಡಿದ್ದಾರೆ? ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ವಂತೆ. ಏನ್ ಸರ್ ನೀವೇನ್
forgot Martha. Compromise, yes.
See the settlement matter, reporting settlement case number 18, 37, list number 2.
But issues settled, parties are also present, filing a joint memo.
Parties present.
Where is the petitioner?
Well,
Where is the petitioner?
Petitioner, where is the petitioner?
petitioner, my lord. Here.
Where is the petitioner? MS Engineering College.
Yes, my lord. He represents MS. He represents MS.
Yes. And what is this memo?
Lord, we had given them two proposals. It's a right of way issue for construction of Lord, line. We had given them two proposals. They have accepted the second proposal. That is at page 3, my lord, is my proposal. Second option, they have said they are okay with the second option.
To increase the height of the proposed
Yes,
tower.
and that map at page 5 indicates the increased height. And they have undertaken not to do any construction beneath the corridor, and they will get compensation for the tower foot plus the corridor as per the
Where is it mentioned, in which paragraph?
First paragraph itself, my lord, mentions. Petitioner has no objection for construction of 220 kV multi-circuit line on the existing corridor, and thereby third respondent KPTCL agreed to increase the height of the proposed tower at location number 100, wherein the ground clearance would be 15.85 meters as against the existing ground
What is
clearance.
questioned in the petition? What is that order? Second respondent is?
Removal of obstruction was
Deputy
what
Commissioner's order
yes,
is questioned.
Yes.
Please come. The present petition is filed. Questioning the order passed by the second respondent dated 24/11/2023. Thereby, the second respondent has directed the petitioner not to create any obstruction.
Yes.
Not to create any obstruction. Today, a joint memo is placed before the court. The parties are present. A memo is filed stating as follows. Extract this, just a one memo. In the light of the memo that is filed, the writ petition is disposed of.
Great.
Yes, next. What is other two?
Cell number 29, list number 1, serial number 29.
The writ petition is filed. Agreed with the order passed in I number 20 to 22, invoice number 25, invoice number 197 of 2008, dated 2/5/2026, by the 35th Additional City Civil and Session Judge at Bangalore. The petitioner plaintiff is before this court. The petitioner plaintiff has filed I numbers 20 to 22. I number 20 is filed under section 151 CPC to recall the order dated 12/3/2019. I number 2 is filed under order 18 rule 17 for recall of TW1 for further chief examination. I number 22 is filed under order 7 rule 14 CPC for protection of the documents filed with the application. The court by order impugned had dismissed the applications. While dismissing the application, while dismissing the application, the court has observed that the opportunity given by the court to the plaintiff not properly utilized. The order sheet reveals that the plaintiff and her LRs are indulged in dilatory tactics. The legal maxim, law helps the vigilant, not those who sleep over their rights, emphasizes that the law assists those who are proactive in protecting their rights, not those who are negligent or inactive, and accordingly dismiss the application. Then counsel appearing for the petitioner submits that the petitioner is seeking possession, and these 3 sale deeds pertaining to the neighboring owners. Owners are very much crucial, which will be looking at the boundaries, where from the court can look at the boundaries of the boundaries in the said documents. Earlier, they were under the impression that those documents are before the court, and later, when they came to know that they are not placed before the court, the petitioner has come up with the instant application. The trial court, without considering the same, only on the ground that enough opportunity is given, has dismissed the IA. He has relied on an order passed by a coordinate bench in WP number 44631 of 2019 in case of Sri Munikrishnappa and others versus Sri PM Lokesh and others. He relied on paragraph number 5 and 6. It is submitted that in the said case, though there was a delay, still the court has permitted the party and allowed the application. He has also relied on another judgment of a coordinate bench in case of Chandaswamy alias Cheluvanna versus Parvathamma, arising out of WP number 2282 of 2026, dated 28 January 2026. He relied on paragraph number 3, 4, and 5. Extracted. Whenever I say para numbers, you should extract it, whether I tell or not. He has also relied on another judgment of the apex court, a judgment of the apex court in Sugandhi, within brackets, read by a legal representatives, and another versus P. Rajakumar, reported in 2020-10 SCC 706. He relied on paragraph number 8 to 11. Relying on this, it is submitted that the court went wrong in dismissing the applications without considering both the factual and the legal aspects. Next part. Then counsel appearing for the defendant submits that the defendant has filed his objections, and in these objections, it has been categorically mentioned how the plaintiff is dragging on the matter. The counsel has drawn the attention of the court to the objections filed before the court, and it is submitted that they have stated that the suit is filed in the year 2018, seeking the relief of possession, permanent injunction, and main profits, and both after completion of the evidence of both the parties, the matter was posted for final arguments on 24/3/2021, on which date the plaintiff came up with an application for appointment of a commissioner. The said application came to be allowed on 8/11/2021, and the commissioner report has also been tabled before the court on 9/11/2022. The report was not in favor of the plaintiff, and under the circumstances, another application was filed for appointment of the second commissioner on the same subject matter. The second commissioner's report has also been tabled before the court on 15/4/2025, and that also is not in favor of the petitioner plaintiff. Then thereafter, the court has proceeded to hear the matter. The plaintiff has addressed his arguments, and during the course of his arguments, no such issue has been raised, stating that the documents now sought to be produced is with a mistaken impression that the said documents were already on record. It is stated that if such documents were before the court, same would be reflected in the list of documents produced along with the suit. Such a contention by the plaintiff is unacceptable and an abuse of the process of the court. It is stated that without any basis, only to protract the proceedings, the present application is filed, and the court has rightly dismissed the application. There are no grounds to interfere. Next, having heard the counsels on either side, what is the material on record? There is no dispute about the fact that the matter was posted for final arguments on 24/3/2021, and thereafter two advocate commissioners, one after the other, were appointed, and both the reports are placed before the court. This court has perused the affidavit that is filed by the petitioner in support of these IAs. The reasons that are given and why the petitioner wants to rely on that said document cannot be considered. And already the petitioner has sought appointment of advocate commissioners, and the same was done. And again, another second advocate commissioner is also appointed. The court has rightly observed that the manner in which these successive applications are filed by the petitioner shows that the whole purpose is to delay and protract the proceedings. The petition has relied on several judgments. The ratio laid down in those judgments, it depends upon the facts and circumstances of each case. At a belated stage, when an application is filed before the court, the petitioner has to say why this was not done at an earlier and appropriate point of time. The reasons that are forthcoming, that are stated in the affidavit, and the reason and how it is put forth before this court by way of arguments is not convincing, and the trial court was right in dismissing the petition, and this court finds no reasons to interfere accordingly.
In this case, my lord, the both commission report does not say about the boundary at all. That is the particular case. That is the reason I am requesting my.
Yes.
One more mentioned matter. Cell number 18, Rajshekharappa DR. Jay Kumar.
For respondents.
For the respondent.
Who mentioned?
I mentioned.
Have you informed them?
We call him, but he is not. I called, but he is not pick up my call.
Then what to do?
Any date maybe.
Why did you mention today?
Because some of the petitioners are respondent are settled matter. Okay. Some of the petitioner and respondent are settled matter.
No, morning somebody. No, it is mentioned at 1:30.
Yes, ma'am. 1:30 I have mentioned.
Then where is he?
He is my senior. Man.
Just like that, without even telling the other side, you first of all mentioning at 1:30 was not appropriate. Still you mentioned.
No, I called, but he not pick up.
Huh?
I informed her, but he not pick my call, madam.
Let it be in the list whenever it reaches, it reaches. Yes.
Cell number 32, list continue. Cell number 32, list 1. Anna DR.
Yes.
The
application is filed by the petitioner as third party obstructor to protect the property standing in the name of the petitioner company. Not the petitioner company is the absolute owner who is not arrayed as a party in the suit.
No, what is the suit for?
Suit for declaration, declaring that the plaintiff is the absolute owner
You are the,
a scheduled property.
you are the,
Please no.
you are the plaintiff.
No, I am the third party obstructor who had filed application in the execution side because not there is a direct mandatory injunction granted in favor of the petitioner plaintiff to remove the alleged encroachment said to be made by the judgment debtor with respect to 4 into 100 feet. It is the case of the plaintiff that the defendant, who is a judgment debtor, will not encroach the property. Not the owner of the property, not is the present petitioner, which is a company represented by a director. Not the learned judge will not dismiss.
What is the construction and what is
It is a factory shed, my lords. It is a factory shed of the petitioner company. And my lords, what the plaintiff claimed that the judgment debtor has encroached the property. Not the plaintiff, petitioner is not arrayed as a party. Therefore,
then what happened?
Please note, now the executing court has dismissed the applications on the ground that the authorization issued by the company to represent the director is not a proprietary authority. Kindly see notes page number 34, para number 27. I have produced the sale deed showing my title notes.
No, your order 21 rule 97 is dismissed.
Lord, of course, Lord, it is my application is under 47, Lord, section
47 you have filed.
Yes.
That the decree is not executable.
Not executable. Please note, because the inquiry should have been conducted. Note, there is no inquiry as such notes made by the trial court. Let me kindly see for a moment. Notes section 47, subsection 2. Because I am not a party to the proceedings. Questions to be determined by the court executing decree. Where a question arises, subsection 2, notes. Where a question arises as to whether any person is or not the representative of a party, such a question shall, for purpose of this section, be determined by the court. For the purpose of this, a plaintiff whose suit has been dismissed and defendant against whom suit has been decreed are parties to the suit.
47 is applicable in this.
Lord, my contention is that since I am not a party, the owner of the property.
No, you are not a party. If the judgment and decree is passed.
Yes.
According then you will file a petition as an obstructor.
Yes.
How can sir? How it is not an executable decree?
Lord, of course, not a mere quoting a wrong provision may not come in the way. Not of course.
Oh, here,
of course.
No. That proposition will not apply here.
My contention
because the
was that
exercise under 47,
of course.
Exercise under 21,
Altogether
97 are two different things.
Yes. Of course, not the executing court ought to have considered whether it has got executable decree, not against a person who is a title holder. But I have produced the sale deed which standing in my name, the company's name. What the trial court, not executing court holds that the kindly see para number 27.
So first of all, you read it. How will you come within the four corners of this? Please read what is the adjudication under 47.
Please. Not application will not see at page number.
All
8.
questions arising between the. Please read it.
Not provisions notes.
Section 47.
Please. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Therefore, the application is.
If you have to read it, it starts with the questions arising between the parties. Next.
Between the parties to the
Next,
suit.
next. Where a question?
Yes. Where a question arises as to whether any person is or is not the representative of a party.
So, it all relates.
Such a question shall.
That is
Yes.
all with regard to the.
Yes.
The,
I am.
Between the parties.
I am an independent
also,
body, Milords. I am an independent body where, Milords, the property.
Want, I can issue notice, but I am not convinced with this application itself, which the court can decide, and you are entitled for an interim relief.
Lord, kindly see the finding, Lord, of the trial court.
But I will not grant any interim order. Notice to the respondents, petition is permitted to take out and summons and file a memo to the deputy.
Please.
If the memo is filed, list the matter.
Hearing on interlocutor
Whenever the
application.
memo is filed, list the matter. Once the memo is filed, list the matter.
Bill number 33, Kavita HC for
I appear
petitioner.
to the petitioner, my lord. This is a,
Voltage.
I have filed an IA for early hearing of the petition. my lord.
IA is filed, IA 1026 is filed for early hearing. List this matter on
A short date, my lord, because he's a decree holder, he's deprived of,
August, it is not
he is
possible.
deprived of the fruits of the decree,
Completely
2013 suit, my lord.
List this matter on 17th of August.
My lord,
Bill number
IA is
34.
ordered.
my lord, July, my lord, July.
July
At
is not
least.
possible because if you see the entire July, the date is given 70, 80 matters a day.
My lord, he has a decree of perpetual injunction is in his
We'll have
favor.
it, August
My
itself
lord.
is, August is early,
At least, my lord, mid-July, my lord. I
not
would request.
possible because I've already given dates for all the matters.
34,
Lord, I appear for
yes,
the
Nagraj.
petitioner.
Appearing for the respondent.
The notice may be dispensed, my lord, to in respect of respondent number 5
Second dispensation of notice,
for 5, 7, 9 and 10 and 11. They are
5,
all
7,
expert.
9, 10 and R11. Memo is taken on record and notice to so is dispensed.
And IA 1 for stay may be considered.
26 is filed for early hearing. Early hearing of what?
As a main matter because stay.
So we'll hear early
Stay.
hearing. Place this matter on
Allah, now a stay may be considered
Well,
well,
it's,
because
date may be
the
fixed.
ex parte decree obtained and already FDP is also obtained. That is why I'm suffering from the decree. And I filed a miscellaneous petition. That is also
if
dismissed.
the IA is coming up before the court, what IA you sought is for early hearing.
Early hearing, stay is also afraid. IA 1 for stay is also there.
If it is your stay, this matter wouldn't have come today.
Allah, that is why, my lord, I moved it for considering the stay.
The
It
court
is
also
moved.
understands why it
My
has come,
lord,
we will consider only that.
let them not to precipitate the decree, my lord. That is
You
why.
don't have either
Suit, it is a ex parte decree, miscellaneous filed. Miscellaneous appeal is dismissed on the ground that even on merits.
26 is filed seeking early hearing. This is matter on 3rd of August.
My lord, IA stay may be considered, my lord.
Then you withdraw this petition. It will come in the due course. Because you filed IA, it is before the court. And
No,
filing
I have early hearing, I am not
No, I'm
present.
not hearing. It has come up before the court only for.
No,
the
IA 1 per stay is also, it is
It is not,
posted.
it wouldn't have come. It has come only for this IA. Because which is the latest IA of 1 of 26.
No, because of IA 1 not posted, because that is why I have filed IA early hearing.
Your filed IA.
Main
number
matter,
1 of
it
20.
could be disposed
Here's
because,
the main matter.
it could be disposed
I
by.
will not hear it now.
My lord, otherwise I will be defeated. The decree is already passed and the FDP is also filed. FDP is ordered. That is why I am suffering from a decree, ex parte decree.
Discuss this matter on 3rd of August.
No, 3rd of August at least next month first week, because consider the seriousness of the case, my lord.
Matter in second list on 20th of July. Yes.
Cell number 35. 35, Manjula Kamajalli.
Notice to the respondents. Please.
Cell number 36. Cell number 36.
A decree was passed.
IA
For-
number 2 of 26 for early hearing.
Early hearing, if your lordship hears the matter, then it doesn't survive. And so for IA, the other IA is concerned, it is for stay, my lord.
Then why did you file this IA?
My lord, since the matter was not listed before the court, my lord, we have filed that IA. I don't press that IA. I don't press because.
No, if everybody starts filing the IAs and so the matters are coming, then that I can't, the court can't.
No, that
interfere.
is true, my lord,
Matter has
but,
to come, you have to
no.
mention it, not by filing IAs. For filing a early hearing means IA comes, we'll give a early hearing date. It is not that we will hear it on the same day.
Because in the earlier bench, my lord, in the earlier roster, my lord, if an IA for early hearing failed, then only the matter will be taken up, not otherwise. But after your lordship has come for his roster, then things have changed.
IA number, this CRP is filed when?
Filed by me only.
No, no, when was it filed, this, this
The
petition?
CRP was filed on 5th February 26. Notice was ordered immediately.
It has never come up.
My lord, thereafter it didn't come up before the court.
Is this matter? Notice is served.
Notice
On all the parties.
so far as the second respondent is concerned, we have served upon the learned counsel who represents the second respondent before the trial court. Execution
As per
petition is
that,
pending.
acknowledgement is filed. I have sent the copy on the council appearing for the respondent number 2.
Please, my lord, in the
Memo
trial
is
court.
taken on record and notice to R2 is held sufficient. Is this matter on 4th of August?
Cell number
At least
37.
they are going to change the kata, my lord. That is the urgency, my lord. In view of this.
Uniform application. Yes.
Next month.
Cell number 37. Girish Krishna.
Notice.
Cell number 38.
Notice.
Cell number 39.
Notice.
Serial number 38, notice may be dismissed, respondent number 326.
30?
38 serial number.
Notice to whom to be dispensed with?
Respondent number 326.
A memo is filed, second dispensation of notice to respondent number 326, dispensed with at the risk of appellant. Notice to other respondents.
I am permitted to hand summons, my lord, to the respondent number.
Permitted to, the petition is permitted to same hand summons.
Please.
On the so and so. I
Much
shall file a memo to that effect. Yes, 39.
Cell number 39.
Notice.
Cell number
By
31.
hand, my lordship. By hand, my bid showed to you.
Which one, 39?
39.
39 also hand summons. Yes,
The
40.
date might be fixed, my
40.
lordship,
K. Chandranath Ariga.
because it is for rejection of plaint I have filed.
Every matter is for that only, all CRPs. Yes,
Cell number 40.
For the petitioner.
yes. Notice to the respondent.
Please.
Don't take hand summons?
No, no,
notice
they
to the
don't
respondent.
accept.
Yes, yes.
41.
For the petitioner.
Shiva Prakasham.
Yes, notice.
And summons may be issued.
Hand summons is 42.
Cell number 42. Yes, delay of filing.
Yeah,
Notice.
my lordship, appearing for the petitioner, my most respectfully mentioning a matter of severe consequence that has happened in this weekend.
There is a delay in this, we will not hear anything.
My lordship, I have submitted IA3 application on condemnation of delay. The
Let the notice
petitioner,
go.
the
Let notice go in the.
on Saturday, there has been a warrant been executed, my lordship. I require your help, my lordship. So on Friday, I submitted a,
Help you. If you argue on the merits, I'll pass an order.
yes, my lordship. I have a few submission, my lordship, if you may give permission.
No, there is a delay. You are questioning what is the order impugned?
Delivery warrant, my lordship. There is an ex parte delivery warrant issued by the executing court. So we require your help in providing a stay, my lordship.
You that fell, what is this ex parte delivery warrant? Is execution pending or not?
Delivery warrant is executed, my lordship, but a grave thing has happened is that the signal boards have been broken. It has been vandalized, my lordship. The lock has been broken. Along with that, we suffered the damages where the signboard has been damaged, my lordship. We informed the court bailiff that today the matter is listed and we requested for a 48-hour stay to the court bailiff, my lordship. In turn, I informed even the decree holder as well to manage till 48 hours where the matter is posted, my lordship.
Come to the impugned order.
Impugned order.
I have filed a dispensation application, my lordship, as the matter was.
Order copy is also not there.
Yes, my lordship, on order copy I have this.
Order copy, so you don't even file a typed copy. Order copy is dispensed with, then looking at what the court will pass orders.
Yes, my lordship. I pray time to submit the copy of the executing court order, my lordship.
So now there is nothing before the court, only your submission.
Yes, my lordship. I have the order copy of the trial court where my main prayer is that an excessive 3,000 additional rent has been added by the trial court and they requested for an interim stay for the stay of the delivery warrant, my lordship. The delivery warrant is executed, my lordship. The lock has been broken, but they are.
Call for the records and modify the judgment and decree dated 11/2/2026 passed by the so and so to reduce the ongoing monthly occupational damages from 15,000 per month to the contractual rate 12,000 per month commencing from 1/1/2026.
The order copy is enclosed, my lordship, of the trial court.
Where is it?
It's in the page 42, my lordship. Yeah, page number 38, my lordship. If you see that the defendant is directed to pay arrears of rent of rupees 15,000 and damages of 15,000 per month, my lordship. But if you see the matter of fact, my lordship, I have been.
Before going into the merits of the matter, this judgment, this order is passed on 11th February 2026. And the court has directed you to deliver possession of the property within 2 months from the date of this order.
Yes, my lordship.
What are you doing till now?
I'm a amputee, my lordship, and I've been in a medical emergency where I have submitted my medical documents as
Have you
annex.
contested the suit or not?
Yes, my lordship, we have contested, my lordship.
Hmm.
And order has been passed where I'm supposed to pay from this start of the January 1st, 2026, a monthly arrear of 15,000, my lordship. So I'm ready to oblige by whatever the court says, my lordship. What I require, my lordship, is a prayer. I'm pleading, I beg, my lordship, is that stay on the further execution of the proceedings in the executing court, my lordship. So the lock has been broken and the bailiff has put the lock. So require your help and protection to to avoid further throwing of the material outside of the premises makeup studio, my lordship.
Why the parties have come to the court?
I have requested to come, my lordship.
Why?
To have a representation, my lordship.
They will represent.
No, my lordship. Actually, the father is not amputee; he cannot come. So I have a.
Okay, why should the parties come to the court? That I'm not able to understand. You are the one who is arguing.
Yes, my
Why
lordship.
the parties are in the court?
Yes, my lordship. I oblige, my lordship.
No, all the advocates should stop this practice. It doesn't make any difference to the court if the parties are in the court or not.
Yes, my
Whatever
lordship.
the order to be passed, that only will be passed.
Yes, my lordship.
And all the more if parties are in the court, it will be otherwise.
Yes, my lordship. Like, apologies for the.
No, it's a suit for any other suit for eviction.
Yes, my lordship.
And what is so special about it?
Yes, my lordship. On the Friday.
You have to make out grounds and you have not come to the court.
Yes, my lordship.
Within how many days you have to file the appeal? When was the order copy ready?
We had a 20 days minor delay, my lordship. As soon as I was given the application, I filed on 8th of this month, my lordship, immediately. So at the same day, the executing passed an order to have a break lock on the makeup studio that we have been running since 8 years, my lordship. I immediately filed the file.
What is this premises? Premises is used for what purpose?
It is for makeup. It's a salon, my lordship.
Huh?
It's a beauty salon. Even though the caveat is expired, we served a copy to the caveator also, my lordship.
Who is the caveator?
So,
What is the name of the advocate?
Markham Advocates, Nagraj sir. Markham Advocates, my lordship.
Write the name. Print the name of so and so. This is matter tomorrow.
Yes, my lordship.
Yes.
Cell number 43. Study
And don't bring the
Yes, my
slides to
lordship.
the court.
Much obliged, my lordship.
Yes.
Study Joshi for petitioner.
For the petitioner in this case, my lord, the matter was dismissed for non-prosecution on the ground of non-compliance of office objections. my
When
lord.
was it?
Yes, my lord.
When was this?
On 4/11/2025.
Then you comply with the office objections now.
Yes, we will comply, my lord. I am a NOC brief, my lord. I will comply with.
The pending consideration of IA number 1/25, petition is permitted to comply with the office objections. Once the office objections are complied, list the matter.
My name kindly be shown in the cause list, my lord. I'll write.
Print the name of,
Gopal Krishna Kurundwad. Right.
print the name of, delete the name of. for the petitioner, it is submitted that he has filed an notice of color. Yes.
Cell number 44. KV Narasimhan for petitioner.
Yes.
May I, ma'am? Lord, respond number 8 to 10 before the FDP court or before my lords as petitioners. Lord,
Respondent numbers?
8 to 10 before the FDP court, final decree
You are
proceedings.
the judgment debtor.
Lord, in fact, I'm the subsequent purchaser. I'm the judgment debtor. Madam. I'm claiming through judgment debtor. Lord, initially, my lord, respond number 1 to 3 herein filed a suit for partition against defendant number 1 to 3. My lord. Respond number 1 to 3, my lord, are the sons of defendant number 2. Lord, said suit came to be decreed and in my lord, annexure A may be
Date?
on 2nd November 2002.
Hmm.
Said suit came to be decreed, my lord, and an order came to be passed at page 21.
By that time, you were a party?
I was not a party. My lord, what happened, my lord? Defendant number 2, that is father of plaintiffs, sold the property to defendant number 1, and defendant number 1 sold the property in favor of defendant number 3 before the execution, before the filing of the suit. So the suit was,
Number 3.
I claim to defendant number 3.
You are not arrayed as a defendant.
I'm not arrayed as a party. During the pendency of the suit, my lord, I purchased.
When was your sale deed?
My lord, my sale deed was in the year 1997, subsequent to institution of the suit.
Suit is of the year?
1997. My lord, the trial court comes to a prima facie observation, my lord, that defendant number 2, after executing the sale deed in favor of defendant number 1 and 3, has purposefully included only one property in the plaint. So if at all subsequently defendant number 1 and 3 comes to conclusion or comes to any findings that there are other properties which are in favor of the joint family property of defendant number 2, they have that liberty to file, to add those property in the final decree proceedings. My lords may take page 21 for a moment.
No appeal is filed against her.
No appeal is filed. Page 21. Page 21. My lord, order portion, my lord, last paragraph. My lord, the plaintiff suit is partly decreed. Plaintiffs 1 to 3 are entitled for 1/3 share each in the suit schedule property. There shall be partition and separate possession of the plaintiff's share in the suit schedule property. During partition, if it is found that the family of plaintiffs and second defendant owns other immovable property as on this date, as far as possible, the suit schedule property shall be allotted to the share of second defendant, and the share of the plaintiff shall be adjusted in other immovable property of the joint family. So, my lord, a liberty was given, whereas if at all there are findings that there are other joint family properties, the judgment debtor before the FDP court can include them. So this suit schedule property, which is already alienated in favor of defendant number 1 and 3, will be allotted to the share of defendant number 2, and other properties which are joint family properties will be allotted to the share of plaintiff. So there will be equity to everyone. Now, this being the case, FDP proceedings came to be initiated. Now, in the FDP proceedings, I file an application, that is respond number 8 to 10. I file an application stating that there are 5 other joint family properties which are standing in the name of defendant number 2. That is the father of plaintiffs number 1 to 3.
How are you acquainted with all this?
Well, I acquired the property through defendant number 3.
No, to say that these are the other properties available for partition.
Well, I get the RTC records and a compromise decree which was entered between the family members where they have stated that this belongs to my branch. So based on the RTC records, my lord, it was standing in the name of
in a way you are seeking partition.
I'm not seeking partition. My lord, all I'm stating is, my lord, because
all the parties, if the defendant, the other family members feel that there are other properties, that would be for them to file an application.
Please, my lord, what happens, my lord, generally?
This is the application filed by you.
Please, my lord, my lord, why?
The order will see.
My lord, may I submit, my lord?
After reading the order, you can submit. Come
Please.
to the order.
My lord, there are 2 more facts, my lord, which I want to tell.
No, I will hear you.
My lord, the sequence of events, my lord, I have that application which I filed to include 5 other properties that came to be dismissed. I approached this honorable court. This honorable court directs the trial court to conduct an inquiry whether as to those 5 properties are joint family properties or not, and then you take a decision as to whether to include them or not, my lord. Then, my lord, the FDP court fails to include those 5 properties even after coming to conclusion, my lord. That is the impugned order herein. Please. Lord, impugned order is at page 71.
Order of this court, where is that?
Please, my lord. Writ petition, my lord. It's at the page 45 at annexure F. The operative portion is at page 51. The impugned order dated 5/4/2023 passed on IA number 8 in FDP stand disposed of by directing the trial court to consider all the rival contentions between the parties in FDP, including rival contentions as regards the properties which are the subject matter of IA number 8, and by conducting necessary inquiry in this regard and by
I've seen that.
Please,
Come to the present order.
impugned order. My
Where is it?
lord, impugned order is at annexure J at page 71. My lord.
Yes.
My lord, the reasoning basically given by the impugned order is these properties, my lord, came to defendant number 2 through his mother, who got it by way of a compromise decree. So once a property is given to mother, my lord, the property inherited by a person through a woman attains self-acquired nature of self-acquired property. So defendant number 2 property during his lifetime cannot be claimed by plaintiff, that is the sons of defendant number 2. So this property cannot be given to the
But here the plaintiff has not claimed at all.
please, my lord, what happened? Why, my lord, why this application was filed? My lord, what happens generally, my lord? Father alienates the property.
No, when you filed an IA to saying that these are all the joint family
Please.
properties, what was the objection that were filed? You have the.
Please, objection, I have it, my lord. Objection, please, my lord.
What did the decree holder?
Statement of objection is at page 35. My lord, they take up a contention that these properties came to defendant number 2 through her mother, that is Gurama. So during the lifetime of defendant number 2, we don't have any share. So you don't claim any property in this, my lord. There's only one page objections, my lord, at page 35. 2 paragraphs may be looked into.
But this you're referring to the earlier one or the present one?
To the objections filed to my application, my lord.
Not this application.
Which
No,
application?
There was an order. That time only they have filed this.
My lord, my
Oh.
second time there was no application, my lord. It was remanded back and the matter was considered based on the old page 35, my lord. My lord, para 4 may be looked at.
Let's go to the decree. Where is the judgment and decree?
Judgment and decree, my lord, page 21. My lord.
And look at the, let us go to that
Schedule.
cost item. Come to that. Oh, yeah, the suit cost item at page 50.
Please, my lord.
What is the relationship of parties?
My lord, plaintiff number 1 to 3 are the children of one Venkatesh, that is defendant number 2. Lord, defendant number 1, my lord, is the purchaser of the property. That is one. There was
How many are the suit schedule properties?
only one property in the plane. So this defendant number 1, my lord, originally purchases the suit property in the year 1996 from defendant number 2. Then, my lord, this came to be sold in favor of defendant number 3 in the year 97. Subsequently, this suit came to be filed, including only one property.
Not subsequently. After filing the suit, you purchase.
No, my lord. Defendant, after selling it to defendant number 3, suit came to be filed. After the suit, I purchased it. Lord, trial court makes an observation that this might be a collusive suit because the father has father has asked the plaintiff, that is his sons, to initiate a suit only with.
According to you, this D2, who is the father of the plaintiffs, have some other properties
Please,
apart
ma'am.
from the suit schedule
Please, ma'am.
property.
Please,
And that has to be, now in the final
Please.
degree proceedings, that
Please.
has to be allotted.
My lord, what happens, my lord, if at all?
Now, let us go to your application.
Please, my lord. Lord, my application is at page 31. Page 31, my lord, in the schedule, I ask for 5 other properties to be included in the plain schedule property.
Where is that?
My lord, page 31, annexure C.
Yes, come to the order now.
Please. My lord, may I submit, my lord, why this attains significance? My lord, if it is a collusive suit between defendant number 2 and plaintiffs, my lord, if at all I am able to prove to the court that there are other joint family properties, these joint family properties can be allotted to plaintiffs at any time. Only with respect to that portion, my lord, which has been executed in my favor, which has been sold before the institution of the suit by defendant number 2, that portion, my lord, will be allotted to defendant number 2. And my lord, defendant number 2 has already executed a sale deed, so it attains equity to all the parties. So that is the reason, my lord, why these properties have to be included. My lord, Annexure J is the impugned order.
There are the photographs, that's the only property.
Please, my lord, there's only one property which was sold in my.
105.
Please, my lord.
At 105, there are photographs.
Please, my lord. These are the photographs, my lord, to show that after I purchased.
4 photograph and 5 photograph is not one and the same. 104 appears to be a different house. 105 different house.
My lord,
There is 106 also.
8 to 10, my lord, defendant number 8 to 10. There are 3 respondents before the trial court. So we have constructed houses in the property. So that is the photographs, my lord. In fact, I have stated in the ground D of my.
The pendency of the suit, you have constructed the houses in the suit schedule.
During pendency of the suit, I purchase. Subsequently, I make construction, and these are the photographs at annexure P, Q, and R.
Come to the
Please. My lord, order is at annexure J, page 71.
Yes.
May I take to reasoning, my lord, directly?
Yes.
Lord, reasoning starts at page, last 2 paragraphs will be looked into, my lord. Para 26 at page 92.
Yes.
May I read, my lord?
Page 93, I think.
Para 26 at page 92.
The learned counsel for the respondent argued.
Further, the learned counsel for the respondent number 8 to 10 argued that the plaintiff's petitioners have claimed that their father Venkatesh, that is defendant number 2, had only inherited the suit schedule property from his father, and other properties which shown in IA number 8 are inherited by Venkatesh, who is the second respondent herein, from his mother Guramma. But as per the admission given by the petitioner, the mother of Venkatesh, that is Guramma, had never claimed any right over the properties which mentioned in IA number 8, as she died in the year 1977. And these properties were allotted to joint family headed by B. Narayanappa, who is the father of Venkatesh, only in the year 1982, when OS 331 of 1991 was compromised. Therefore, the properties proposed to be included in IA number 8 are the properties inherited by Venkatesh from his father, just like the suit property, and hence all the properties which are inherited from his father B. Narayanappa will be divisible properties. 27. Admittedly, mother of Guramma died in the year 1977. After her death, her father's brothers, children had filed partition suit against Venkatesh, who is second respondent herein and father of second defendant. It is pertaining to note that though the second respondent and his father have acquired the properties through compromise decree in OS 331 of 1991, the said properties are not the ancestral properties of second respondent Venkateshappa. The said properties were allotted to the share of second defendant and his father jointly, who represents the branch of Guramma, who is the mother of second defendant. From the aforesaid documents produced by the respondents, it is clear that second defendant acquired item number 2 to 5 from his mother Guramma, who got share in her father's property. Therefore, said properties are absolute properties of second respondent. Hence, the petitioners have no right to claim their share during the lifetime of second respondent. Therefore, the contention of respondent number 8 to 10 is not sustainable. When item number 1 to 5 of the properties which shown in the item IA number 8 are not divisible between petitioners and second respondent, the question of adjusting the property of petitioners by allotting the proposed properties towards the share of petitioners does not arise. Therefore, in view of the above discussion, it is held that properties shown in IA number 8 are not the ancestral and joint family properties of petitioners and respondent number 2, and as such, they are not available for partition between the petitioners and respondent number 2. Hence, it is held that respondent number 8 to 10 have failed to prove that properties which are mentioned in IA number 8 to 10 are ancestral and joint family properties.
Properties belong to
Guramma, my lord. My lord, after the death of Guramma, there came to be a partition suit filed. That may persuade my lords to take the exhibit, my lord. Trial court records have been called into. Exhibit This is a compromise decree, my lord, which came to be entered. Lords may take exhibit P37 for a moment. R37.
Lower court record. It's not there.
A suit, my lord, came to be,
This record is not there.
in fact, in the
Call for.
record.
Not there. No, I think it is not ordered. When was it ordered?
I may be
This
mistaken.
Order copy doesn't show.
I may be mistaken.
No, it is not called for. Then you can submit.
Please, my lord, there came to be a partition suit in the maternal side of Gurama, my lord. In that, my lord, Gurama expired. Gurama was represented by the defendant number 2 herein and Gurama's father. Lord, there a compromise came to be entered wherein these 1 to 5 properties, my lord, which I want to include, came to be given to the share of defendant number 2 and Gurama's father. There, my lord, a specific government came to be made in the compromise decree, my lord, that these properties will be taken by Gurama's father and defendant number 2 herein, representing their particular branches. So, my lord, when the entire property came to defendant number 2 as a joint family property,
Gurama's father means that is the maternal grandfather of second defendant.
maternal grandfather of the plaintiff's, my lord. Second defendant's wife is Gurama. Please, second defendant's wife is Gurama. And Gurama's father was also made as a party because of expiry of Gurama, my lord. There, my lord, a contention came to be, an averment came to be made in the compromise decree.
Gurama is the mother of Venkatesh, not wife. Sorry.
Gurama is the mother of Venkatesh. I stand correct.
Second defendant.
Please, ma'am.
So why was Gurama's father is, that's what I said, is a maternal grandfather.
Maternal property, ma'am.
Maternal grandfather of second defendant.
Please, ma'am.
It's self-acquired property.
It was self-acquired property, but now that Gurama has expired and this defendant number 2 was brought on record, my lord, defendant number 2 in the compromise decree, my lord, is finding that these properties will be inherited by defendant number 2 as a
Filed by whom?
suit was filed by
Children of Venkatesh.
children of one Dodda Ankanappa, my lord. That is Gurama's, the interstate dispute between the maternal family.
Present suit filed by children of Venkatesh. Because it is an ancestral property. He did
Earlier suit.
earlier suit,
Maternal
my lord,
dispute.
the other branches of that family, that is Dodda Ankanappa's family, therein there was a compromise. Gurama was no more. She was represented.
No, that who is the plaintiff in that suit?
Plaintiff is one
And partition in the family of Gurama's maternal family.
children of Dodda Ankanappa. My lord, Ankanappa and Dodda Ankanappa are the brothers.
Of the pleading.
Gurama's father Ankanappa. Then Dodda Ankanappa is the Doddappa of uncle of Ankanappa. Children of Dodda Ankanappa had filed suit against Ankanappa.
Yes. Yes.
In that property, my lord, the present,
Some property fell to the share of the mother.
the
of-
same properties, the same item number 1 to 5, which I want to include, my lord,
Those property fell to her share.
fell to, not her share, fell to the share of defendant number 2, because she was no more, my lord, defendant number 2 was representing.
He is the surviving heir of that.
Please, my lord, and representing, and in the compromise decree, my lord, a specific government came to be made. The plaintiffs and defendant number 1 have entered into this compromise as managers of their respective branches, and this compromise is for the benefit of the respective branches. So, my lord, defendant number 2, my lord, took these item number 1 to 5 properties representing his entire branch. So, defendant number 1, my lord, is followed defendant number 2. Sons are plaintiffs number 1 to 3. So, they took those entire 5 suit scheduled properties as joint family properties. My lord, now, my lord, in the equity basis, my lord, may I submit this? My lord, what will happen if these 5 properties are included? My lord, plaintiffs will get additional share in 5 suit scheduled properties. Whereas I, my lord, will get only 1 property, that is suit scheduled property, which is mere 10 guntas, which was already executed, which was where defendant number 2, where my lord was already executed sale deed.
The issue is whether it can be considered as joint family property or it becomes a self-acquired property is the only question.
Please, my lord, to answer that question, my lord, defendant number 2 should have examined himself before the FDP court, should have filed his evidence, should have led evidence. Now, defendant number 2, in fact, abstains from leading any evidence. He does not produce any documents. Not when it is in his knowledge. Section 114 of the Evidence Act kicks in, my lord, where something is in his personal knowledge, if he does not enter into witness box, adverse inference may be drawn against him. My lord. Now, my lord, what is the prejudice caused to the plaintiffs? I may ask this question to myself. If these 5 properties are included, plaintiffs, my lord, apart from the 1/3 share, 1/4 share in the 10 guntas of land, will get this entire 5 suit schedule property to their share. Only that property, my lord, which was sold by defendant number 2 before the institution of the suit will be allotted to defendant number 2. And through defendant number 2, I'll get only mere 10 guntas, my lord. What is the prejudice caused to plaintiffs? And my lord, adverse inference has to be drawn.
You put it very simply, but it's not so simple.
My lord, may I submit this? My lord, defendant number 2, even if he claims through mother, my lord, in the compromise decree, I have taken a specific contention that he has taken this entire property to his particular branch. So this is entire branch, including the plaintiffs, all these 5 properties will be joint family properties. To refute this, to rebut this, my lord, the only person who could have rebutted this is defendant number 2, who participated in the OS.
You have relied upon that compromise decree.
Both parties have relied on the compromise decree. And defendant number 2 does not enter into the witness box. So when something is in his personal knowledge, if he does not enter into witness box.
Anyhow, what is in his personal knowledge? The judgment and decree will speak.
My lords may look.
Speak anything. You're also
Please.
relying on the compromise decree.
Please.
That can be looked into what it speaks.
My lord, the judgment and decree, my lord, what the trial court has done, not considered that portion of the compromise decree where it has clearly stated that this properties will be allotted to defendants and he will be representing his entire branch. So these properties will be going to the entire branch. And my lord,
What do you mean by entire branch?
entire branch of defendant number 2, including the plaintiffs.
They were there. They were the parties to that.
They were not parties, my lord. This is suit of 1991.
So where is the question of that branch will come? Now, he is the only son to the deceased mother. He was the only son.
He was the only son.
As on that day, then what is the age of these
Please.
children? They were not even born on the day.
They were, my lord. 64 is the age as of now. So 1991 they were born. So if he's taking through his entire branch, so these petitioners were alive.
What's on that?
Please.
No, even if you take it that way, the partition was done long back. Then if they're all entitled.
My lord, partition was done and the share was allotted to defendant number 2. Between defendant number 2 and plaintiff, there's no partition. Now, my lord, what happens, my lord? May I say only one point, my lord? Defendant number 2 executes a sale deed. The sons of defendant number 2 plaintiffs come and make only one property which was already sold, leaving out these 5 properties. So this is a classic case of collusion, my lord. Not 37 is the plaint, 37 is the plaint, and 39 is the compromise decree.
Yes, Mr. Senior Counsel.
My lord, against the judgment and decree, in OS 1497, no appeal has been preferred.
Shall we look at this judgment and decree, what it says?
Pardon me?
The earlier judgment and decree.
Yes.
In favor of the defendant number 2. Can we look at it, what it says? You have the copy of it?
No, I don't have that copy. You have the compromise decree. Compromise decree, my lord?
Compromise decree.
Compromise
Yes, yes, my lord, I've got.
Para 5.
Where is it?
My lord, 39 may be looked into.
The plaintiffs defendant 1 have entered into this compromise as managers of their respective branches. And this compromise is for the benefit of the respective branches. That is respective branches in the sense, my lord, Doddankanappa and Chikkankanappa, not it refers to my children. It is that family. So just because these words is there, it doesn't mean, my lord, it binds my children. And it is presumed to be allotted to my children.
What page number?
Lord,
39, but 39 is
R13,
all
R39.
extracts.
Lord,
Oh,
R39. Apologies, my lord.
That
There's
it
no
binds
page
Ankanappa and Doddankanappa's branch. That's all.
No, that's why I just want to look at what is,
Yes, madam.
how it is.
The
worded.
plaintiffs and defendant 1 have entered into this compromise as managers of their respective branches. Here, madam, the branches refer to Doddankanappa and Chikkankanappa. The mother of the second defendant, here is the second defendant, represent the branch of Chikkankanappa.
The plaintiffs and defendant number one have entered into this compromise as managers of their respective branch. Plaintiff and defendant number one.
Yes.
You get the
Therefore,
clarity?
in that suit, my lord, they represent the branch. There are two branches, Dodankanapa, Chikankanapa. Defendant represent Chikankanapa.
Pursue plaintiffs.
Yes,
and
ma'am.
defendant number one.
Yes.
Have entered into the compromise as managers of their respective branch, and this compromise is for the benefit of the
Respective branches.
respective is, you have to read it, who respective are plaintiffs and defendant number one.
Please, but defendant number one is no one but husband of Gurama. So entire chain will come into place, my lord. Defendant number one is Narayanappa therein, my lord. Narayanappa therein is the father of defendant number two. So entire branch, my lord, will be entitled for the share in item number 1 to 5.
That is respect. The word branches has to be referred to the parties in that suit, my lord. Here, my lord, Dodankanappa's children, grandchildren.
According to you, who is defendant number one?
Yes, defendant number one, my lord, he represent because Chikankanappa was no more. He had only one daughter by
Defendant number one. That is defendant number two's father.
Please, madam.
Narayanappa.
Please.
No.
Yes.
Narayanappa is.
So let us look at
No,
the
no.
decree, it will be clear who are them in the.
Narayanappa, my lord,
cross-site is
one minute, my lord. Ankanappa had got only one daughter by name Gurama.
No. Defendant number one is Narayanappa.
Narayanappa is the father of father of Venkatesh.
One minute. I will explain, my lord. My lord, Narayanappa, my lord, is the husband of Gurama. Ankanappa had only one daughter by name Gurama. Except Gurama, he did not have any other children. That Gurama was married to Narayanappa. By the time the suit was filed, Gurama was no more. Therefore, her husband was made as defendant number one. Therefore, the word respect to Miller, it refers to that branches in that family. That is Gurama's family. She was no more. As on the date of filing the very suit of in the year
No.
91.
The properties are allotted to the Venkatesh father. So according to you, like, is it a self-acquired property?
It becomes self-acquired.
Then that has to be partition among the other families.
No.
He is no
No.
more.
Who? My lord,
Narayanappa is no more.
it doesn't fall under section 6. Neither under 1 minute. It doesn't fall under 6. He can, Venkatesh, if he wants, he can sell all this property. I cannot hold over that property as a children. I don't have any control.
No, it is
My lord,
it is not allotted to Venkatesh alone.
Assuming, my lord, it is allotted to Narayanappa. That is father of Narayanappa and Venkatesh.
Grandfather of the plaintiffs.
Maternal great grandfather, not paternal. Maternal great grandfather.
So in this partition.
Because Narayanappa got this property because of being a husband of Gurama. Not. So therefore it is self-acquired property.
Yes.
So therefore, I am entitled for only 1/3. 1/3, of course, my father has also got 1/3 share. Remaining extent, they can proceed against Venkatesh, against 1 to 8 items.
But what is the finding of the court now? Court has dismissed in respect of all properties.
No. My lord, insofar as the equitable share is concerned, whatever the property, 1/3 share of Venkatesh, he is entitled.
No. Suit is decreed. That is a different
Decreed.
aspect. Now, he wants to add this 1 to 5, whatever the properties is mentioning.
Those property, therefore, those properties are not neither the joint family property nor the ancestral property. It has come to my father through the great grand paternal side. Maternal side.
What happened to the properties of Narayanappa which were fell to his share in the partition?
Still within Venkatesh.
It is with Venkatesh. That is my father. He can proceed against the property. Whatever the properties he wants to include and asking for the share, let him independently proceed against the property. I have no objection. So the suit property in the present suit is concerned,
But
my share.
That is what is the order of the.
No, therefore, if there is any family property, Rashma kindly see, my lord, the findings the operative portion,
There is no clarity in this. 1, 2. 2 is earlier it was a mother of Venkatesh. No, wife of, correct, mother of Venkatesh was the original defendant. After her death,
one minute. In earlier suit, that is in OS number 331 of 1991, that is the suit filed by the grandchildren of Doddankanappa. It should have been against Ankanappa. Ankanappa was no more. Then Ankanappa had got only one daughter by Gurramma. Gurramma was also no more. Gurramma was represented by her husband Narayanappa. Narayanappa happens to be my grandfather. And Venkatesh is my father. I am representing the children. So this property, to whatever the items he wants to include in the FDP, it is not the property which has come to my share or to my family through, it is not a joint family property.
Narayanappa was not allotted anything.
He is not allotted.
No share was allotted.
He was,
to Narayanappa.
he was a party to compromise.
He is allotted, assuming it is
So
allotted.
certain share is allotted to Narayanappa.
Yes, ma'am.
Who is the grandfather of the
It becomes a property of section 8 of the Hindu Succession
No,
Act.
correct. I'm saying one property, part of the property is allotted to Narayanappa and also to Venkatesh.
Yes, madam. So it becomes a self-acquired property of section 8. I cannot have any control over that property as either as a grandchildren of Narayanappa or as children of Venkatesh. I cannot have control over that property. So therefore,
These issues discussed by the court in the impugned order?
pardon me?
Was all these issues?
Yes, it is
discussed
discussed.
by the
Lordship,
court?
can you
Where
see?
is it?
Lordship, kindly come to page 88. Page 88, paragraph 21. Further, Exhibit P1 compromise decree in OS number 331 of 1981 reveals that item 2 to 5 of the application schedule properties were allotted to the share of second defendant and his father jointly, who represent the branch of Gurramma, who is the mother of second defendant. The learned counsel for the petition argued that Gurramma died on 23/1/1977. Thereafter, Sri Muniappa Ankanappa, who is the father of Gurramma, and Muni Yankappa Muni Mariappa had filed a suit for partition separate possession in respect of properties, was shown in item number 8. Further argued that as per the compromise decree item number 2 to 5, that his property shown in item number 8 have been allotted to the share of husband and son of Gurramma and second respondent hearing jointly.
Give a copy of this.
I shall.
Yes.
Jointly. To deny the evidence at PW1, the learned counsel for the response 8 to 10 has cross-examined PW1. During the cross-examination, PW1 has admitted that serial number 125/2, serial 128/3 measuring 10.5 guntas and serial number 163/2 are belongs to her father. Further, she voluntarily deposed that the said properties are came to her father from his mother. In this regard, cross-examination PW1 is reproduced as hereunder. Sir, it is in Kannada minute, same it is the extract. From the evidence of PW1, it appears that nothing has been elicited from mouth of PW1 that the application schedule properties are the joint family properties of petitioners and respondent number 2. The learned counsel for the respondent 8 to 10 has argued that second defendant sold social property in favor of first respondent Sri Ramappa under a registered sale deed dated 15/1/1996, and the first defendant Sri Ramappa had sold the social property in favor of third defendant Krishnappa. Krishnappa is now before Lordship Millard under a registered sale deed dated 27/2/1997. After the second sale transaction, second defendant connived with plaintiffs who are claiming to be the son of second defendant and brought the suit by including only the suit property, which was already alienated twice. During the pendency of the suit, the social property was sold by third defendant to various persons under several sale deeds. However, with an intention to defraud the bona fide subsequent purchaser, the plaintiffs did not implead the purchaser as parties to the original suit, though they were necessary parties to the suit. The respondents 8 to 10 are subsequent purchasers of the social property under various sale deeds executed in the year 1997 and 1999. These respondents are impleaded as respondents only in the present final decree proceedings. The conduct of the plaintiffs and second defendant has always been detrimental to the interest of the bona fide purchaser. Further argued that properties which shown in IN number 8 are the joint family properties of second defendant and the plaintiffs. The said properties were acquired by father of second defendant by name B. Narayanappa under a compromise decree in OS number 331 of 1991, as he was the manager of the joint family consisting of himself and his son Venkatesh. The said suit was filed by family members of Chikka Ankanappa, who is the father of Gurrama.
I've seen that order. You can make.
So therefore, my lord, the findings, my lord, it doesn't, neither an ancestral property nor a joint family property. Insofar as the children of Venkatesh is concerned, all the plaintiff invoice number 49 is concerned.
And they cannot seek partition during his lifetime.
They can't. So therefore, madam, in equitable partition, madam, 1/3 share which is allotted, which is in which Venkatesh is entitled. Yes, they are entitled in equitable share. In respect of any damages, he can proceed against the present property, that is IN.
The entire suit scheduled property, the buildings have come up.
Pardon?
Purchased.
The purchasers, they raised structures in all the three, in all the.
No,
in the
only
entire extent.
only some of the area they have purchased, not entire 10 or wood. They have not
What is the total extent?
10 guntas.
10.5 guntas.
10.5 guntas. They have purchased, I think, a site.
Site.
That's all. Not entire 10.5 guntas they have not purchased.
Three houses have come up in now.
Only some 3 portions, houses are there. The rest of the lands are vacant.
What is the share allotted to this?
1/3 share, madam.
Venkatesh?
Then it has to be 1/3 each.
Then how much will come to him?
Let's say
I think 3.5 guntas, 3.5
It will
guntas
come
will
up
come
to
to the share of.
1/5. It will come up to 1/5, my lord. The reason is 3 sons filed a suit. Subsequently, daughter also came to be impleaded in FDP.
Four
So
and the
4
father.
plus father, 1/5, my lord. There will be nothing left to Venkatesh. Entire property has been.
How much?
Please,
Out
my
of
lord.
the 10 guntas?
2 guntas, my lord. My lord, in fact,
Then-
my instruction.
Your purchase?
My instructions are I purchased the entire extent. That is the reason why trial court gave the liberty to file
What happened to other two?
other 2.
Oh, there are 3 buildings, you said. 3 different people have purchased this property.
8 to 10 is what I meant. My lord. I represent all 3 of them. Respond number 8 to 10.
And the construction during the pendency of the suit, taking risk,
Lord-
knowing that the matter is pending, and such a person should not be protected by this honorable court. Madam.
My lord, may I submit for 2 minutes?
Copy of.
Please, may I submit only for 2 minutes? Lord, section 54, my lord, lispendence sale is not per se invalid, subject to result of the suit, which my lords also knows. Lord, what is the grievance of plaintiff, my lord, now to accept these these additional properties? If at all my lords allows this petition, they'll be entitled for larger extent of land in the entire five scheduled properties. I'll be allotted in only with respect to these 10 guntas of land. Lord, this makes it evident, my lord, this is a classic case of collusive suit. Father sells the property, instigates the sons to file a suit, and includes only one property which is sold in my favor, leaves out all the 5 additional properties. If at all, my lords includes these properties, I'll not be having any share over those properties because I'm not a family member. Plaintiffs will get 1/5 share in all the properties. I'll be only entitled to with these properties. And my lord, my last submission, my lord, defendant number 2, who was alive at the institution of this suit, was the only person who contested the old suit 1991. If at all it was his, he is there, my lord. Now he is also is there. If at all it was his contention that those properties came through my mother and no one else is entitled, he, my lord, should have entered into witness box, given his evidence. Nothing has been done. So, my lord, in these circumstances, the Honorable Apex Court has held that, my lord, adverse influence has to be drawn against them. There's only one judgment, my lord, I will not trouble. My lords may peruse that.
The presence and the evidence of the father is not required. Law is very clear. My lord, law is very clear. Whether, my lord, these properties can be considered as an ancestral property or.
Which paragraph you're relying on?
My lord, page paragraph 50 to 58.
I'll consider.
Lord, why is the plaintiff shying away from accepting additional properties to their share? This itself shows their conduct.
He could have taken summons, my lord. Even he is also not in good terms with me.
In fact, my lord,
he could have taken summons to Venkatesh, if at all he wanted to examine him, because he is also not in good terms with me. He keeps on selling all these properties. Where should the children go, my lord?
Lord, if at all, it's my condition of my learned senior friend that I can proceed against Venkatesh. So it presumes that there are other joint family properties. The original suit, my lord, which was filed for partial partition, is anyways not maintainable. So it was their case before the original court that this was the only property which was the joint family properties. So it is a collusive suit, my lord. Now, defendant number 2 cannot take advantage of his own wrong. He does not enter into witness box. Now his sons are getting share in all those 5 properties as well as this property. I will be left with nothing. Section 54, my lord, clearly states, my lord, is not 52. Lispendence sale is not per se invalid. It will be subject to result of the case. And I have got the liberty of the trial court to include additional family properties if at all I come to conclusion. All these properties are standing in the name of defendant number 2. Please, ma'am. Grateful.
Number 45.
Give it to the court officer.
Please, I shall do. Grateful. Well, may I submit
Take
a
that copy.
short synopsis and family tree for my lord's perusal, please. Grateful.
45, Chandra Chudia for petitioner.
As for the respondent in this.
Yes.
Application was filed for res
All these
judicata.
order sheets are like more than the file. Yes.
The application was filed,
What is the suit for?
suit for declaration.
Injunction and
Injunction. Earlier suit, a declaration suit was filed by the son, Your Honor. Same scheduled property, claiming that his grandfather had rights in that particular property, and the grandfather had, so we are the purchasers of the property. In the year 1958, during the lifetime of the grandfather of the earlier plaintiff, Your Honor. Earlier plaintiff suit is dismissed, appeal is filed before this honorable court, dismissed. Now, the son, after the son's suit and the appeal is dismissed, now later on, father has come that my son did not have an independent right. It is my father's property. So the defendants have to be restrained from this particular property. Injunction suit,
Original suit is for declaration.
declaration, and injunction issue was, and consequential injunction. There was an issue with respect to injunction also. Yes, my lord.
That suit is dismissed.
Yes, ma'am.
Appeal is also confirmed.
Yes, miss. Confirm. Appeal is
What
confirmed.
is the present suit?
Now filed by the father.
Earlier is for by the son.
Yes, yes. The same parties. And in that,
How he claimed, father is also a party to that.
father was not a party in the previous suit.
What is his case? How he has acquired title to the property?
His father,
Through his father.
through his father. There, the grandson had come stating that my grandfather could not have sold the property, and he files a declaration suit. He does not file a partition suit. He files a declaration suit to declare the sale deed executed in favor of the defendants therein as null and void, and a consequential injunction restraining us, being the purchasers in possession of the property, from interfering with the peaceful possession and enjoyment. The court frames issues on all these particular. An injunction issue is also framed. An injunction issue is also answered in negative in favor of the plaintiff therein, which the Honorable High Court also affirms, my lord. Then later on, after the suit is almost maybe 3-4 years later to the suit being disposed of, even before the Honorable High Court, now the father has come out with, my son did not have a right to question the transaction done by my father. So it is me who was still alive. I should have questioned that, and now an injunction suit is filed. I file an application after filing written statement under section 10, stating that it is squarely a res judicata because the question are same. The person who here, the present plaintiff is claiming under the same person, the title in which suit it was read. For your lordship's assistance, I would like to just read out. Your lordship have read many a times, but still for my satisfaction and the veterans of my.
File order 7 rule 11.
I did not file 7 rule 11, my lord. I just filed res judicata section 11.
Application under section 11.
11.
That is decided by the court now.
The court has rejected my application.
Because the parties are not one and the
Yes. May I read out for the assistance of the close this one on the explanation in
Yes.
section 11, my lord, res judicata. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties, or I will pause here and emphasize, or between the parties under whom they or any of them litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by.
Father is not claiming through son.
Father is claiming through his father. Son had also claimed through his grandfather. That's the only issue which I would like to place it and read.
For example, if father files a suit, that suit is dismissed or like.
Son had
No,
filed.
I'm saying
Yes,
like in
ma'am.
the earlier litigation.
Yes.
son files a suit. Father files a suit, dismissed. Son files a second suit, claiming title to the property from the father, and he files a suit. Then what you are submitting is right.
Yes. But my question, my lord, I would like to pose a question to the issues in the present suit, whether it is injunction, whether it is declaration, both were tried by way of framing issues. Answered. Wouldn't it be a waste of the precious time of this honorable court with these types
But
of?
at the same time, we can't brush it aside like that.
May I read for your lordships furthermore? In the plaint in the present suit, prayer B is to declare the judgment and decree passed in so and so, in OS number so and so, before the honorable court as null and void. If it was null and void, yet I would have not stood here, not binding on the plaintiff. Null and void is different, not binding is different.
The court was right. Please, let's read the findings.
Because null and void means I was not a party in that suit.
Whatever it is, but at this stage, the manner in which the suit is filed and how the prayer is framed, you cannot say that it is a judicata. Let's read it.
Yes, my lord.
Read the reasons given by the court.
My lord, I will not trouble your lordship and waste much time, my lord.
Yes.
I will just directly go. Reasonings of the honorable court, page number 20 of the paper book, my lord.
Yes.
Having heard and upon perusal of the records, it discloses that the plaintiff has filed this suit against the defendant for a relief of permanent injunction, restraining them from interfering over the suit schedule property, and declare the judgment and decree dated 21/1/2015 in OS number so and so, passed in so and so, is not binding on the plaintiff. Upon service of summons, the defendants appeared through their counsels and filed a written statement denying the case of the plaintiff. They contended that the suit is barred by the law of res judicata, and further filed a present application to dismiss the suit as hit by the provisions of the law of res judicata, contending that the suit property in this case is the property in OS number so and so, and the claim of the plaintiff therein with respect to the right, title, interest over the suit schedule property is similar to the claim of the plaintiff herein, and the plaintiff in the said suit and the plaintiff in the present suit claiming under the same genealogical head, and the plaintiff in OS number so and so. Mahesha is none other than the son of the plaintiff herein, and the judgment and decree is passed in the said suit is not binding on the entire family, claiming declaration under the same genealogical head. As such, the suit is hit by the provisions of res judicata. Further, contended that the judgment and decree dated so and so, passed in so and so, and the pendency of the proceedings in RFA is well within the knowledge of the plaintiff, wherein by virtue of that time it was pendency. Now that suit has been, RFA has been dismissed, confirmed the lower court order, passed by the assistant commissioner, initiated the plaintiff. Such being the case, the plaintiff herein cannot claim the said judgment is not binding on the plaintiff, and even though the said judgment is within the knowledge of the plaintiff and is in order, they further contended that the
present suit is only for injunction.
Yes, my lord, only for injunction. The court, while reasoning 10, my lord,
Yes.
reasoning admittedly, those were the previous, this one, the court's reasoning. Admittedly, previous suit in OS number so and so was filed by the son of the present plaintiff, namely Mahesha, against the present defendant in respect of the present suit schedule property for the relief of declaration and title, declaration of title and permanent injunction, claiming that he was the absolute owner of the suit schedule property as it is his ancestral property, and the said property belonged to one Venkappa. After the death, Naga and Mutta became the owners of the property. Therefore, it is a crystal clear, and the subject matter of the suit in OS number so and so are one and the same. This the court comes, are one and the same. Further, the relief sought in the suit is permanent injunction and declaration to effect that the judgment and decree in OS number so and so is not binding on the plaintiff herein. In OS number so and so was the relief of declaration and permanent injunction. Therefore, it was a comprehensive suit. Hence, definitely, competent court has already decided the dispute. But in the objection, the plaintiff contended that he was not a party in OS number. His son was the plaintiff in the said suit. But during his lifetime, his son cannot file a suit, and further contended that the fraudulent suit has been filed by the son. Hence, it is not binding on him. Of course, Section 11 CPC must not, parties must not to the same principles of res judicata would apply to any parties claim under the same, under same person. Admittedly, in the case on hand also, plaintiff claims his title and possession under his father, Naga and Mutta. I will emphasize these two lines here on. Even in OS number so and so, the plaintiff therein, who is the son of the plaintiff herein, was claiming title and possession under the Naga and Mutta. Taking into consideration of this aspect, definitely principles of res judicata would apply. But the main objection of the plaintiff.
To the earlier suit. Where is the judgment?
My lord, the judgment starts from page 57, my lord.
No, in this suit also, he's seeking declaration.
Yeah, it's an injunction suit.
No, the court says.
First suit was
No, second suit
declaration,
also the court records the same.
declaration and consequential injunction.
This
Your
one-
lordship will find it at ink page number 50.
I read it. Court says this is also the same.
Yes, my lord.
Same relief. Come to the earlier judgment.
Yes, my lord. If your lordship finds it ink page number 58, injunction is also, there was a typographical errors as partition, but the court while signing the judgment has corrected it as declaration and injunction.
What are the issues framed?
Issues frame. Your lordship finds it at page number 61 of my paper book, Your Honor. Whether the plaintiff proves their absolute right and title in possession of, whether the plaintiff proves interference, injunction is already decided, is my contention, my lord. What is the relief the plaintiffs are entitled for?
So coming to the first issue, what is the?
Starts from page number 62. Issue number 1 and 3 have been held as common issues and read out, Your Honor. May I read out, my lord?
Where is that?
Page number 62.
No, where is the finding?
Finding starts from the next page, Your Honor. The page, para number 10 itself, the finding starts, Your Honor. In page number 62 itself.
No, court has not given the entire, all the issues are dealt together, I think.
1, 2, 3 are dealt to. 1, 2, 3 are dealt together, my lord. To that, I would like to assist your lordship's question. Yes, my lord. I get that. I get that, and I just assist that on that. May I just read one line at page number 63, my lord, the third line. The claim. They are in possession and enjoyment of the suit schedule property. The said suit property is the ancestral property of one Venkatappa, who was the absolute owner of the property. After his death, his sons Naga and Mutta became the owners. They are paying Kandayam without any right title in the property.
Now the present plaintiff is Naga.
Naga's son.
No, not in this.
Earlier, Naga and Mutta.
In this suit, the son of the present plaintiff is the.
Yes, Mala.
Yes.
Mahesha by name.
Present plaintiff's name is?
Venkatappa. He is the son of Naga.
Yes.
May I trouble your lordships to take paragraph number 14, my lord, where the court observes 64, page number 64.
It's contention, I think.
My lord?
It's contention of the defendant.
The contentions. Now, why I just wanted to say is that court records what are all the documents produced by us. Then at page number 16, the court goes to say, no single document has been produced. If your lordship finds that no single document has been produced by the plaintiff to show their title over the suit schedule property. On the other hand, defendants have produced sale deed, exhibit D9, 10, 11, and 11. Exhibit D10 discloses on 4/8/1941, one Narsamma, son of and Kempaya, have sold 3 acre 13 guntas in survey number 134/2 in favor of Nagappa, and 11 discloses that on 1952, Nagappa sold 3 acres in favor of Kempanna, and exhibit D9 discloses that on 10/6/1959, said Kempanna sold it in favor of Bettaya. Bettaya is our father, Your Honor. We are the purchasers of the property in the year 1959. From the above documents, it is very clear that Naga alone had purchased 3 acre 13 guntas from Narsamma and Kempaya in the year 1941. Therefore, contention taken by the plaintiff that the suit property originally belongs to one Venkatappa is falsified. Exhibit D10 on the other hand discloses that one Nagappa son of Venkatappa alone had purchased 3 acres 13 guntas in survey number, and thereafter the said property has been purchased by one Kempanna from Naga. And exhibit D11 and thereafter 59 father of the defendants Bettaya purchased the said property from Kempanna as per exhibit D9. In the cross-examination, PW1 has stated that the above suit has been filed by him and his brother in the plaint. Above brother. In the plaint, it is mentioned that first plaintiff is one Venkatappa, that is the grandson of Naga. Second plaintiff is son of Mutta. No document has been produced by the plaintiff to show that the property belongs to Naga and Mutta. On the other hand, the defendants have produced the sale deeds to show that originally the said property was purchased by the grandfather of the first plaintiff, Nagappa, and it was sold to one Kempaiah, and the said Kempaiah in turn.
Please come to the present plaint.
The present plaint is at ink page number
33.
33, my lord.
4, sorry.
27, my lords. 27. Your lordship finds the genealogical tree, your lord. Venkatappa, Naga, Mutta. Venkatappa is the present plaintiff. Under him is Mahesha, my lord, who was the previous plaintiff, your lord. Now may I read paragraph number 5, my lord. The plaintiff submits that the said property is the ancestral property of the plaintiff, and one late Venkatappa was the late Venkatappa was the absolute owner of the land in survey number so and so. After demise of Venkatappa, his sons Naga and Mutta and their family were continuing in possession and enjoyment of the property.
No, read para 4.
Para 4. The
They say
plaintiff
something
submits
about-
that
they
father
say-
and
No, they say about the revenue entries, even till now it is in their name, is the case of the plaintiff.
my lord.
Not stated by them in the earlier suit. Here, that's why he says that son has not properly pursued that matter, prosecuted.
My
them.
lord, it was.
Look at it. In
My
fact,
lord,
that's why I'm asking
may I
you-
make this submission, my lord? Son was before the court in a declaration suit. Father was before the assistant commissioner on revenue proceeding.
No, if you look at it, he says that because the court gives a finding that nothing has been placed before the court by the plaintiff, how they have, whether they have been in possession of the property or how they are claiming it to be the owners of the property. They have not filed any documents. Now, if you look at this paragraph number 4,
Yes, my lord.
according to the entries in revenue records such as Pahani since 1975, 76 to till this day, both in column number 9 and 12 too, their names were reflected.
That would be a wrong submission. I have placed on record even the RTCs which are marked as exhibits in the previous suit here.
What are the other contentions? Let's just see which are relevant.
Yes, my lord. Paragraph number 6, how they say they are the class 1 heirs and succeeded. This has also been already answered, my lord. The plaintiff submits that they said Naga and Mutta died leaving behind the plaintiff as class 1 legal heirs to succeed to their estate, who being the son of Naga, that he has
No,
inherited.
According to you, whether the court has to give a finding on whether the said judgment decree is binding on him or not.
While consider an application under section 1011, my lord, res judicata, court, as I've just read out, court comes to the conclusion that it is similar in nature.
That is true. First of all, what he says is, one of the prayer is that the judgment and decree in the other suit is not binding on him. No, he has to demonstrate before the court how it is not binding on him. That is one of the relief.
Yes, ma'am.
The secondary, other reliefs are declaration and injunction. Unless and until he passes through that first prayer, the court will not consider the other two. As far as first is concerned, there is no question of res judicata. That has to be decided by the court.
The first prayer is restrain us from interfering with the peaceful possession.
All or none of it are consequential. This is not a consequential prayer. Let us see the prayers.
First prayer itself is injunction, my lord.
Then these are all independent prayers.
I do agree. First prayer, when there is already an.
As A, B, C, D, A is not a consequential to B, or B is a consequential prayer to A.
No,
These
I
are all
will.
independent prayers.
I will stand as a single prayer of annexure. Prayer A. I'm sorry. Prayer A, my lord. Doing writ. I'm sorry, my lord. Prayer A, if as your lordship points out, it's independent. this independently.
So now it is like this. Part of the suit prayer is barred by res judicata, part is not. So the court has to dismiss the suit partly as barred by res judicata.
May I submit this way, my lord? The sale deed of the year 1959, your purchasers of the property.
Correct. Those are all your prayers or your the findings that is pertaining to prayer 1.
Yes, my lord.
Prayer 2 is he seeking a relief that was never decided by any court. So, assuming for argument's sake that it is barred by res judicata, then how it should go?
If your lordship is pleased to take paragraph number 13, the cause of action, my lord. The cause of action to file the above suit arose on 28th April 2017.
These issues, that's why the court said it's a question of trial. Please come. Agreed with the order.
My endurance before the court was ultimately wastage of time on this particular.
That is true, but unfortunately.
As your lordship finds out that it should not be thrown out.
We are bound by certain procedure and certain, because each and every case, if you just start throwing the cases at the, even before the court hears it and looks at it, it's because there are two prayers. One prayer according to you is barred by res judicata, the other not. The other has to be, the court has to give a finding. No, while dealing with that, court will say that already this issue is already decided, the same thing will apply. But it has to go through the procedure now.
Because the second portion of the CPC with respect to section 11, I was more strong on that particular, which I said I would like to emphasize upon.
What is that?
A person claiming or agitating a suit under the same right or title whom both the parties claim.
That is true. That is also prayer 1.
No, my lord, it comes to prayer 2.
What prayer 2?
Not binding. Because he is also agitating that his father Naga had a right. Earlier.
Oh, but that issue, whether it is binding on him or not, court has to decide. Yes. You cannot say that is res judicata. Issue number 2.
Yes.
That is not res judicata. It has to be. Yes. No, so far, no court has decided that. But the first time he has come up before the court saying that judgment, as far as second issue, whether the son is entitled for declaration, injunction against you or not, is decided. According to him, son has no right to file such a suit, and that judgment is not binding on him.
So that issue
exactly
has to be decided
by the court.
Para 24, page 24.
What I was under my impression and my understanding of reading of this, maybe I am totally wrong. My understanding was that in a former suit between the same parties or between the parties under whom they or any of them claiming litigating under the same title. There I stood myself, my lord.
Yes, please come. Agreed with the orders passed to 9 number 2, invoice number 1261 of 2019, dated 19th February 2024 by the Principal Civil Judge, Bangalore Rural District, Bangalore. The petitioner defendant is before this court. The respondent herein has filed a suit seeking a decree of perpetual injunction restraining the defendants or any other person or persons, restraining them from interfering or disturbing peaceful portion of the suit scheduled property of the plaintiff, and also sought for a declaration that the judgment and decree dated 21/1/2015 invoice number 1370 of 2007 passed by court of the FTC2 Bangalore is not binding on the plaintiff. The facts of the case are: the respondent herein is the plaintiff. Earlier, the respondent's son has filed OS number 1370 of 2007 against the very same defendants in the suit, seeking declaration and injunction. That suit came to be dismissed by judgment and decree dated
21st January 2015.
21st January 2015. Against that, the plaintiff has filed RFA number
478 of 2015,
which came to be dismissed by order dated 27th August 2019. It is a case of the father, that is the petitioner before the plaintiff in the present suit, that the judgment and decree which is passed in the earlier suit is not binding on him, and the son of the plaintiff has no right to file the earlier suit. When it comes to the relief, he has sought the same relief of injunction and a declaration. The defendants have filed the defendant or defendants.
Defendants.
The defendants have filed an application under section 11 saying that the suit is barred by res judicata. That is IA number 2. That came to be dismissed by order impure. While dismissing the application, the court has observed that
Page 24 last.
the court observes that principles of res judicata applies to any parties claiming under the same person. Admittedly, in the case on hand, plaintiff claims his title and portion under his father Muthu and Naga. Even in OS number 1370 of 2007, the plaintiff therein, who is the son of plaintiff herein, was claiming title and portion under Mutta and Naga. Taken into consideration of this aspect, definitely the principles of res judicata would apply. But the main objection of the plaintiff herein that when he is alive, his son cannot file a suit as he has not inherited the property during his lifetime. In this aspect, it requires a full-fledged trial. The said aspects cannot be decided without full-fledged trial. It is also observed that res judicata is a mixed question of law and fact, and which cannot be applied in each and every case and depends upon facts and circumstances of each case. It is a case of the plaintiff that during his lifetime, his son cannot file a suit claiming his possession and title of the suit scheduled property. However, he filed the present suit. However, the sons have filed the suit fraudulently. The court has come to the conclusion that the issue of res judicata cannot be applied in the case on hand without a full-fledged trial. The court further observes that the subject matter involved in the previous suit and the present suit is one and the same. Even the parties are claiming this under the same parties, but only question needs to be tried is whether his son had right during his lifetime to file a suit without his father. Another point is whether the said suit is filed fraudulently. And the principle of res judicata cannot be applied to the facts and circumstances of this case. Agreed thereby, the defendant is before this court. When counsel appearing for the petitioner, defendant submits that the court has failed to consider the contentions put forth by the defendant, both on facts as well as law. It is submitted that when both the earlier plaintiff and the present plaintiff are claiming the right to property by way from a common from a ancestor, that is the earlier suit grandfather, and in the present suit from the father. And when the court has given a finding that they are not in possession of the property and they are not entitled for the relief as prayed for, and when it has attained finality, it is not when the said judgment and decree has attained finality. Now, in the light of section 16 of the section 11 of the CPC, the present suit is barred by res judicata. This aspect, though the court has appreciated the fact, also has accepted the contention on some of the on the fact that the subject matter is one and the same, and as per section 11 res judicata applies, still the court has rejected the application. Anything else?
That's it.
Then counsel appearing for the respondent submits that the court has rightly held that this is a mixed question of fact and law, where the evidence has to be let in, and at this stage the same cannot be decided. Particularly the issue the prayer that is sought that the defendants have no right to, earlier plaintiffs who are the sons of the present plaintiff have fraudulently filed the suit and they have no right to file the suit and rightly dismiss the application. There are no grounds to interfere. Having heard the learned counsel, the petitioner produce the material on record. Before
One sentence put it bad. We are the purchasers of the property right in the year 1959.
It is in the contentions of the petition. It is submitted that the defendants have purchased the property way back in the year 1959, and from their vendor has no nexus with the plaintiffs.
The vendor, my vendor, that's my father's vendor, had purchased the property from the father of Venkatappa.
The property is
So
purchased in the year
Venkatappa's father Naga himself had sold the property in favor of Kempaya, and Kempaya in turn had sold the property in favor of Bettaya. That is the father of the defendants.
It is submitted that the property is sold by the grandfather, great grandfather of the
Great grandfather of the previous plaintiff.
great grandfather of the plaintiff in the earlier suit and the grandfather of the present plaintiff.
Sorry, father
Father of the present plaintiff.
Father of the present plaintiff, grandfather of the previous.
Grandfather of the plaintiff in the earlier suit has sold the property in favor of the defendant's father.
Defendant's vendor.
A defendant's vendor.
Father's vendor.
Defendant father's vendor in the year
52 first.
52.
Naga sells it in the year 1952. Then from 52 he purchased in 59.
That produce the material on record. Before proceeding with the proceeding with the merits of the matter, it is appropriate to look at order section 11 of the CPC. Extract it is the contention that there is no dispute as rightly recorded by the court that the suit schedule property is one and the same, and both the plaintiffs in this case and in the other case, they're deriving the right and title to the property from the common vendor. Here, apart from seeking a declaration and injunction, if that is the case, it would fall in a straight bracket whether the issue of res judicata, whether it is hit by principles of res judicata or not. But in this case, the petitioner, the plaintiff is seeking another relief, that is that the judgment and decree is not binding on him. The said suit has been filed fraudulently, and during the lifetime of the plaintiff in the present suit, the plaintiffs in the earlier suit have no right and title, have no right to file the suit, and he has raised his independent contentions. Now the issue whether even if the contentions of the petitioner are held to be correct, only now the part of the suit as far as the declaration, whether the court can only appreciate as far as the relief with regard to declaration injunction, but there is another prayer with regard to the other prayer has to be decided by the court after a full-fledged trial. In those circumstances, the court, having appreciated the contentions, has held that now it is a matter of it's a fact and law. As such, the evidence has to be adduced at this stage on an application under section 11 filed by the defendant. The suit cannot be dismissed. And in the considered opinion of the court has rightly answered the issue, and there are no grounds to interfere.
Maybe if we had failed in the earlier suit, father wouldn't have come. This is property litigation.
Sometimes, though we understand what it is,
but we are bound by the law.
Law doesn't permit to take such a.
As your lordship said in the previous matter, seeing or speaking is easy, but when it comes to reality for analysis and writing, it would be a difficult choice.
Yes.
Much.
Petitioner and matter moved on to.
My lord, I appeal for respondent in this case.
Yes.
Madam, for petitioner, Madam, police protection order granted on 19/6/2026.
What is the suit for?
Suit for declaration and permanent injunction filed by respondent number 1 and 2 against me. But
The decree.
decree, no, my lord, the 39 rule 1 and 2, the order for the injunction order, 39 rule 1 and 2, IA number 1.
When was the injunction granted?
Injunction was granted, my lord, on 2021.
20?
21 minute. 6/1/2021 order.
Then what happened after that?
My lord, after MFA filed, my lord, the after lapse of 1.5 years, on the point of the delay, MFA was dismissed. But the pendency of the suit.
Now, the injunction, interim injunction that is granted against you,
Yes.
as far as that is concerned, it has become
Absolute. Well, what happened pendency of the suit? The plaintiff has filed the application IA number 11, stating that the defendant number 1 and 2 are in possession of the property and directing to pay the rent and deposit the rent in the court. That is IA number 11.
What is the injunction? What injunction is sought?
Injunction is not to interfere in the peaceful possession of the vacant site property.
Then after granting injunction, he says you are in possession of the property.
Yes, IA number 11 has filed in the same court.
Now please come to the injunction order.
In IA number 11, kindly see. What?
We will see, before that we'll see the injunction order.
Injunction, my lord, they not to interfere in the peaceful possession of the property.
No, let's see how it is considered by the court.
My lord, the police protection order 2025 filed application.
Filed.
My lord,
That is not filed.
2000, the injunction order was not filed. IA number 2/2025 filed for the police protection to the enjoy the property. But 2023 filed application, IA number 11, he admitting that the defendant number 1 and 2 are in possession of the property. That is IA number 11. Lord, page number 223, minute. IA number 11. In the affidavit 225, the plaintiff number 1 and 2 filed the affidavit. In para number 7, minute. Para number 7, I state that though the dependents are in using the suit scheduled property, suit scheduled properties, my lord, the 50/90 the vacant site as per their plan. Lord, we are in possession of the property. There was a construction house and their sheds and shops are there. I kindly their para number 7, my lord, they are admitting though the dependent number 1 the dependents are in using the suit scheduled property unauthorizedly without paying any rent whatsoever. Very conveniently, they are causing the untold misery. They are admitting the position 2023, this application was filed.
Then what happened to this IA number 11?
Well, IA number 11 is pending before the court, not considered. Well, one more application is filed. Well, we have filed the suit against the plaintiffs for permanent injunction. Injunction was granted by this honorable court, wherein the very same the plaintiffs filed the IA for appoint the court commissioner to identify the property. The my property is different, their property is different. Kindly see the
What is that?
238.
What is that suit?
That is suit Malad OS number 7040/25. In my suit.
Which suit is first?
Suit for permanent injunction against the plaintiffs.
Their suit is first or your suit is first?
My suit is second, their suit is first.
In their case, with respect to the same property, court grants injunction, and your case also court grants injunction.
Malad, my property is 90/100.
Where is the plaintiff in your suit?
In my suit, Malad, the injunction order granted by this honorable court.
Why this court has granted injunction?
That is a plaint in 259, Malad. My suit, 259. Suit property in page number 226, my lord. All the piece and parcel of property bearing survey number, word number 12/1, new number 115 situated at so and so, measuring east west 100 feet, north to south 90 feet. In that suit, my lord, injunction granted in favor of petitioner for not to interfere against the dependent. My lord, in that suit,
Where is his suit? Is plain
my lord, the plaintiff is, my lord,
in their suit.
my suit is 259, my lord.
266 is whose suit?
My lord, 259 page number. Suit on OS number 7040/25.
That is 7040 is filed by,
Filed by me, my lord, petitioner.
that I have seen.
Yes.
I said, where is the plaint in their suit?
Their plaint, my lord. In page number 32, my lord, annexure B. OS number 40/2020.
What is the suit schedule property?
That is suit property is measuring site number 2, new municipality site number 2, ward number 2, situated at so and so, measurement is north, east to west 18.29 meters, north to south 27.43 meters.
So there is no connection between your suit and his suit.
Blood, this property, my contention is, my lord, 19 to 100 is my property. They're claiming half portion of their claiming the property. And kindly see the photos there, the contention. In my suit, filed the application for appointment of the commissioner. Their contention that, my lord, the plain suit property of the respondent is.
Property is situated at 18th Main Road.
Oh.
Your property is 18th Main Road, 15th Cross, JP Nagar.
Yes, my lord.
And his property is 12th Main, 15th Cross.
Yes. On their own application before the court, my lord, this.
First you clarify this.
Yes, my lord.
Both the properties or adjoining properties. What is your case?
My lord, we are in possession of the property. 1967, the father of the plaintiff acquired the property. My lord, on 1999, my lord, the 9 guntas of the property.
Asking one question, simple question.
Please.
According to you, how these two properties are situated? According to you, your property is different, his property is different.
My lord, no, my lord, my property, my lord, they are trying to interfere in my property, my lord. The suit property, my lord, the 100 into 90, it is belongs to me. They are, my lord, they created the document.
The injunction, when the interim injunction is granted, MFA is dismissed. Whatever is your further remedy, you have to take. If it is not, what a court has to presume?
My lord, pendency of the suit, he admit, my lord, the dependent number one is possession of the property. IA number 11 he has filed. How there he has to file the recovery of possession against me. How there, my lord, he has directed to pay the rents to the court. That's version he has changed in the application.
So what happened? What is the present
That
order?
application is pending consideration before.
Present order, what is the present?
Present order is, my lord, directed to, that is operative portion. The jurisdictional police station are directed to provide necessary protection to the plaintiff. Very same plaintiff filed IA number 11.
Where is the order?
Order is page number 25, my lord, 24 reasons. Reasons. That is in the last, the para number 7. In last 2 lines, my lord, the dependent number 1 has contended to protect the proceedings. Plaintiff has filed this up.
Oh. There is a counsel for the respondent.
My lord, I am appearing for the caveator, my lord.
Yes.
My lord, copy has been served now itself, my lord.
IA number 11 has filed by them, my lord. They are not in possession of the property. That is how their
Submitting about the papers.
papers I served, my lord.
He has filed caveat.
My lord, now
Caveat paper served.
How it is served?
My lord, on 3 p.m. I served their office.
my lord, they served 3:45 p.m., my lord.
You should have served it in morning. How will he, how he will go through the papers and
Yes,
submit
please,
before
my
the
lord.
court?
It is an
My lord,
urgency.
kindly have it on 24th, my lord.
Police will trouble the future.
This is a matter tomorrow in the first list.
My lord, kindly have done 24th, my lord. My senior is not available for tomorrow, my lord.
Then
Day
I
after
will grant
tomorrow.
stay. I'll grant stay and have it whenever you want.
My lord.
If you want to argue, I'll have it tomorrow. Or if you want it at a long date, I will grant stay and then whatever you want to do, you do.
No, my lord, only one day, my lord. My senior is going to Chikbalapur for arguments, my lord. Kindly one day, my lord. 24th, my
Till
lord.
such time, don't do anything. This is matter on 24th, till such time not to precipitate the execution.
Yes, please. Please.
Learn counsel for the respondent caveator seeks time. It is submitted that the senior is unavailable. This is matter on 24th. As the matter is adjourned at the request of the learned counsel for the respondent shall not precipitate the execution till that day listed in the first list. Yes.
Yes, we make some submission.
Oh, it's already 4:40.
May I make one submission, Miller?
Yes.
The previous matter which was disposed of, as the matter is of the year 40, serial number 45, Miller.
Which year is that?
2019,
Which court is Bangalore court?
Court, Bangalore Court.
There are so many matters in that court.
My lord,
Can't grant any expeditious.
my lord, only endure is, even though I have succeeded in the previous
That
round.
is true, but the problem is we can't, as per the Supreme Court judgment, we can't give that kind of.
No, it's already in the
directions.
stage of evidence, my lord.
Oh, there are so many matters pending on that court. In fact, I have sought for what is the pendency? Much older matters are pending.
It's a rural court, my lord. Rural court at Bangalore.
According to you, what is the pendency of that court?
Because I will not be having.
Yes.
It's only a small endeavor.
No. But when whoever comes to the High Court, if we start giving it, then the trial judges are in a complete.
Because it's almost like
What to do?
it's almost like a continuation proceedings of the year 2007.
Yes. In that matter, simple say there shall be an expeditious disposal. Yes. All matters in this list shall come in the first list tomorrow. And other matters as per their list. Give the.
My lords, one submission, my lords.
In all the, please wait, all the matters interim order will be extended. And whenever the list matters will come in the first list. Remaining matters, you can tell the court officer as per your convenience and the convenience of the court, she will fix the date and interim order will be extended.
My lords, one
That's
submission.
only one
my lords.
submission, my lords.
No submissions.
My lords,
Second
serial
list.
number 58, my lords, tomorrow the trial court has posted it for arguments.
That you can, if you tell the court officer that she will do that.
Lords, second list, one matter, my lords.
Sir, list number 1, all the matters which are remaining will be coming in the first list tomorrow. List number 2 ನಲ್ಲಿ dates ಹೇಳಿ. ಇಲ್ಲ ಡೇಟ್ಸ್ ನಾವು ಅಸೈನ್ ಮಾಡ್ತೀವಿ ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ನಾಳೆನೆ ಬೇಕು ಅಂದ್ರೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಯಾವುದು ಒಂದರಲ್ಲಿ ಎಲ್ಲ ನಾಳೆಗೆ ಇನ್ ಲಿಸ್ಟ್ 1 ಅದೇ ಸರ್ ಲಿಸ್ಟ್ 1 ನಲ್ಲಿ ಲಿಸ್ಟ್ ಅದು ಬಿಟ್ಟು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮಾತ್ರ ಡೇಟ್ಸ್ tomorrow ನಾಳೆ ಬಂದಾಗ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸರ್ ಡೇಟ್ಸ್ ನಾಳೆ ಬೇಕಾಗಿರೋದು ಮಾತ್ರ ಹೇಳ್ಬಿಡಿ
ನಾಳೆ ಜರ್ಮನ್ ಇದೆ 48-52 ಬೇಕಾದ್ರೆ ನಾಡದಕ್ಕೆ ಹಾಕಿ ಇಲ್ಲ ಅಂದ್ರೆ ಸೋಮವಾರ ಕೊಡಿ ತೊಂದರೆ
ಯಾವುದು
48 and 52
ಯಾವುದು ಲಿಸ್ಟ್ ನಂಬರ್
1
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ನಾಳೆಗೆ ಸರ್
ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಕೇಳ್ತಾ
ನಾಳೆಗೆ ಲಿಸ್ಟ್ ನಂಬರ್
ಹಾಕೊಳ್ಳಿ ನಾಳೆ
ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ ಹೇಳಿದ್ದಾರೆ ಇವ್ರೆ ನಾಳೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮಾತ್ರ ಕರೆಕ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮಾತ್ರ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಆಲ್ ದ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ದೇರ್ ಇನ್ ದ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಟುಮಾರೋ ಅಂತ ಹೇಳೋಗಿರೋದು ಹೌದು ನೀವು ನಾಳೆ ಬೆಳಗ್ಗೆ ಫಸ್ಟ್ ಅವರ್ ಅಲ್ಲಿ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡಿ
ಇಲ್ಲ ಕರ್ಕೊಂಡ್
ಮೇಡಮ್ ಆನ್ಲೈನ್ ಏನು ಕೇಳಿಸ್ತಿಲ್ಲ.